Let us pray. Lord, our governor, bless the leaders. Prime Minister, all the members of the congregation, nation, praise to you. Finally, teach our people to rely on you. Thy kingdom come, thy will be done on earth as it is in heaven. Please forgive those that trespass. Lead us not.
This House is in session. Minutes of the meeting held on Tuesday, 28th of March, 2023, Friday, 31st of March, 2023, Tuesday, the 2nd of May, 2023, and Tuesday, the 9th of May, 2023, to be confirmed. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be confirmed.
Question that the aforementioned minutes be confirmed. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned minutes are hereby confirmed.
Messages from her.
Minutes of the meeting held on Tuesday, 16th May 2023 to be deferred. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
Questions that the aforementioned minutes be deferred. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned minutes are hereby deferred.
Messages from Her Excellency the President. Petitions, papers.
Honourable Leader, Government Business.
I'm commanded to lay the annual report and audited financial statements of the Fair Trading Commission for the period April 1st, 2020 to March 31st, 2021.
Government notices, private members' notices, notices of questions, reports from select committees, first reading of bills, statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honourable Leader, Government Business.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
Questions that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business, sir.
Government Business is the order of the day.
Order number 7, in the name of the Honourable Minister of People Empowerment and Elder Affairs, to resume the debate on the second reading of the Child Protection Bill 2023.
Honourable Member for St. Michael South.
Thank you very much, Mr. Speaker, sir. I want to again thank the House for allowing me this opportunity, sir, to speak on this bill and to conclude and to send this bill off to Select Committee. But it's quite fortuitous, sir, that we have the opportunity to come back and to address some of the things that I've heard during the course of the last week and to reinforce the main points of this piece of legislation that is before this House, sir. Let me begin again by reminding the House and the public, sir, that the legislation that currently serves as the primary legislation in relation to child protection is extremely old and outdated. So last week I went through great pains to explain, sir, that this legislation was, for the most part, sir, written 100 years ago. Some of it in 1918, some in 1904. Sir, I took that opportunity, sir, to suggest very strongly and clearly that our society then, compared to our society now, sir, is a completely different society. And that indeed what that legislation was meant to address in 1904 and 1918, and some of it, sir, the more recent ones in 1983, 85, do not reflect the current circumstances of the day. Sir, I took that opportunity. So the first thing was in relation to the age of the legislation. Sir, I also took that opportunity to explain that this Convention of the Rights of the Child, that Barbados ratified the convention because now there is talk that this administration is somehow now making some unholy alliance with powers that be to subject ourselves to the will of an international community like mindless, unthinking people and be subject to the dictates of this in the international community while we are passive recipients of that dictate. And I made the point, sir, very clearly that the Convention on the Rights of the Child was not signed by anybody in this House. Period. Whether they're here in person or not, sir, that the Convention on the Rights of the Child was ratified by the government of Barbados, not by this Barbados Labour Party administration or any Labour Party administration. But indeed, the Convention on the Rights of the Child was ratified in 1990, when the Democratic Labour Party was in office. It is interesting to me that the very same Democratic Labour Party is now criticizing the very same Convention on the Rights of the Child that they ratified, not this Barbados Labour Party administration. It is a kind of a contradiction and a hypocrisy, sir, but unfortunately it is also a short-sightedness, because there is really nothing inherent in the convention that is dangerous. But men now have set themselves their sights, sir, solely on achieving political office by criticizing anything that falls in their way, even themselves, sir, to gain political office. And that they who criticize should ask themselves who ratified the convention in 1990, and to state their objection to their own party's ratification. And to criticize, in many cases, sir, the founding fathers of their own party, because it was their party, sir, who ratified the convention. None of us in here did, sir. And I call it a short-sightedness only because, sir, so set are they on achieving office that the benefits embedded in the Convention of the Rights of the Child, they're now ignoring. They're now ignoring, sir. So now to suggest that we somehow are only responding to some international community is an error, an unfortunate error, probably a deliberate error, because I know that this bunch of Democratic Labour Party candidates and hopeful MPs in some distant future, sir, I know that they have no regard for the former Democratic Labour Party. And so I suspect that when they criticize the ratification of the convention, that they're deliberately criticizing the stalwarts of the Democratic Labour Party. It is an attack by this bunch of DLP supporters and candidates on the former Democratic Labour Party. That's all it could be, because the Labour Party wasn't involved in it at all. it is obviously a case, sir, of infighting. And so I would wish for them, for they who criticize the ratification of the convention, to come out and to say what about it they criticize. And if they are so opposed to it, to come out and say who they are opposed to, because none of us in this place ratified it. But again, sir, I want to make the point, sir, that it is short-sightedness, because there are things in the convention, sir, that speak to the protection of children, sir. This convention has been ratified by several countries, signed by several countries, further ratified by several countries. So it is not a thing that Barbados has done on its own. And I looked at the file, sir, as I was preparing for my presentation last week. I went through the file, sir. I saw different persons responsible for children, different ministers responsible for children, making comments on the file. I've seen no objection to it at any point in the file, sir. And what this Barbados Civil Party administration has done is different. There is an OECS model bill, and I feel I have to take the time to explain this morning, sir. I won't be long. But there is an OECS model bill that has now shaped this emergence of proper child protection legislation in the region. We took that OECS model bill. We dismantled it, sir. We have a belief in this party, sir, that when it comes to these things, sir, you have to go through them word by word, line by line. We dismantled it, sir, deconstructed, reconstructed, our jargon, and made sure that that legislation, sir, was fit for Barbadian purpose. We went through it line by line and made sure it was fit for Barbadian purpose. We then held several consultations with other persons in Barbados, sir, including the very same people who know that they have on political blinkers, now have now taken a dislike for the same legislation that they were endorsing previously. Same people who had the opportunity to comment on the legislation and endorse the legislation, now that they're wearing their political blinkers, sir, have lost all sight and all direction. And I will speak to that perhaps in a little bit more detail further. So I want to be clear, so that we consulted far and wide, so that what you see before you is a piece of legislation, sir, that reflects the Barbadian reality. So one, the legislation that guides the current principles in Barbados, sir, that guides the relationship in relation to children is old. And two, sir, it was signed in 1990, not by this administration or any Barbados Civil Party administration. And three, we consulted heavily, including some of the same people who are now criticizing the legislation. 3 points. I go further, sir, because these things must be said. There are people now who are suggesting that this legislation takes away the rights of parents. That this legislation, because we are articulating that you have to give a voice to young people, children should have a say in their own issues, that this legislation somehow takes away the rights of parents. Nothing could be further from the truth. So I took the time, sir, and I went through the existing legislation, the different pieces of legislation, sir, because point 4 is that the current legislation is a patchwork. You want to do something with children, you have to go to the prevention of cruelty to children, the protection of children. I mean, there are all kinds of pieces, sir, of legislation all over the place that you have to be able to address. We pull it all together. But when you go through these 4 or 5 different pieces of legislation, you can find very few references even to the word parent. In the existing legislation, not the one that I am bringing, or the Honourable Minister responsible for Home Affairs, when you look at what exists now, there are very few protections set into that legislation for parents. And I say, sir, in this floor of Parliament, without fear of contradiction, that our legislation now has more protection for parents than any other piece of legislation that referred to children in this country, for sure. For sure. But there is now a narrative, obviously, meant to achieve, again, political ends, suggesting that we have somehow taken away the rights of parents. Sir, I have worked at the Child Care Board. I do not stand here because of some political affiliation. We both worked at the Child Care Board. So we know, sir, that at the end of the day, what exists and what does not exist. I don't need anybody who came through legislation to come and tell me about how it works. Somebody who has never had a single relationship with children in this country to come and tell me how this thing works, sir. I know for a fact that parents now have way more protection. The need to consult in this legislation begins at the very beginning, sir, and goes all the way through to the end, from the cradle to the grave consultation with the parents, sir. To the extent, sir, that we are even now allowing the officers to go to the households and work with parents. This legislation and the one that follows, sir, you would see at all points the whole intention is to keep the family together. That is the point. To keep the family together. The family is the priority of the legislation, sir. So we're working to protect children within the context of protecting and maintaining families. You pull any of the existing bills, sir, you will not see it. So for those who have a lot to say, that we are taking away the rights, I encourage them, in fact, I challenge them to pull the legislation that currently exists. Show me the rights of parents in that legislation. To pull this legislation and to show me where we have taken away any single right of parents in this legislation. And I go further, sir, when they fail at it, because they will fail at it because it is a lie and conjecture. When they fail at it, I will then show them all of the things we put in to protect parents in this legislation. Or not, the former Prime Minister, sir, the MP for St. Peter, used to say to all of us that you cannot take the low road to high office. And time after time, it is clear to me that the Democratic Labour Party candidates, sir, are keen on taking the low road every single time. Last election, sir, I was happy to see new candidates come forward. Because I am still relatively young, I was happy to see new candidates come forward. This time around, I am happy to see new faces come forward. Happy to see that young people want to get involved in the political process. But there is a toxicity somehow now that permeates George Street, that whoever comes forward seems to take on this personality, that their politics must be the politics of lies and conjecture. And I will go further, sir, because it is clear to me that even at the risk of the reputation of this country, even at the risk of hurting the very children that this legislation seeks to protect, that those who come forward will go to all lengths, sir, to try to get political office, sir, even if it means that it destroys the same children that they're trying to protect, sir. There's a person who is now on today's front page as a professional. She's a professional by day and a politician by night. I don't know if she speaks, sir, in a professional capacity or if she's speaking in her political capacity, but I know this, that when I look at what is being said, sir, by this person, and in yesterday's paper, sir, I read one. I thought for a second I was misreading. Sir, it is suggested, sir, in yesterday's news, Daily Nation, sir. And you have to read these things, sir, because, you know, there is a great danger in letting some of these things pass. The rights of the child should not be given to the state. This is the title of the article, sir. And in this article, sir, it is quoted, sir, permit me to say, sir, because this is what the article says. Parents are the voices of the children, not the state, says human rights activist, sir, and it goes on to name the person. This article then goes on to say, sir, all kinds of things, sir, and I won't even address all of them, but this last paragraph really had me concerned. This paragraph, sir, says...
I remember, you know,
I know the rules.
Yes, and that if it is not a document of the House, and I can understand the enthusiasm and the pain that it is causing you, Honourable Member, but don't quote.
Sir, I would not quote, sir. There was a suggestion made. And that suggestion, sir, was that in this legislation somehow, that we have not only taken away the rights of parents, but that somehow all of the state's authority now will override any authority of the parents. It goes on to say, the suggestion, sir, becomes further ludicrous by saying that we will now allow children to have medical procedures. That we will now allow children to have medical procedures that could come back to hurt the children. I do not know where this came from. There is no reference to it at all in any of the legislation. There is no reference, sir, this is somebody, sir, speaking on a political platform by night, being a professional the next day, giving the impression that they have no political persuasion, but we know that this is politics. Taking on a political personality under the pretext of professionalism, bringing into question now a whole profession, suggesting that this legislation would somehow allow children to have a medical procedure that they will later regret in life. There is no reference anywhere at all in this legislation to anything such, sir. So I would like to know where that came from and what was the injury that this person was trying to cause, sir. And that it is causing fear and panic deliberately, sir, to drive people away from an administration that is doing what is in the best interest of children. It is a very, very dangerous thing, sir. And I say it all the time. I said, sir, that I was very happy to see new persons emerge. And I support them. But I just do not understand why in the attempt to gain political office, people will lower themselves to these levels. And I would like to think sometimes, sir, you know, even as I try to think that a political party could come somehow and publicly sanctify itself, and that my expectations, sir, might have been too harsh. But every action they do live down to my expectations. Every action living down to my expectations, sir. I listened, sir, to the bits and pieces that I heard. There is nothing in this legislation that speaks about any medical procedure, any child being allowed to go to a doctor and having a medical procedure that would somehow, the child will somehow regret. A kind of conjecture and innuendo meant only to cause pain, sir. Meant to embarrass the country. Meant to scare children, sir. I do not understand how all of us, whether we are in this place or another place, can agree that children should have a say in their own business. That children should be allowed to actively participate in the decision-making processes that govern their lives, all of us, anybody of mature thinking. But yet when you offer them the opportunity in legislation to participate in the decision-making processes that would govern their lives, particularly for the most vulnerable children. Particularly for the most vulnerable children. We are somehow suggesting, sir, that we are violating the rights of parents, sir. That, sir, is innuendo, lie, and conjecture, sir. It is my understanding, sir, on this whole idea, sir, because, Mr. Speaker, sir, I believe that the truth has got to be spoken. I do not know, sir, of any Labour Party person, sir, whether it is in this administration or this legislation or otherwise, sir, would come and suggest, sir, as was the case, sir, by a former member of Parliament on the other side, a sitting minister at some point, would come and suggest, sir, that 16-year-old children should get the HPV vaccination with no reference to their parents, sir. A former member of the outgoing last administration, sir. That was not this Barbados Labour Party. There is no reference in anything that we do, sir, to making parents lose that authority. sir. So when the conjecture and the lies are spoken about the Barbados Labour Party, sir, you know I have a saying that stop telling lies on me or I will tell the truth on you. And the truth is, sir, that it was a member of the Democratic Labour Party that suggested an HPV vaccination should be given to children without reference to their parents. It wasn't me, sir. I do believe, sir, that there's a need for consultation on a lot of these things. I do believe, sir, that parents have a right to be heard. And until we address the legislation, sir, because, sir, in all fairness, there is a problem currently in the legislation. I explained it last week, sir. I'm sure you are familiar with it. That at 16 years old in Barbados, that is the age of consent. That means that a child at 16 years old can consent to sexual relations in Barbados. However, until you are 18 years old, you cannot go to a doctor without your parent. So obviously, sir, you can engage in activity without your parent, but to go to the doctor for 2 years, you need to have a parent, sir. There's a conversation that needs to be had. And it is immature. It is immature and it is dangerous to try to lay blame to some evil at the foot of the Barbados Labour Party, sir, when this Barbados Labour Party is the administration that is trying to do right by children, sir. I will close, sir, because I will have another time to speak. And I know the Honourable Member for Christchurch South, Christchurch East, sorry, the Honourable Minister of Home Affairs, will have an opportunity, sir, to address a number of these issues. So I would close by saying, sir, that this legislation serves to protect children. This legislation, sir, serves to protect parents. I throw out my challenge one more time. Show me in the legislation, in the former legislation, the pieces of legislation where we have taken away the authority of parents. And show me in this legislation, sir, any gaps, sir, and those are ones that we must now seek to fill. Sir, the last point that I wish to make is that we are sending this bill to Select Committee. And in Select Committee, sir, we would allow for persons to come in and to make representation. The reason that we are sending the bill to Select Committee is to allow for other views to contend. And to have a piece of legislation that has been subject to so much rigor that when in its final iteration, sir, it reflects, therefore, the will of the country. So there are some suggestions, sir, that I have heard, sir, that I've been discussing with the Honourable Attorney General, sir, that perhaps we need to look at some things, make the legislation where we felt that it was clearly, sir, to some people we need to make it clear, and in Select Committee, we will make it as clear as possible. There is no, in law, sir, I'm not a lawyer, but I know that you can raise a bill. Most of these bills, sir, like the Domestic Violence Act, sir, mostly are dealing in the civil realm, but that the criminal charges come under another bill. Well, this is not new, sir. So I do not understand why all of a sudden, sir, is like, oh, these things are not here. If we need to make amendments, sir, we will make the necessary amendments. That is why we are sending the bill to Select Committee. And I encourage persons, sir, who have an objection, sir, persons who have an opinion, and persons who feel they have something to offer, to come forward and to make a contribution. And from the floor, we give the assurance that those things would be heard, sir. And where they, sir, align with what we are trying to do, sir, where they add value to what we have doing, where they, sir, put in the things that we may have left out, because no administration, sir, no drafting is perfect. I've been in a room the other day, sir, with 4 lawyers. 4 lawyers. And all 4 had a different opinion on the same piece of legislation. This is a fact. All 4 had a different opinion on the same piece of legislation. That is the norm, but it is the beauty of the legal process. It is the beauty of the legal process, that it allows people to have an opinion, sir, and to make a defense of it. But to run on the court. And the other thing is this, sir, as I close, sir, before I send this bill to Select Committee, sir. While I think the opposition is being intellectually dishonest in all regards, because I've just explained to you where this thing started. It didn't start with us. I've explained, sir, that the parents, sir, are protecting this legislation. While I think they're being intellectually dishonest, sir, I feel that there are those, sir, who have the public's ear, who also have a responsibility, sir, to engage in a little bit of rigor and not just to repeat what it is that is being said by politicians for political purposes under the pretext that they're professionals. Any person in the media, sir, or any other person, sir, could pick up the legislation, go through it, and see that a lot of the claims that are being made, sir, are untrue. And I encourage them so to do. I've also, sir, said to my staff yesterday in a staff meeting, because if I speak, they will think it's political. Y'all are free, according to the permanent secretary, not from me. The permanent secretary said the heads are free to go and speak about the legislation. Because the legislation, sir, is written, sir, in a way that the public servants feel proud about it, sir. So there is no underhand business going on in this legislation, no attempt, sir, to sabotage anybody. And I just wanted, sir, to take this opportunity to make those things clear. There are a few other points, sir, but that is an opportunity for another time, sir. So with those few words, I beg to move this bill will be read a second time.
Honourable, the microphone.
Mr. Speaker, sir, I beg to move this bill be referred to the Joint Standing Committee on Social Sector and Environment.
Question is that the bill be sent to Select Committee. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Order number 8, sir. In the name of the Honourable Minister of Home Affairs and Information, to move the second reading of the Child Justice Bill 2023.
Honourable member for Christchurch East.
Mr. Speaker, I thank you. It is very difficult coming behind the impassioned and passionate and heartfelt presentation by my colleague from St. Michael South. It is such passion, sir, that was displayed through this entire process as we worked together to harmonize the child protection legislation and the child justice legislation. I saw a side of him, sir, that having read some of his poetry, I knew that he had, but often he camouflages his softer side, sir, with political bravado. But he could not camouflage it with something as near and dear to his heart as child protection. And I know one of his children, sir. One of his children actually lives in my constituency. And they say you shouldn't judge a parent by the child. Usually they say that when the child has done something bad. But I think, sir, that he'd be happy to be judged by his child because she's a wonderful young lady who thinks he's the best father in the world. Sir, where are we and why are we here? If we live in Barbados, sir, and we cannot ignore the circumstances increasingly facing our children, we would have grown up, sir, at different stages with the challenges appropriate for the times in which we live. Back in the day, sir, my mother's only concern, or her concern, was I got home before the street lights came on. She didn't cast her mind any further than that. When we went to the beach in summer, sir, we left in the morning. I just had to get back home before the street lights came on. At that point in time, your parents started to worry, not before. A child, sir, the most a parent would shout at you, tell you, look, go outside and run about, and stop playing video games because video games had just come in. And the legislation, sir, that might have governed us as children, both in terms of our protection and in terms of our justice, would have been appropriate for the times in which we live. By our time, sir, my time was a little bit behind yours, but by my time, sir, the legislation was becoming outdated. So you know, if it was outdated some 40 years ago, then it is woefully outdated now. We are brought face to face with the realities of what our children are facing. We read of the problems that our children are encountering. Often, some people say that we've deviated from old, hardcore Bajan values, that our children are subject to too many outside influences, that they don't know right from wrong. I think, sir, it is simply the effluxion and evolution of time. Every generation has to deal with new challenges, and the rules that govern us in society must be constantly reviewed to make sure that they're appropriate for the challenges being faced by that generation and to govern society and prevent anarchy. Sir, what is clear from the suite of legislation, and by suite of legislation, sir, I will refer to the child protection legislation, the child justice legislation, and the soon-to-be amendments to the educational system, sir. If you have sight of all of these pieces of legislation, it is clear, one thing is patently clear, that children are at the center of it, the well-being and the protection of our children. In the wider outside circle, sir, is the retention of the family. So all of these pieces of legislation, sir, tend to steer us toward protecting and guiding our children, and also as much as possible keeping the family unit intact, whether it be by direct intervention with the children or whether it be with direct intervention in relation to the family unit. This child justice bill, sir, was on the card, but let me not say this. A child justice bill was on the cards when the last government was in. It was not brought to this parliament for reasons best known to them, though I understand that some form or fashion of it was floating around and knocking around on the desks of those responsible for well over 2 to 3 years. But it did not come before this parliament. We took the position, sir, back then, in 2018, that focus on our children and modernizing our legislation was a critical thing for us. When my honourable colleague for St. James North, sir, occupied the seat that I now hold in cabinet, he pulled that legislation, dusted it off, looked at it, decided it was woefully inadequate, and went back to consultation on it because things had moved on. And we were intent on getting the best possible draft of the legislation as we can. As with our whole legislative process, we're not looking at stopgap legislation. If we're looking to revolutionize an area, sir, we strip it down, we deconstruct it, reconstruct it, and make sure that at the time our legislation is passed, it is cutting edge. It is the most modern piece of that type of legislation in the world at that time. And I wish to thank my colleague from St. James North, Mr. Edmund Hinkson, who started this process and gave me a platform on which to back with the runs already scoring. There was a lot of work, and he also remained an accessible and willing resource for me with questions that I had and my ability to consult with him to get us to the point where we are now. I also wish to commend the honourable member for St. Thomas, who occupied the position previously held by the honourable member for St. Michael South. And she worked tirelessly to push both pieces of legislation. Quite frankly, sir, the child justice legislation was ready in some form well before the child protection legislation. But we also had to look at the signal that we wanted to send. With what was happening with our children, did we want to send the signal that this government was more important on dealing with them once they got into the system? Or was it equally or more important to keep them out of the system? Thus, it was decided, sir, that we should run the preparation of the child justice legislation and the child protection legislation side by side on a parallel course. That had an additional benefit. The additional benefit was that it allowed, anytime an amendment was made in one, to make sure that that amendment harmonized with what was happening in the other, so that when we come to the end of it, although the two touch and concern different topics, they are necessarily related, because as you will see when I get into mine, a process started under the child justice legislation can be diverted, and the child continue under the child protection legislation where the circumstances so warrant. So they had to be harmonized and harmonious. And we went through a long process. As the Honourable Member for St. Michael South just said, we consulted with everybody. Everybody who had an interest had a seat at the table. All of the persons that you know who are accustomed to speaking on this topic had a seat at the table. All the organizations who you know have representative interests in this subject matter had a seat at the table. And we embraced all because it was important to us that when completed, this legislation was our own. It was owned by all of us, not just this Barbados Labour Party government, but also the traditional opposition party, also the fringe parties, also all of the stakeholder organizations, also the man on the street. It was intended that everybody looking at this would have had a chance to play a part or have their voices heard in relation to it. We didn't want to drop something. I mean, children concern us all. The family unit necessarily is contemplated to include a child. So every family in Barbados contemplates or contemplated a child in it. So everyone should have had the opportunity to weigh in on this because it affects us all and it affects the younger generation who will grow up to be decision makers in this country as well. So when we approach the last election, in the manifesto, sir, for 2022, under the justice system, it was clearly said, sir, that there will be emphasis on juvenile justice legislation. Sir, also, there was a recommitment to our position on restorative justice. As outlined in the 2018, I can make this a document, House, sir. I believe it already is. As outlined in the 2018 manifesto, alternatives to the fine and confine approach were established. The BLP will build future altering interventions, whether it be coding classes in prison, after-school music classes, etc. But there was the commitment to restorative justice. And restorative justice as well, sir, plays an important part in the juvenile justice legislation, the child justice legislation. So the Barbados Labour Party is a front runner in this. It was under the former Attorney General, Sir David Simmons, that the Penal Reform Act was framed and sought to transform the system of justice in Barbados. What we perceive justice to be, what were the imperatives of justice, what were the focuses on sentencing, whether it be rehabilitation, with a heavy emphasis on rehabilitation, and trying to put our persons who had to be away from their families for a while in the best possible position to go back in and become constructive members of our society. That was started, sir, way back in the 1990s administration of the Barbados Labour Party. What we're doing here, sir, is having wasted some good 10 years between 2008 and 2018 on it, we are now trying to bring it to its fruition. We're trying to bring it before the people of Barbados as a living, breathing document, which they will have a further ability to input into. Sir, how is it different? How is this new legislation different? This bill, sir, is intended to bridge the policy gaps and capture the legislative and institutional amendments necessary to provide a holistic approach to the rights of the child, sir. And this bill will make or does make provision for the reform of two pieces of legislation that have recently occupied the attention of the public: the Juvenile Offenders Act, Cap 138, and the Reformatory and Industrial Schools Act, Cap 169. Sir, we seek here to establish a modernized approach to handling children who are in conflict with the law, and that is the phrase that we choose to use rather than juvenile offenders or whatnot, which carries a certain stigma on it. We try to, in our wording and in our structure, emphasize the positive outlooks that we're trying to make and try to stay away from stigmatizing our children. So we're trying to establish a modernized approach to dealing with children who are in conflict with the law by establishing, sir, a system of assessment to ensure the child is properly assessed by a court in proportion to the offense committed. We establish a diversion mechanism. All of these I'll go into further, but I just want to state them up front, which enables the court to remove the cases of children who are in conflict with the law from formal court proceedings. It's also incumbent to ensure that children who require care and protection, which can better be dealt with under the Child Protection Act, are diverted to proceedings under the Child Protection Act. We also look at different forms of sentencing, sir. So community-based sentencing, restorative justice sentences, and corrective supervision. There also is provision for the operation of secure residential facilities for the detention of children who have committed serious offenses, the establishment of a reintegration board to facilitate the early release of a child from a secure residential facility. So I'll just pause here for 1 second. This government is perhaps the government that has most sought to divest itself of authoritarianism where it could, of absolute authority. The Prime Minister, our Prime Minister, sir, is perhaps the Prime Minister who has most shed things within her discretion to make it more palatable and transparent. So under the existing legislation, the person who got to decide whether a child had to stay the full term or go home early was the minister, in the sole discretion of the minister. The minister does retain a discretion under this new legislation, sir, but in addition, there's a reintegration board, and the name says what the objective of that board is. At the earliest possible time, to be able to reintegrate the child into its family, back into society, back into school, so that the child can continue to be a productive member of society. And this bill, sir, also seeks to involve parents and the community in the processes by way of family group conferences. Now, I will deal with that separately. Sir, let's start first with the application and criminal responsibility. This act has said that a child under the age of 12 is not capable of committing a criminal offense. Under the previous legislation, so under the Juvenile Offenders Act, Cap 138, Section 8, right, said that the court shall not render punishable for any offense a child who is not, in the opinion of the court, above the age of 11 years and of sufficient capacity to commit a crime. We know, sir, what that has led to. The ambiguity in the language has led to situations where it is sought to establish that the child, although under 11, had a requisite mental capacity to be able to commit a crime. And for those who are listening, a crime has two components. There's the actus reus, which is the act, the offending act, which under the legislation constitutes a crime. But you must also have the mens rea, or the mental ability or intention to commit a crime. So if you accidentally do something and a crime results, but you were not negligent in doing it, then the court will likely find that you had no mental component to establish a crime. So although the action happened, the crime was not committed because there was no mental element there. So this posed some issues, sir, when arguing as to what really is the appropriate age for criminal responsibility, and is it an absolute age? Is it an age based solely on a number? Is it an age based on a combination of a number and maturity? Is it an age based on a combination of a number, maturity, and IQ? And this has led to some interesting results in the courts. Sir, this legislation has changed that. Clause 5, early up, sir, Clause 5. A child under the age of 12 years is not capable of committing a criminal offense. There's no ambiguity there. There's no wiggle room, there's no leeway. Under 12 years old, that child is not deemed to have the mental capacity to commit a criminal offense. Sir, it also looks, sir, at the general guidance as to how a child should be treated in the context of the juvenile system, taking into consideration the safety, welfare, well-being of the child, his beliefs, and the rights of the parents. And part 3 of it deals with the assessment of a child. Now, this is a brand new and critical addition to the legislation, sir. As it stands now, sir, a child or someone convicted of an offense or charged with an offense gets to have their circumstances considered after they are found guilty at the stage of mitigation. So when you go through the entire process, then if the person is found guilty, there's special circumstances that are considered then to assist in what the appropriate sentence should actually be. Under the new legislation, sir, when the police officer brings in or takes custody of the child, before anything else, that child is supposed to be assessed by a probation officer. Before anything else. So I'll give you the comparison between the old legislation and the new legislation. Under Section 992 of the Juvenile Offenders Act, the language is before deciding how to deal with him, this is after a finding of guilty, the court shall obtain such information as his general conduct, home surroundings, school record, and medical history as may enable it to deal with the case in the best interest of the child or young person, and may put to him any question arising out of such information. Now understand, sir, once again, this is after a finding of guilt. The new parallel clause, Clause 7.4, the police officer responsible for the investigation of a case with respect to a child apprehended in accordance with subsection 1 shall ensure that the child is assessed by a probation officer before the commencement of the initial inquiry into the offense alleged to have been committed by the child. Before you start to question that child has to be assessed. Even after questioning occurs, when the child, if the child is charged or brought before the court, the magistrate or presiding officer has access to the initial assessment. So before the evidence is taken in respect of the child, the magistrate is fully aware of the circumstances of the child that he's dealing with. This is not a child in abstract. When young Arthur Holder comes before me having committed some offense, sorry, sir, I will respect the sanctity of the seat. Sir, when young Kurt Humphrey comes before me having committed some greater offense, I know who Kurt Humphrey is. I know where he came from. I know how he's doing at school. I know what his intellectual level is. I know if he's been in other difficulties, because that then allows me to make other decisions and informed choices that ensure the best treatment for Kurt. Young Kurt, based on what I know, may not be served by going through a judicial process. Young Kurt might be better served by diversion. Or young Kurt might be coming from a family where the behavior of the family is such that Kurt has to go and steal to feed himself. At which point we should not be looking at finding Kurt or charging Kurt or trying Kurt for theft or shoplifting. But instead we should put him in a protective environment where Kurt gets the food that he needs. So this is a revolutionary approach to justice. Sir, under Clause 13 of the previous Act, no young person shall be sentenced to imprisonment if he can be suitably dealt with in any other way, whether by probation, fine, corporal punishment, committal to reformatory or industrial school, or otherwise. Compare that, sir, with the new section, the new parallel section, or comparable section, which is 59.2. A sentence of imprisonment shall be used as a sentence of last resort, and that sentence shall not be imposed unless the child is of the age of 14 years or older at the time of commission of the offense. So we start by saying it is a last resort. Imprisonment of the child is a last resort. Now, sir, under the previous legislation, the age in which you consider the possibility of imprisonment, I believe, was 10 years. But this one has now moved it to 14. Sir, if we look at the Reformatory Schools Act, other provisions in relation to the children and how they are secured and dealt with, it says at 11.1, wherever any child who in the judgment of the court or magistrate before whom he is charged is under the age of 16 years old, is convicted on indictment or in a summary manner of an offense punishable with imprisonment, in lieu of or in addition to any other punishment which he may be subject, the court or magistrate may subject to Section 2, sentence him to school, and there detain for a period of not less than 3 years and not more than 5 years, but not in any case extending beyond the time when the boy is in the opinion of the magistrate to attain the age of 19 years. Sir, the point was made by someone yesterday. Sir, that the old legislation treated the juvenile in a worse way than adults. Juveniles got the short end of the stick. So where there was an offense, sir, that was punishable by imprisonment, where imprisonment was an option, I need to be real clear on this. Where imprisonment was an option, and an adult, so where for an adult it would have said a fine or imprisonment, for a child, fine was gone and imprisonment occurred. And that imprisonment, sir, had to be between 3 to 5 years, a minimum of 3 years. Any child awarded a custodial sentence by the court went up for a minimum of 3 years. There was no 6 months and let's review. All of the options, sir, that existed to adults and were available to adults to deal with them, to evaluate them, to consider them, to suspend a sentence, to whatever, all of those options or none of those options apply to children. If you were found guilty of an offense that could attract imprisonment, you went up for 3 to 5 years. So let's take the wondering that people don't like to talk about. Well, everybody likes to talk about. A girl who was found guilty of wandering went up for mandatory 3 years. There was no provision to assess her situation after 6 months, a year. She's shown exemplary discipline. She's shown exemplary progress academically. Let us give her a chance on the outside. And this applies to boys too. Any boy attracting a sentence that was punishable by imprisonment went up for 3 years. And our aim and the trend of modern legislation is to invoke judicial discretion. It's to promote judicial discretion, especially in terms of sentencing. And we talk about about mandatory minimum sentences, and people question the constitutionality of mandatory minimum sentences. Sir, we had them existing in our legislation in relation to children, and no one questioned it. So we have now done away with that. Sir, it goes further to state, so in relation to corporal punishment, I know this is a hot one for people. So under section clause 59.5, corporal punishment, severe or frightening measures shall not be inflicted on a child detained in the prison under the section. And in relation to those in a secure residential facility, section 87.1, corporal punishment, severe or frightening measures shall not be inflicted on a child in a secure residential facility. Now, sir, what does that mean? Not just the corporal punishment or whipping, as some of the legislation has it, but you can't even threaten to do it. You cannot punish a child in a way that is severe or frightening to that child. The child must understand the reason for which they're being punished, and the punishments for the most part, sir, are also set out in the new legislation. But what is clear is that corporal punishment is now completely removed as an option in relation to children under our penal system and under any realm of sentencing in relation to a child, no matter what the offense. Sir, I pause here to switch a little bit and let's talk about the initial inquiry and diversion. I think perhaps the signal policy enshrined in this legislation is diversion. The ability to divert. What does that mean? I hear no one ask. As it stands now, sir, if a child comes into conflict with the law and is picked up by the police, that child is questioned. If an offense is found to have been committed, that child is then charged and tried pretty much in the same way that you would try an adult. The child goes through the prosecution, the lawyer may make a no-case submission. If not, they continue to defense. They go the whole way through. And at the end of it, if the child, as I said, is found guilty of something punishable by imprisonment, that child can be sent up into custody for 3 to 5 years. That's as it stands now. We have introduced something now, sir, called diversion. Diversion, I think there's a definition for it, sir. 1 second, sir. It is so important, I actually want to read the definition of diversion, sir. Diversion means the removal of cases of children alleged to have committed an offense from the formal court procedures and the adoption of informal procedures in relation to such children, pursuant to Part 5. And a diversion option means a plan or program with a specified content and duration set out in 3 levels under Section 36. Now, what will now happen is that a child who is picked up by the police for being in conflict with the law gets their initial assessment. The police then will do their investigation, but that child, during the course of that investigation, has to be attended by a social worker, a parent, and they have the right to an attorney. So this is not even a legal aid discretionary thing, no, sir. The law actually says that the child has a right at every stage to be represented by an attorney paid for by the government. So we may have to reshape the legal aid framework, because this, as I said, this is not discretionary. Any child, of course, you can't force anybody to accept legal assistance, but any child who wishes to avail themselves, or any parent who wishes to have their child avail themselves of legal representation is free to do so, whatever the offense, at the expense of the state. And there are certain rules in relation to the attorneys as well who deal with the children, that they have to explain to the child in language they can understand, that their foremost duty is to the child, while they can encourage the child to take responsibility for their actions. They should not pressure the child, etc., etc. right? So it's child-centered, but you go back to diversion. So the investigation is carried out, and a charge is brought. When that child first appears before the magistrate, as I said, would have seen the assessment form. If the magistrate has not yet seen the assessment form, the proceedings are halted until the assessment is done and the magistrate has cited the assessment. At that point in time, sir, the magistrate can use his discretion and say, you know what? Based on what I see here, no justice is going to be served. Send this child through a formal court process. Maybe it is better that we engage some other form of resolution in relation to the child. Maybe it is better that we engage the child protective services to deal with the child and can divert the child at that point in time. If it doesn't occur there and the court starts to hear the proceedings in relation to the child, at any point in time in those proceedings prior to the close of the prosecution case, the magistrate can halt the proceedings and recommend diversion or make a diversion order in respect of the case. And the lawyers representing the children are also encouraged to be able to push for the diversion orders. What does the diversion order do? The diversion order says, you don't have to go through these formal proceedings. Let's have an evaluation on you. Maybe an apology might be sufficient. Maybe an apology and counseling might be sufficient. And there are levels of the diversion. I will go into them later, sir, but the basic thing is that if the matter is so diverted and the child satisfies the terms of the diversion order and complies with and receives a favorable report from the probation officer, then that's the end of the matter. Then the child has no conviction against him and is not in danger of going anywhere and can go home to his family. And there's family counseling involved in here as well, sir. Sir, proceedings in the court are also conducted in an informal manner, sir, to encourage maximum participation between the child and his parents or an appropriate adult in a manner that can be understood by a child. So the legal jargon is out of place. The court proceedings in relation to the child are conducted in language suitable for a child to understand. The attorney, and they're informal, so you can get interjections in there, you can get clarifications in there. The magistrate can ask the child, do you understand what was said? Ask the child, would you like to explain it in your own words just so I can understand, so I'm certain that you understand what is going on. So the whole proceedings are child-friendly. And as I said, the court may divert the matter anytime before the closing of the case for the prosecution. So if we get to a point of a guilty, pre-sentencing reports and pre-sentencing conference is mandatory before the court can sentence. So the court cannot impose a custodial sentence unless a pre-sentencing report has been received and considered by the court. But even so, and that's under section 50 and 51 of the new bill. Even so, sir, the pre-sentencing conference includes the probation officer, it includes the representative of the child, and it can include the child as well. So there is no unilateral decision-making in respect of the sentencing for the children. At all points in time, the child's interests are there to be represented so that the final outcome, no matter what it is one that has had the child at the center and all options in relation to the child having been considered. Sir, the other thing, another important diversion, sir, or addition, is the use of the family group conference. Now, this does not appear anywhere in any legislation that we have previously had. Nowhere at all does it appear. And it is deemed to be a part of the restorative justice agenda, sir. So At paragraph 54, at clause 54, which is under restorative justice sentences, where a court makes a determination of guilt with respect to a child, the court may refer the matter to a family group conference for a written recommendation. And who are in the family group conferences, sir? The following persons shall attend a family group conference: the child and parent of the child or an appropriate adult. Because let's be honest, sometimes with the children who are in conflict with the law, the parents have no interest in the child at all and don't appear. So if we kept referring to the parent of the child, then half of the important aspects of the legislation will be hamstrung if you don't have cooperative parents. So the court can also appoint an appropriate adult, or an appropriate adult can also be recommended by the probation department. So every time you see parent or guardian, then an appropriate adult is there to act in loco parentis if none can be found. So the following person should attend a family group conference: the child and parent of the child or an appropriate adult. Any person reasonably requested by the child. So the child can actually say, you know what, I trust Uncle Wilfred. He's my godfather. I want him to be there. My good godfather. The probation officer, a police officer, importantly, sir, the victim of the alleged offense which the child committed, and where the victim is under 18 years, the parent of the victim or an appropriate adult on behalf of the victim. The attorney at law representing the child where applicable. A member of the community in which the child resides, recommended by the probation officer, and any person authorized by the probation officer to attend the family group conference. So there's no limit. And what you're seeing now, sir, is community involvement in the process. So we are not looking at the child in abstract. A priest from the area in which the child is, where the child goes to church, or who knows the child, can say, look, let me help. I want to help. A Sunday school teacher, a neighbor, you always got them people in the gap who look out for the children in the gap. That person can be called to attend, a mentor, right, can be called to attend a family group conference. And the aim of this family group conference is restorative justice. It is meant to bridge the gap between the victim of the offense and the child in conflict with the law. So this is ADR, sir, alternative dispute resolution at its best. This is perhaps the most progressive thing that we have done in relation, no offense to my friend from St. Michael South, but this is perhaps the most progressive thing that we have done in relation to resolving issues or disputes with children. Now, there's a procedure that you have to follow, sir, and the family group conference is encouraged to try to resolve it, try to make an award that restores the injured party, right? Usually an apology is involved, all that sort of thing, sir. But if for some reason the family group conference cannot bring a resolution to this, then the matter is referred back to the court. I think they have 14 days, or they have a time limit to deal with it. But then the matter is referred back to the court, which will proceed with its sentencing. Now, sir, another important thing is under section clause 63, notice the parent of child. And that clause, importantly, says, people keep saying, I find a lot of parents, sir, have abdicated responsibility for their children. They let the children leave home, the children behave as they will, and the parents take no responsibility. When children damage some things, sir, the parents ain't want to hear that. They were not there. They ain't tell the child to do it. They ain't got none to do with that. So the victim who can't enforce for damages against a child is left without a remedy. Sir, not anymore. Under section 63, where it appears to the court that finds a child guilty of an offense relating to the property or against the person of another, on evidence admitted or on submissions made in the case against the child, the willful failure on the part of a parent of the child or an appropriate adult to exercise proper care of or supervision over the child was likely to have substantially contributed to the commission of the offense, and B, that compensation may be paid to any person for loss caused to the person's property, whether the loss was an element of the offense charged or happened in the course of commission of the offense, or injury suffered to the person, whether as a victim of the offense or otherwise, because of the commission of the offense. So effectively, the court can give notice to the parents that you may be held liable, and the parents then have to appear. And when I say parent, I mean parent, anybody who has custody of the child, has to appear to show cause why it should not be levied against them. The other thing here, sir, is in relation to children, quite often the offenses don't necessarily combine all of the elements of an offense for an adult. So even where damage occurs, like a child, I don't know, runs through your house swinging a bat, right? And then runs out in the road and somebody swerves and to miss the child and crashes into a pole, right? So, but then it follows, the causal, what is a normally or naturally inferred consequence of the action, falls to be compensated by the parent. So where a parent has been delinquent, they're not monitoring the child, they should have known better, their poor exercise of control over their children, or their negligence in respect of that child has resulted in damage to the property of another or to the person of another, then that parent can be called upon to pay the damages. And if they don't pay the damages, sir, then you know the normal causes in relation to contempt of court and imprisonment then follow. So, for all who feel that being a parent is you beget a child and that's the end of that, no. You need to participate in your child's upbringing. You need to participate in supervising your child. You need to monitor what your child is doing. You need to pay attention to the child's behavior because you may be held responsible for it. There was some concern, sir, under the former legislation in respect of something that happened maybe 2 years ago, sir, where a parent was concerned that they may not have been notified that their child was moved for treatment from a secure residential facility or from the government industrial school. We have sought to address that and codify that, sir, by section 79.5 that says where a child is moved from a secure residential facility to a hospital facility, psychiatric facility, or residential protection and treatment center for examination or treatment, the child is not discharged from custody, and during the time the child is hospitalized, the child should be deemed to be in the custody of the director of the secure residential facility in which the child was detained before hospitalization or treatment. But it also said, sir, that notwithstanding subsection 3, that they remain in the custody of the director, no child who is hospitalized in a psychiatric facility should be discharged from this facility except in accordance with the provision of the Mental Health Act, and the director shall notify the parent of the child or an appropriate adult and the director of child protection where a child is moved from a secure residential facility to a hospital, a psychiatric facility, or residential protection and treatment center for examination or treatment. So no moving of people's children without their consent or information. And as I said, sir, we account for the fact that sometimes the parents are unreachable. So if the parent shall be notified as soon as possible, sir, and in addition, the director of child protection. So the child cannot leave a facility without somebody in the protective services knowing and understanding where that child is and what treatment that child is being afforded at any point in time. Sir, we have here, sir, perhaps the most revolutionary piece of legislation that we have brought so far. And it is child-centered. Although the child protection legislation, which was dealt with by my colleague before, deals with the protection of the child and the embracing of the child, and this legislation is normally contemplated to be the punitive aspect of the suite of legislation. This piece of legislation at all stages also protects and secures the interests of the child. So I perhaps should have started with this, but I take you to the principles enshrined in paragraph 6.1 of this legislation because they properly encapsulate exactly what guided the legislation, sir. The court or person performing any function pursuant to the provisions of this act shall be guided by the following principles. The safety, welfare, and well-being of the child shall be the paramount consideration. Codified is in the law. The safety, this is number one, guiding principle number one. The safety, welfare, and well-being of the child shall be the paramount consideration. B, a child shall, as far as possible, be given an opportunity to respond before any decision is taken which affects the child. As I said, the proceedings are informed at every stage, sir. The child is represented, has the right to be represented by an attorney, and that attorney can intervene on behalf of the child at any stage in there. C, a child shall be addressed in a manner appropriate to his age, maturity, and intellectual development. D, a child shall be treated in a manner which takes into account his beliefs. This is all-embracing, sir. So persons of different religions, different spiritual backgrounds have the right to have their beliefs taken into consideration. All procedures carried out under this act shall be conducted and completed in a timely manner. F, the parents and family, can I have some water, please? The parents and families of a child shall have the right to assist the child in proceedings under this act and wherever possible to participate in decisions affecting the child. So this legislation does not keep parents on the outside. Normally, sir, the players in the judicial process are the prosecutor, the accused, defense counsel, and the presiding officer, judicial officer, whether it be a magistrate or a judge. Right? Those are the players. In this legislation, we've bent and shaped the rules so as to recognize the frailties and vulnerabilities and the particular and peculiar circumstances of children and allow them to be represented by the parents at every stage of the proceedings. All consequences arising from the commission of an offense by a child shall be proportionate to the circumstances of the child, the nature of the offense, and the interests of society. And this ties in with the restorative justice, this ties in with the diversion, this ties in with all of that, sir, that when you're dealing with a child, if it is a minor offense, then you deal with it in a way that encourages a resolution of a minor offense. If the child is poor and from humble backgrounds, then you deal with it in a way that accommodates the particular circumstances of that child. If, sir, to be honest, it is an archaic piece of legislation that is there because we just haven't cleaned it up off the books and it is of really no interest to society, then it is accorded the status of a no interest to society case. But it's proportionality. You look at the child themselves, you look at the nature of the offense, and you look at the interests of society, sir. And these are set out in the principles of the legislation. And a child shall not be treated more severely than an adult would have been in the same circumstances. So this, although we've taken away the mandatory 3 to 5, whatever the sentence for an adult is in relation to the offense, a child should never get a harsher penalty than an adult of the same circumstances would for the case. A child lacking in family support, education, or employment opportunities shall have equal access to available services. And I'll do H and I together. Every effort should be made to ensure the child receives equal treatment in relation to other children who have committed similar offenses. Sir, the bulk of the children who are in conflict with the law are the children of poor people, of poor Barbadians. Whether it is their circumstance, whether it is where they grew up, whether it's where they went to school, whether it's the influences that are in the gap near them, the reality is you don't see rich people's children in court. You don't see it. You hardly see middle-class people's children in court. If a middle-class child go and shoplift something, the parents can intervene real quick. Sir, shell out some dollars, and that charge disappears. Where a poor child goes and steals something, then the parents ain't got the money to make the approach. They don't have a name. They don't have a clout to call the supermarket manager and say, listen, that's my child. So the reality, no, let's be straight, sir. Let's be straight. Every time, sir, the public would not necessarily know because matters involving children are not reported in the press. But sir, we know having been in the court, every time you see a child in there for an offense, the child doesn't speak well, the child is not doing well in school, the mother, if they have to pay a fine, struggles to pay the fine, the circumstances are the same. So those children are disadvantaged by our system as it currently is. Poor people, children can't afford top lawyers. So I know you do some pro bono work, but sir, if some of those people that you represent had to pay your full fee, they couldn't do it. They couldn't do it. So what we have done in this legislation is no poor child is going to be disadvantaged because of the circumstances. They get access to everything. Everything that anybody else would be. You get access to a lawyer. You get access to a probation officer. You get access to a system that is now shaped to protect you and encourage your diversion out of the system. Normally, sir, we try as fast as possible to get to the end of a case. Right? When you have somebody who poor can't defend themselves, the worst thing, sir, is some people who choose to defend themselves. You know the prosecution runs through them cases. Just get the end of sentence. Just get to the end of sentence. The aim of this legislation is not get to the end of sentence. The aim of this legislation is divert wherever possible. How else can we deal with this other than convicting a child, a poor black boy or girl? Sir, that was the guiding principle of the legislation. When making a decision regarding the release of a child in detention, sir, because you get to consider at the first hearing, you get to consider during the process, and even at the end, sir, a court shall consider the following principles when making a decision regarding the release of a child in detention. Preference shall be given to the release of a child into the care of a parent or an appropriate adult with or without the imposition of conditions. My friend just now, not an hour ago, sir, he spoke about the preservation of the family unit. And we're doing more than anybody else, sir, to try to keep that unit intact and encourage rehabilitation and reintegration. At every step in this process, we're trying to get the child out of the system. And even, sir, in considering whether to release the child, the first consideration is not releasing the child to the child care board, is not releasing the child into a protective environment. The first consideration and preference, the use is the word preference. The preferred option for the court in dealing with children is to send that child back home and let that child come to court where necessary. So where the release of a child into the care of a parent or appropriate adult is not feasible, the release of a child on bail or bond upon the recommendation of the prosecutor shall be considered. So sometimes you don't want to put that child back with the parents because the initial assessment might have pointed to the fact that the parents are largely to do with the behavior or neglect of the parents are largely to do with the child being there in the first place. Then you consider putting that child on a bond, sir. And if the child is above a certain age, the child can be put on a bond of its own recognizance. And so where a child must be detained as a measure of last resort, I like the language, sir, that's being used. They're making it real clear. Preference, go home with your family. Where, as a last resort, the child has to be detained, the least restrictive form of detention appropriate to the child and the offense shall be selected. Whatever is the minimum that we can do to secure your attendance back in the court, we will. Whether it's by reference to child protection and put the child in a children's home, right? Whether it's by sending them, sir, whatever the least restrictive form, because that child must not feel that they are a criminal. The child must not feel that they're a criminal. Sir, it set out some of the rights of a child while in custody and whatnot. Sir, the one thing, I'm going to wrap up now, sir. But one of the critical things here is that we try to get the children to own up to what they've done. So the diversion, the family conference, all these things are usually contingent on a child owning up. So where from the assessment, the child has indicated the probation officer, the initial assessment, that I know I did it, then the magistrate sees that straight ahead and says, you know what, this child has accepted. All right, so we don't need to carry them through the rigor of a court system. How can we best deal with this child so that they can be reintegrated? At any point in the proceedings, sir, where the child indicates that they're willing to accept responsibility, that they're ready now to accept responsibility. Because, sir, sometimes we don't feel what we did is wrong. We might take a hard-ass position that, well, I wasn't wrong. But when you hear somebody saying it, and you understand from the victim that I've been hurt by this, it may filter through, sir, through the explanation of the probation officer, through the explanations of the attorney, through whoever. It may filter through, sir, that, you know what, I didn't do right, and I want to accept. And all the aspects of the diversion are contingent upon the child's willingness to accept responsibility for what they've done. The indication is, you know what, I accept responsibility. And then we look at what form that responsibility takes. Sir, I'm not going to look for the exact section and give it to you off the top of my head, sir. But some of the levels of punishment involve something as simple as an oral or written apology. If it's a fight between children, you cuff the child somebody too hard, then perhaps an oral or written apology might suffice. If the other person accepts it, then that's the end of that. The court may release you with or without supervision, or requiring you to come back. Sometimes it's something a bit more. Sometimes it is counseling. Sometimes it's a mandatory order that you have to attend school, that you have to attend certain counseling or classes, that you have to keep a clean slate, that you have no contact with. The normal things, sir, that usually attach to probation, right? Normally, if we think of what the probationary terms usually involve, then, sir, they run slightly along that, except they drift to the more lenient aspects of it. Let's not keep the child in the system any longer than the child has to be in the system. Sir, I am going to... It's a very long section, sir, but when we studied law back in the day, sir, there were two aspects of sentencing: punishment or deterrence. The penal reform system brought in rehabilitation. And at that time, that was seen as cutting edge. Punishment can be something other a sentence can be something other than punishment or deterrence. You looked at what was the appropriate punishment. Was it a slight one or a hard one? And you know what? What do I need to sentence you with to ensure you don't come back here again? So those are the two aspects. We then were cutting edge in the 90s, and we brought in rehabilitation. How do we rehabilitate this offender and let them go back, let them understand that what they did was wrong, let them understand the need to do better, and let them go back to becoming a productive member of society? That's what we got to in the 90s. Sir, we have gone way past that now, sir. We are now at restorative justice. We are at restitution. How do we make the victim whole as part of our sentence? If the victim becomes whole, then we do not need to imprison you or slap a conviction on you. If you apologize, although you found guilty, then we divert you or we deal with you another way. We look at reintegration. How can we reintegrate the offender? Give them the best possible chance of reintegration. And these are not things to infer from the legislation. Sir, they're built in and specifically stated in the legislation. They're built in. The protections are built in there. Sir, this legislation attempts to change what child justice looks like. We have, over the last 2 years, the child justice system has come for some heavy licks, sir, in the public, in the press, in social media. We've come for some heavy licks, and in some cases, deservedly so. Sir, there is a perception that any child getting into the system is going to be unfair. The child will come out worse than when it went into the system. Oh, Lord, don't get the police involved. If that child barely go to court, the child get it for 3 to 5 years. And the child can come out disgusting. So that is what the concept and perception of child justice is now. Child justice helps no one, including the child. You end up sentencing the child. The victim doesn't get any restitution or restoration. Nobody's benefited but the child. You lock away the problem and look back at it again in 3 to 5 years. That is what child justice looks like. No, sir. No, sir. The intention now is to change what child justice looks like for a child who comes into conflict with the law. Sir, we have to locate the debate in the entire transformation process with respect to our children. I am glad, sir, I am glad that I came right behind the Honourable Member for St. Michael's South, because it says to everyone, let us read these things together. They're yin and yang. They're two halves of a solution. We can't get away. It can never be only child protection, sir, because at some point in time, children will actually run afoul of the law and have to engage with the judicial system. At some point in time, it will happen. As much as we may not want it, as much as we may not want to ever have to impose a custodial sentence on a child, at some point in time, we will have to. Let it be of last resort. But when it comes, let us ensure that the children who go into the system receive the best possible care and the best possible advantage in the system and come out better citizens. Thank you. Sir, and to this end, you realize that this legislation is putting a lot of burdens on the state. But the state has to do what it has to do. The system has to improve. Every person who comes in to contact with a child, whether under the child protection aspect or whether under the child justice ambit, every person coming into contact with a child has to be trained to deal with a child, not general social services, not general kind-heartedness. The officers who deal with the children should be trained in dealing with children. The probation officers who deal with the young children should be trained in dealing with young children. The social workers should be trained in dealing with children. The magistrates must get training in dealing with children. The court clerks, every person at every step has to have the training that enables this legislation and the child protection legislation to actually work, sir. And, sir, we need to deal with parental accountability. And as my almost parting shot, sir, I've been lucky, sir. I've been lucky. I've come up with people who cared about me, sir. And I've always had access to people who cared about me.
Yes, please.
I got some tough love back in the day. I think probably, sir, almost everybody in my gap beat me at some point in time. I used to give a lot of trouble as a child, sir. I'll be honest here. I wasn't easy as a child. And I was not abused as a child, but, sir, I accept that even when the tough love came, that the persons who administered it or who sought to take their time to correct me cared about me and wanted to see me do better. And we need to get back to that. Let us not turn a blind eye to what our children are doing. Let us not turn a blind eye to what our neighbors' children are doing. Let us not turn a blind eye to what our friends' children are doing. If you see children behaving bad on the road, do what I do. I immediately call the principal. I call them and get the principals, and I would take pictures of them. And I would tell the principal, some of your children are at this particular bus stop behaving in this way, or outside Cape Shepherd behaving in this way. Right? Sir, I love children. I love children. My heart is in this for children. This legislation is children-centered. I would not have it any other way. But as much as we need to get involved, sir, as much as we need to get involved, parents, the parents of Barbados need to get involved in the things that touch and concern their children. It cannot all be for teachers. Teachers have those children from 9 to 3? That's what, 6 hours? Teachers have children for 6 hours in a day, and not on weekends. You, the parents or the person in control of that child, have the child for all the rest. It is not for the teachers to instill the discipline that you refuse to introduce at home. You are responsible for, your child is a reflection of you. If you didn't want the child, you shouldn't have had the child in the first place. And if you cannot deal with the child and you cannot accommodate the child, sir, there are services provided by the government to assist in dealing with that, including counseling, sir. But what can no longer happen is that parents take their hands off, and when the worst happens to your child, you say woulda, coulda, shoulda. So, sir, the aim of the Child Justice Bill is to delineate the legislative and judicial measures to protect children as well as safeguard the rights of a child. It is envisaged, sir, that the children who become a part of the legal or criminal system at an early age would not be disadvantaged, but would be afforded opportunities to reverse their situation. This bill, sir, seeks to ensure that the time spent in a secure residential facility and by participating in programs and interventions, these children and youth will reintegrate into communities equipped with emotional intelligence, self-worth, and aptitude to become successful and productive adults. I repeat that. We seek to ensure that after time spent in a secure residential facility and participating in the programs put on, and by the interventions provided by this legislation and the child protection legislation, these children and youth will reintegrate into the communities equipped with emotional intelligence, self-worth, and aptitude to become successful and productive adults. But, sir, I caution you, the ultimate success and administration of both the Child Justice Bill, sir, and the Child Protection Bill that was recently introduced into Parliament will only be achieved and maintained if appropriate interventions and programs are designed and executed both at organizational and community levels, and I say at the family level as well. We all must work together. We all must work together and ensure that our youth are not ostracized, but they can be afforded opportunities within mainstream society to be in a position to reach their fullest potential and contribute not only to the development of themselves and their loved ones, but to Barbados. Sir, having gone through and over this bill more times than I can count, having consulted with more persons than I can count on the bill, sir, I am also satisfied, and this is, I didn't want to have to go here, but sir, I'll go here. Sir, this bill, I am assured, ensures compliance, sir, with the UN Convention on the Rights of the Child, Universal Declaration of Human Rights, United Nations Standard Minimum Rules for the Administration of Juvenile Justice, which we call the Beijing Rules, the UN Rules for the Protection of Juveniles Deprived of their Liberty, and the UN Guidelines for the Prevention of Juvenile Delinquency, the Rider Guidelines. We own this bill. This is our bill. This is this government's bill. This government's bill is part of a suite of legislation aimed at protecting our children from cradle to adulthood. We have ensured compliance with our treaty obligations, sir. But we didn't do it because of that. We did it because it was time, and it was right, and it was just, and it was the best that we could do, sir, to ensure the protection of the children of Barbados within our justice system. Sir, with those few words, I beg that this bill be read a second time. Sir, I
Honourable
beg that this
questions,
bill be sent to committee, sir, for further consideration.
Questions that this bill be sent to committee for further consideration. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, we revert to messages from Her Excellency the President.
I am in receipt of your message from Her Excellency the President. Her Excellency the President, to the Honourable the House of Assembly. Her Excellency the President wishes to inform the Honourable the House of Assembly that on the recommendation of the Prime Minister, under Section 3, subsection 1 of the Ombudsman Act, Cap 80, she proposes to appoint Dr. Nigel Taylor, JP, SCM, to the office of the Ombudsman established by Section 2 of the said Act. Her Excellency further wishes to seek the approval of the Honourable the House of Assembly for the proposed appointment pursuant to Section 3, subsection 2 of the said Act. Signed, the President, State House, Barbados, 23rd May 2023. Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 1:45 p.m.
The question is that this honourable chairman be suspended until 1:45 p.m. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it. This honourable chairman stands suspended until 1:45 p.m.
Order number 10. A name leading the House to move the passing of a resolution that an address be presented to Her Excellency the President approving the proposed appointment of Dr. Nigel Taylor, JPSCM, to the Office of Ombudsman.
Honourable Government Business.
Thank you, Mr. Speaker. I beg to move that the resolution do not pass.
The question is that the aforementioned resolution do not pass. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it. This resolution stands passed.
Order number 9, sir. In the name of the Deputy Prime Minister, Minister of Transport, Works and Water Resources, to move the second reading of the Water Reuse Bill 2023.
Honourable Member for St. Michael, Southeast.
Thank you, Honourable Speaker. To introduce the Barbados Water Reuse Bill, a bill, sir, that has been on the order paper for quite some time, and it has seen many iterations since its inception. But nonetheless, sometimes the road to getting completeness takes a little longer than we anticipate. And I'm therefore here this afternoon, Mr. Speaker, to be able to properly introduce this bill with the hope that it will also pass in the other chamber as well and be able to place us on a trajectory which is necessary as we try to grapple with not only climate change, but also new technologies as it relates to access to water as well. Sir, for years, Barbados has been labeled as being amongst the world's most water-scarce territories. I think we're probably at the 15th in the world. I've been hearing that from the time I became minister. It almost sounds like a stuck record. What I know, sir, is that for most Barbadians, when you start to have discussions about water, it is often relative to issues relating to the condition of the water, the fact that in some parts of the country, some people, they're getting water that is brown. In some cases, they may not have had the water been turned off for whatever reason. But generally, the discussions on water does not relate to really an in-depth analysis of issues of water scarcity or the different technologies that we may have to use as a country in order to improve or to conserve the very precious water resources that we have. Barbados has but a few streams or rivers. We more have springs above ground, and therefore most of our fresh water is actually sourced from aquifers which are below the ground. Perhaps the only time that we have recently even had to think about it is just over a month ago when I introduced the water prohibition, which I think Barbadians know. Anytime that you say that you want Barbadians not to do something, there is usually an outrage at first. But thankfully, I think Barbadians understood that it was an attempt to really send a message to the population that we are in a climate crisis, that we cannot wait until we find ourselves in a situation where we turn on the taps and there's no water, and therefore we have to take steps before things get out of hand to avert any level of a crisis. The conservation measures, Mr. Speaker, were therefore necessary. I can say at this stage that Barbadians have been, for the most part, adhering to the restrictions. We are in the middle of a drought. We anticipated it would last between April to July. If there are any changes to be made in relation to the prohibition, we will make the announcement in due course. But the projections were that we were obviously going to be experiencing some scarce water conditions over the course of the next few months. We had to take these actions similarly back in 2016, back in 2018, and I believe also in 2019. And we took these actions, as I said, to make sure that Barbadians understood the need to preserve and to conserve the scarce water resources. It has, over the course of the last few weeks, I think, made Barbadians think twice about washing their cars with potable water, water running from their taps, and for the main purpose for drinking. It has made them start to think or rethink whether they needed to wash down their houses, wash down the windows at this time of the year. And I believe what was perhaps most impactful was when we had the opportunity to be able to facilitate members of the media being able to go into the Bowmanston well and to be able to tour that well, to be able to see what the Barbados Water Authority sees, in the sense that that is one of the wells that gives that warning signal to the Barbados Water Authority that we may be seeing our precious water resources depleting. It is at that point, sir, that we start to think about water in a more serious way, when there's a reason for us to respond. I think we also are mindful that when the farmers started complaining across the country, that they too were being impacted as a result of the drought conditions, that they were unable to water the crops, and therefore it would have a deleterious effect in terms of their financial circumstances, because if you can't reap what you have plowed and sowed, then you find yourself in a situation where obviously it has implications in terms of your businesses. And therefore, I think as a country within the last few months, we've become a bit more acutely aware of the issues relating to climate change that are affecting this country. Mr. Speaker, it is estimated that around 43 to 47 million gallons of water per day is used by Barbadians, of which about 32 to 36 million gallons is abstracted from 22 public supply wells and 2 of our spring sources, which are operated by the Barbados Water Authority. In addition to this, there is another 8 to 16 million gallons, which is derived from private abstractions. And while it sounds like a lot, Mr. Speaker, in a drought, oftentimes the available supply or demand can exceed the supply that the Barbados Water Authority is obviously able to provide, and that can have negative consequences for the entire country. The fact remains, though, that with the impact of climate change, the frequency of droughts and extreme weather conditions are becoming more and more commonplace across the world. Sir, I recall when I made the statement regarding the prohibition, I spoke of a territory in the northeastern part of Spain, which had been experiencing a lack of rain. They've been in a drought for about 30 months. And while it is that that particular part of Spain is within the Mediterranean, it is known to have periods of drought from time to time. What is unprecedented is that usually you will have a bit of dry weather and then you will get the rains. But the challenge has been in recent times, sir, that the rains are not coming. And so when they seek to describe the conditions in the sense that they speak of the soil being cracked as hard as cement and the earth seems parched, I too, sir, get a little concerned, certainly when we had recent bouts of fires across the country, which obviously impacted a number of areas across the entire island. And to ask myself, really, if we can continue to ignore the issues of climate change and if they're not really right on our back door. Closer to home, though, sir, in Florida, we've also been seeing a number of wildfires. It's been affecting over 55% of the state. And I mention Florida because oftentimes if you say Spain seems so far away. But most people can appreciate Florida. Miami is just next door. So I say that because it is a direct correlation to, I think, what Barbadians can more appreciate. It is right on our doorstep, sir. And the reality is that when 55% of the state is actually being affected, it says, sir, that climate change is very real and that more and more countries across the world are actually recognizing that the definition of water has to expand beyond what we consider the conventional freshwater resources to also encompass things like treated wastewater, things like stormwater, and other sources as part of a country or an island's total water resources. Barbados, sir, is in no different a position. And conversations such as this have been going on for several years, and this water reuse bill today, sir, is really the culmination of a number of discussions that have been taking place. For me, it also marks, I think, the beginning of a sensitization campaign, a public education campaign that is intended to take Barbadians on the journey with us to not only understand the impacts of climate change, but to help them to grapple with different uses of water and ways in which we can help to conserve water at the same time, sir. Because like I said, these conversations are real and climate change is real. We therefore have to speak candidly about water, and we have to start to speak candidly about the reuse of water. And I believe that the time has now come where we must have those very candid and very open discussions with the Barbadian public about the future of our water resources. The Honourable Member, Minister of Agriculture, led the debate, I believe, last week on the Three Houses Spring. That is not by chance, sir, that you can tell that there are a number of things happening within this administration trying to address the access to water to the general population. That particular bill was able to ensure that there was better control by the relevant authorities to be able to preserve and to ensure that people were not denied access to water. And therefore, you will see over the course, I think, sir, of the next few months and certainly next year, a number of pieces of legislation that will come to this chamber trying to accelerate and to ignite in the minds of Barbadians a better understanding of where we are. From as far back as 2005, the Barbados Water Authority had commissioned a project which was called Water Reuse and Desalination Augmentation Project. It was focused on 6 key areas at the time. One of the things that it looked at was trying to quantify all of the available renewable water resources, both potable and non-potable in Barbados. It also looked at providing an alternative source of irrigation for golf courses and also for agriculture. It looked at the viability to recharge the groundwater supplies, looked at providing alternatives for non-contact industrial uses. And of course, very importantly, sir, it took a look at whether we should avoid or we should defer our capital investments for new wastewater effluent outfalls, and finally, whether we should reduce or eliminate adverse environmental effects from discharging wastewater effluent to the sea. The good thing about this project, sir, was that this project resulted in the submission of 3 reports. The first one was the Water Augmentation Project Concept Paper, which looked at how we augment our water supply. And there was also a draft water reuse bill. So I say that, sir, because obviously this thing did not start yesterday. This has been, when I say 2005, that should tell you how long we have been discussing water reuse and how long the technical teams have been trying to find something that not only was palatable, sir, but to provide a framework within which it could be discussed with the public and a platform on which they would be able to certainly reuse water safely. Coming out of that project as well, sir, was also the draft water reuse regulation. So again, we've said much about regulations in the last few sessions of Parliament, but just to reinforce, sir, any time that we have legislation, oftentimes it provides for ministers to be able to make regulations in order to operationalize the bills or the acts of Parliament when they become law. But we have found over the years that many times those regulations are not coming within real time, and it sometimes creates some problems in terms of people's understanding of what they must do, the standards and the policies that need to apply in relation to give teeth to that particular piece of regulation, of legislation. And we saw it recently with the Transport Authority regulations, which have taken 15 years before we can get an amendment to the legislation, sir. And there are several other instances where things have laid dormant for one reason or the other. But the truth is that we have found ourselves as a government having to really tidy up a lot of things to make sure that we too are not accused of allowing legislation to lay in waiting for unnecessarily long periods of times. But what were some of the findings that came out of that particular report? Coming out of that project, it was first of all discovered that the highest users of water on the island is for both domestic and agricultural use. Domestic being within the household, and obviously agriculture is self-explanatory. It is estimated that around 80 to 90% of the water used for domestic activity is actually discharged as what is referred to as wastewater. And for the avoidance of doubt, because I will probably use a couple terms in the course of this presentation that most Barbadians are not familiar with, sir, even some of my own colleagues, and they may do well to refer back to the actual bill so that they stay on top of the narrative. But wastewater, sir, when we speak of wastewater, we are referring to water that has been used or is a byproduct of an activity and contains other matter, whether it is in a solid, a liquid, or a gaseous state, or as the case may be, it could be surface runoff. And surface runoff is simply water, which is primarily from the precipitation, which is running over the lands across the country. The report concluded that this wastewater was a sustainable source of water, which could be treated and used as reclaimed water, which is therefore water which is collected from the wastewater. It is treated and it is processed to meet specific water quality criteria, which can then be used by the public or in a manner which may affect or even impact the public. So when we speak of reclaimed water, we're talking about a process which has taken place where the wastewater is actually treated, whether it's the domestic water, the water that comes from dealing with agriculture. You treat it, you process it, and obviously that has to be of a certain standard and a quality that allows for that to not be of any harm to individuals, sir. Obviously, to recognize that this water can be used will obviously flow from that there has to be some level of regulation. And that is what perhaps over the last few years, since 2005, the various technical teams across the ministries have been trying to work out how exactly do we regulate reclaimed water, water that we can make a better use of by basically treating it and processing it. The second major point, though, that came out of the report was that wastewater treatment plants had been in existence in the island since the 1990s. And so this came to, for me, as somewhat of a surprise because, like I said, I will be very frank. This is not a discussion that you have every day across from in the dining room. It is not a conversation that you can have in the constituency talking about wastewater. Yes, Minister, it's not a sexy subject, right? So you're not going to start talking about reclaimed water in any way. You're not going to start talking about wastewater treatment plants. But what is interesting is that they were in existence in Barbados, as I said, from the 1990s. What is also interesting is that some people operated them with or without a permit from the EPD, which is the Environmental Protection Department. And I place that there, sir, because I think Barbadians need to understand that sometimes things happen in their country because, and I give the reference sometimes of housing. If the government is not able to move fast enough to be able to provide housing for people, people are going to find a way to squat. They're going to find a way to put down a little 2x4 to be able to make accommodation for themselves, okay? And that is just the nature of people. It could be poor people, it could be rich people, it could be whoever. It could be brown, it could be white, it could be Indian, it don't matter. People will find a way to create opportunities for themselves, especially if government has not been able, not that it is unwilling, but unable to be able to put a framework in place to be able to operate. There were a number of hotels on both the south and the west coast, as well as residences that had been utilizing this reclaimed water. And in 2018, it was estimated that there were approximately 68 wastewater treatment plants, of which 18 had practiced some level of wastewater reuse. At the time, however, the EPD only approved the uses of reclaimed water to cover what would have been a narrow spectrum for use in golf courses, so basically to irrigate the golf courses, and for what we would describe as foliage irrigation, to basically wet the number of the plants in the areas. And this was using what would be referred to as a drip system. Obviously, it had the requisite criteria that had to be applied to it, where you had to go through the process of disinfection, because I'm sure all will be aware that there are obviously a number of pathogens that you have to make sure that are out of the water if you're going to use it for another purpose. And of course, you have to make sure that you treat the water to make sure that you don't have any associated health risks arising from not so doing. These approvals would have been granted under the Health Services Act, Cap 44, as well as the Health Services Disposal of Offensive Matter Regulations 1969. At that time as well, EPD was also getting a number of requests for grey water. And again, I will continue to explain, they're all definitions within the legislation, but grey water was something that people wanted to use for landscaping. Grey water is actually wastewater, which is generated from a kitchen sink, the showers, the bathtubs, the wash basins, or from laundry in either a house or a dwelling place, an office building, or a hotel or similar building, sir. Again, we don't call it by these very fancy terms, but these are the politically correct terms by which the technical people will refer to these things. And that is the simple, everyday use. If you go to the Parliament bathroom, you turn on the water, where that water goes is considered to be wastewater. And similarly from your kitchen sink as well. Another observation that was made from this project was also that a number of the establishments, in anticipation that there would have been a further expansion of the law, they went ahead and installed infrastructure in the form of what is referred to as dual plumbing, which is a system that utilizes separate piping systems for recycled water and potable water. So this then meant that they could use portable, non-potable water or reclaimed water in order to flush their toilet systems. Now here's where the problem came, sir. Because while it was recognized very clearly that there were potential benefits which could be derived from expanding the uses of reclaimed water. So we started off by drip irrigation, then we obviously were moving to having the dual plumbing system, which would allow for the flushing of toilets. The reality is that there was a willingness of investors and residences to be able to invest in these systems, and that is commendable. But of course, there was a concern for the health officials, for the technical teams. And it stemmed from the fact that some of the establishments had no color coding whatsoever of their valves and their pipes to be able to distinguish potable water from non-potable water. First problem. There was also no plumbing drawings which the Environmental Protection Department, in some cases, could utilize to be able to assess the systems properly that were being installed in the planning stages. And therefore, they recognized that if not properly policed and regulated, there was a serious concern and potential for cross-connection issues with even the Barbados Water Authority's potable water supply. So these are some of the issues that existed for some time that this piece of legislation that I will introduce shortly is designed to really correct. And it is not to say that the authorities let people do as they like, but in some cases, clearly persons went ahead and did things that obviously they set up the infrastructure for the systems, and they want to do more, but our legislation does not allow for the regulatory framework to be able to allow persons to be able to be regulated, sir. The importance of introducing a regulatory framework, however, to govern water reuse was further emphasized back in 1995. And this arose out of the introduction of what was referred to then as the water harvesting policy. The policy was designed to reduce the use of potable water through the harvesting of roof water, so the runoff of water from the roof, and it saw through amendments to the Town and Country Planning Order of 1972 a requirement that new residences with floor areas under 3,000 square feet would have to install a 3,000-gallon rainwater storage tank. I'm sure I was a lot younger then, and I do recall there was this real mad rush across the country to make sure that everybody got a water tank. I don't think that we perhaps may have understood the context in relation to climate change as we do now, but there was an uptake in the number of persons who, when they were constructing new residences, were encouraged to basically comply with the legislation and to go and to obviously obtain these storage tanks. So you had 6,000 gallons for residences over 3,000 square feet. You had, I think, non-residential buildings. If they had a floor space in excess of 1,000 square feet, they had to provide storage at a rate of 4 gallons per square foot. While the policy initiative, however, was a good one, and still remains a good one, it failed at the time to provide, again, a clear regulatory framework. And we needed the framework in order to address the design standards for the water storage tanks, obviously to provide guidance on the use of the harvested water, as well as guidance on how to prevent, very important factor here, mosquito breeding. Because again, what has been of concern is that we then went on to have a number of outbreaks of chikungunya and Zika and dengue fever between the period 2012 to 2015. And I'm no medical doctor, sir, but I've heard enough from the medical profession to know that in some cases, the presence of these viruses was also linked to, in some cases, people having the water tanks outside of their homes and certainly not following any particular practice to be able to ensure that they cleaned them, to ensure that they looked at the mesh sometimes that is at the top, sir, to ensure that mosquitoes were not going in and creating and laying eggs and having the larvae in the water to be able to breed mosquitoes. These were real issues, sir, and I speak of a time which I think it is important to understand why all of these things have led us to a point where we understand better now that it is not about the symbolism of sometimes the policies. Policies are good, but policies mean nothing if we do not think them through sufficiently to ensure that they can actually be operationalized. And in many cases, that's why we have continued to insist that whenever we bring legislation, even if the regulations are not ready at the same time, that there needs to be an urgency across all ministries to ensure that regulations are put in place in order to operationalize the legislation. So I can also speak to, because it came up in our parliamentary group, in order to meet sometimes the criteria for the Town and Country Planning Department, there were concerns raised that some people would go and borrow a tank from somebody else, or rent a tank and place it on their premises. And again, when they carry it back, obviously that person is not using it, and again, it became a breeding ground for mosquitoes. So many of these concerns, obviously the issues in relation to the wastewater treatment plants that were existing, the issues in relation to what happened in relation to the national harvesting policy, would have influenced a lot of what we will discuss today in relation to water reuse. It would have influenced the National Water Reuse Policy of 2019, which has in turn influenced, obviously, the drafting of this bill. Bear in mind that there was no clear structure for the promotion, the use, and the regulation of reclaimed water, and therefore a policy was constructed led by the Environmental Protection Department. And I haven't asked for your permission, sir, to call names, but I think particular mention should be made of the director of APD, who has led a number of these discussions and has been very instrumental in, along with all of the other authorities, in assisting us in getting to this point. They would have had to collaborate very closely at EPD with the Barbados Water Authority, the Town and Country Planning Department, Environmental Health, Ministry of Agriculture. So there have been a range of agencies that have had to collaborate and to share technical expertise in order to be able to, in a sense, guide us to safety. But why these agencies, sir? Because EPD As you are aware, they conduct the environmental assessments, they will do the environmental scoping studies, they advise the town and country planning on risk and potential impacts from development activities. The town and country planning department, well, they're responsible if you're intending to do the wastewater treatment plant, you have to apply for the permission. So they look at how we utilize our lands, look at whether permissions can be granted in consultation, obviously, with the other agencies that will weigh in. Environmental Health Department, however, they're responsible for promoting and preserving the health of Barbadians, and obviously they have to have access to premises in order to be able to identify any potential health threats as well. And I'll just pause there, sir, because in the course of the drafting of this legislation, persons who have been following will realize that initially we were trying to place the responsibility for this bill, the actual regulatory functions, with the Environmental Protection Department. But after extensive discussions with all of the stakeholders, I think we came to a consensus that while EPD has a regulatory role to play, that they're the ones who are going to be responsible for the inspection, sir, equally, the Ministry of Health has to deal with any back end that they have to clean up as a result of anything going wrong. And therefore, we felt that this had to be treated, water reuse had to be treated more as a public health issue to ensure that those standards and guidelines were properly issued by the relevant health authorities. In other words, we believe that they will have the overarching responsibility, whilst the Environmental Protection Department will work very closely with the Ministry of Health to be able to execute the responsibilities under the bill. Barbados Water Authority, sir, we're responsible for the management and the allocation and the monitoring of the island's water resources, a huge responsibility. We also obviously have 2 sewage treatment plants that this legislation will directly impact us as well in terms of our own regulation, and therefore that is why we have been included also. We also had contributions from the Barbados National Standards Institute, who is responsible for the preparation of standards and quality controls. And why them, sir? Because we had to take a look at the plumbing code, we had to look at the standards that were necessary for people when they are piping in relation to wastewater treatment plants, and generally to be able to have a cohesive system that allows for people to know whether they are doing color coding or whether they're doing the straight coding, to be able to prepare ourselves to allow this piece of legislation to be implemented. Each of the technical teams, therefore, have had that opportunity to weigh in on the framework for the water reuse policy. And in turn, they've been able to participate in exchanging ideas, and they've also in turn been able to help us with the drafting of the water reuse bill. So between 2019 and now, again, you can say that this has taken a little while, but I will contextualize it as I have to do on many occasions when we realize how much time we've lost as a result of COVID. Obviously, attention was somewhat diverted in relation to the COVID outbreak. And so the frequency of those meetings, sir, since 2019 were not as sustained as we would have hoped. But the elements of the policy remain the same, and it was very easy to pick back up the discussions once we were able to meet again, both face-to-face and in the online environment. The policy, though, the water use policy, was able to take a look at the types of uses for reclaimed water. It recognized that the types of uses could either be portable or it could be non-portable. It recognized that reclaimed water can be used for urban reuse, it could be used for industrial, agricultural, environmental and recreational, groundwater recharge, and it can also be used to augment portable water supplies. When we talk about urban reuse, sir, we're speaking about using this water to irrigate, for instance, public spaces, public parks, golf courses. Using it, which is, again, we've already heard, that is what it had actually been used for in terms of the drip irrigation system. So there's no issue there. Vehicle washing, again, ensuring that you're able to reuse water to be able to wash vehicles as opposed to using portable or drinking water. And this water can obviously be used to wash down the schools, it can be used to wash down playing fields, to control dust and concrete, the dust from concrete, and certainly in relation to construction projects. As it relates to industrial reuse, we're speaking specifically about water that can be used to cool down systems, to cool down equipment. It's part of in many cases, the part of the industrial process. Oftentimes you have to pre-treat the water to improve the quality of it in order to prevent either the product being contaminated or the equipment being damaged as a result of specific contaminants. Again, the issues with agricultural use for reclaimed water. Agriculture is the second largest user of water, and certainly with the expansion of the agricultural sector, I think we are all across the world, sir, looking at opportunities to be able to find other methods to be able to allow farmers to have access to treated water, to be able to allow them not to have to rely on the portable water supply. Obviously, there is a benefit, and I'm sure that the Minister of Agriculture, when he speaks, will go into much more detail, but the truth is that obviously there are nutrients in terms of the nitrates and the phosphates that are contained in agricultural water use, or the offshoots from agricultural water, which can serve to not only irrigate our fields, but it can also provide a level of nutrients to the crops as well. The other use relates to environmental and recreational uses. Again, this speaks to the wetland enhancement, looking at creation of wetlands and to be able to preserve wildlife habitats. Then you also have groundwater recharge, which can be used to establish saltwater intrusion barriers in coastal aquifers, can be used to augment portable and non-portable aquifers, and to provide the storage of reclaimed water for subsequent retrieval and reuse. And finally, the other use that was identified in the water reuse policy was one for augmentation of the portable water supply system. And this would entail treating the wastewater with surface and or groundwater, and then the mixture would receive additional treatment before entering the water distribution system. This, however, obviously requires further studies. It is not perhaps the first thing on our agenda, but the truth of the matter is we have had to look at all of the different uses that can come from reclaimed water. And of course, with the help of the technical team and certainly the international technical expertise, we will be able to have a certain set of standards that will govern if we are ever to go in these directions. Sir, this bill has had also input from a number of my predecessors. I think all of my predecessors who have been responsible in some way for water. The Honourable Member for Christchurch East, the Honourable Member for Christchurch West Central, the Honourable Member for St. Michael West Central. It has also had input from the Honourable Member for St. Michael South Central, who would have been the Minister in the Ministry of Economic Affairs and Investment at the time, and who would have had direct responsibility for planning. And I would want to thank them, sir, for their leadership as well in serving on the various committees, both at the subcommittee level of Cabinet, but also they would have had to participate, no doubt, in the discussions with the technical teams and the technical subcommittee. And so I would want to thank them, because this is not an effort that has gotten here certainly through me alone or the Parliamentary Secretary and Member for St. Andrew, but it has gotten here by the effort of all of the persons who would have contributed in some way to the drafting of this particular bill. The bill in 2019, when it came to Cabinet, it was felt a number of the details that were in the original water reuse policy would have made recommendations that we would have to set up an interministerial committee to be able to continue to drill down on the bill, to give us ourselves a time frame within which to be able to roll out a public education and sensitization campaign, to look at the standards as it related to plumbing codes. And so while anxious to get the bill rolled out, at the same time, it was clear that there still needed to be a parallel track that was running to be able to ensure that we were able to bring the legislation while at the same time having a technical committee to continue to, in a sense, just shepherd the process and the implementation of the bill. The Ministry of the Environment back then would have been tasked with looking at the capacity of both their government analytical services as well as the Dos Santos Public Health Laboratory, and to make recommendations as it related to the labs and the lab capacity, to look at how they could improve the processes in relation to environmental samples, conducting analyses of the soils and the water and also the air. So we had extensive discussions at the level of the ministerial subcommittee as well as the technical committee. As I said before, COVID would have delayed a number of the actions that perhaps needed to be taken. When we met, however, I think it would have been close to around the end of 2021. We were about to bring the bill to Parliament, and then we were on the eve of a general election, and there was cause for pause as a result of that. Certainly on assuming responsibility for the ministry, we took another look at the bill, myself and the Honourable Member for St. Andrew, and with the assistance of the technical committee, we were able to recognize that even if the bill had been passed then, that there were still a few more things that we needed to do in order to ensure that there was full implementation. We invited the BNSI, Barbados National Standards Institute, to be part of the rainwater harvesting technical working group. And this was a committee that was chaired by the technical advisor to the Barbados Water Authority, Dr. John Mwanza. The initial estimate that was given by BNSA, my colleague to my right would appreciate the journey that we have taken on this. We were shocked when we had our first meetings, which indicated that these standards for plumbing would actually take us almost 2 years. And I think you can understand that we all felt that this was a race against time in terms of being able to get this turned around quickly. And I would really want to express sincere thanks not only to my colleague minister, but also to BNSA and to that technical team for being able to come up with a solution that would allow us to work towards the National Plumbing Code, but also as an interim measure to be able to look at alternatives to help us to operationalize this legislation once it is passed. The meeting that we would have held, I think it was around April of 2022, we looked at the relevant international standards which had already been published across the world, and in order to reference them to determine whether they could be used as a technical regulation in support of the water reuse legislation. Sir, it should be mentioned here, though, that at one point we were even looking at using a British standard for pipe marking, known as BS 1710, but the standard was not found to be adequate for what we were proposing to do. And the committee went back again into consultation. Sir, I want you to appreciate that this was a process, as I said, they told us it would take 2 years. But this committee, understanding the urgency of bringing this particular bill, met not once every 3 months, but I think they probably met probably every 2 weeks or so to be able to find a way and a solution to the challenges that we were facing in terms of the National Plumbing Code. It was determined that the International Code Council, or ICC Plumbing Code, Chapter 12, non-potable water, and the ICC International Residential Plumbing Code, Chapter 29, water supply and distribution, should be used as a frame of reference by plumbers while the Plumbing Code Technical Committee was working on the National Plumbing Code. Let me just say, sir, that while the committee continues to work on the National Plumbing Code, we found that solution to be able to allow this bill to be operationalized. What does that mean, sir? It means that work still has to continue, but it means that by putting all of our minds together, we were able to find a solution in the interim which reflected what the National Plumbing Code obviously will end up looking like. So we've borrowed something, but with the intention, no doubt, that we will tweak it and fine-tune it to make it relevant to Barbados as well. One of the things that came out of our discussions in the committee was also that we wanted to be in a position to anticipate the passage of the legislation, and we started discussions with the tertiary institutions, in particular the Samuel Jackman Prescott Institute of Technology. And one of the things that we have been working with BWA and them on is trying to look at the course, the syllabus for plumbers to ensure that what is being taught now is basically keeping in line with what is being proposed by this legislation and what is to come in relation to the new plumbing code. So a number of the persons will obviously be introduced to the dual plumbing system, and certainly, Barbados Water Authority has lots of work to do over the next few months in relation to the installation of water tanks and other systems, and I know that there will certainly be a demand for plumbers both in-house and on the outside. And so it is our hope that by strengthening this legislation, but also starting that process a few months ago to alert the SJPI of what was intended, that they too were able to prepare for what we expect to come in the near future in relation to persons who have been trained. Sir, before I get into the bill though, I'm sorry the AG is not next to me, but I want to also say before I start to look at the framework of the legislation that about 2 weeks ago, we called a meeting at Parliament with the Prime Minister. We sat and we worked along with the technical committee and one of the officers from the SG's chambers. And I, again, will call the name, sir, with your permission, only because I think it is important to recognize when people go beyond the call of duty to ensure that we are able to get our job done and done effectively. There would have been persons who would have started the process of the drafting of the bill, and I give full kudos to those persons. But we were put under pressure to be able to get the bill here for debate, and Ms. Michelle Eli was able to, from CPC, was able to provide the necessary assistance. So much so, sir, and I really want to say this because, I can be critical sometimes of things when things go wrong, but I must say that this young lady even sent messages on Mother's Day. She wished us Happy Mother's Day, and then in the next breath, she was asking for comments from all of the staff that were attached to the email. And I say that, sir, I don't know if she's a mother. I haven't had the opportunity to ask her this, but it speaks to a certain commitment and a dedication, certainly to be able to help this government to be able to achieve its agenda. It's not always easy because we put everybody under pressure sometimes, but I can say I truly appreciated the fact that she was new in terms of a new pair of eyes to the bill, but she was able to go above the call of duty, and I would want to thank her on behalf of all of the members of the technical committee for rising to the occasion. That is not to say that it was not shepherded by the Honourable AG, a member of St. Joseph, but simply to say that sometimes you have to recognize officers where they have really assisted us. So, sir, the elements of the water reuse bill. For me, this bill marks the culmination of input from all of the ministries who have collaborated. It has, as I said, after much discussion, we have identified the Ministry of Health as the entity or the responsible agency for the bill. I've been tasked today with introducing the bill, sir, not because it falls on the Barbados Water Authority, but the truth is the Barbados Water Authority stands to gain significantly from its introduction. And I say that, sir, because the reuse of water will have a direct impact on the demand for our potable water supply at the Barbados Water Authority, as there are clearly several uses that can be derived from being able to reuse water. And therefore, it takes the pressure, the added burden off of the Barbados Water Authority if we are able to encourage persons, investors, businesses, individuals to be able to follow a particular regulatory framework in order to help to ease some of the pressure that we have, sir. In other words, my hope is that in future we will not have to come and prohibit anybody from washing cars or washing down driveways with potable water, because they will either have their tanks or they will have wastewater treatment plants affixed to their businesses or their homes, and therefore they will be in a position where they will take that burden off of us, sir. The Water Reuse Bill therefore provides the necessary legislation which is needed to manage and to control water reuse in Barbados. The Act's administration, as I said earlier, falls under the minister responsible for health. The minister can delegate his functions under the Act to any of the public officers as he considers appropriate, except his power to amend the schedule to the Act. And that schedule deals with the composition of what is referred to as a water reuse committee. And I'll come back to this later. It also allows for the minister to have the power to make regulations, to operationalize the legislation. And as I said earlier, regulations have become even more critically important in recent times because of the neglect that has taken place in trying to get them done as quickly as possible after bills are passed. It is envisaged at Section 4.2 of the bill that the minister will delegate to the permanent secretary or to the chief medical officer his functions in respect of wastewater treatment permits, including the issuance, the registration, amendment, suspension, and revocation of such permits. The minister can also give directions of a general nature as to the policy to be followed. So in other words, the policy that has been set out in the water reuse policy document, which has been approved by cabinet, gives the minister responsible for this the general guidance as to the framework that government has in terms of its expectations as to how the bill will be operationalized. And of course, the minister is responsible for ensuring that there is the relevant compliance as well with the policy direction. The first key point, though, that this legislation, that I want to make in relation to this legislation is that it states very clearly that no person shall sell or otherwise supply reclaimed water to another without a permit. And that is a permit that is issued to him by the minister. This permit is referred to in the legislation as a wastewater permit. And at Section 13, it sets out the types of wastewater for use in treatment plants. So you can either have agricultural, industrial, domestic, or surface runoff. Section 14 of the legislation deals with the uses of reclaimed water or non-potable water. It sets out 10 things which can be done, namely the flushing of water closets, cleaning outdoor surfaces, watering or irrigating edible crops, household gardens, ornamental plants and trees and green spaces, the cleaning of animal pens, the coos or holding areas, flushing and cooling equipment, filling surface ponds or lakes, recharging the groundwater, and other similar purposes. So that last part is more or less a catch-all provision. But the bill very clearly sets out the types of uses that are expected or anticipated that we will use as a country in relation to reclaimed water. And again, I refer to water that you are not drinking, sir, okay? In order to activate the process, an applicant will have to submit the application on an approved form and pay the prescribed fee. The applicant will also be required to submit such information as may be required by the minister to determine whether a permit should be issued. So once this process has been followed, the application is then submitted to what is referred to as the Water Reuse Committee. And that is referred to the committee by the minister for further consideration. So just 2 minutes on that, sir. Again, in recognition that the minister, and I think there are very few in here, perhaps apart from the Minister for the Environment that is very technical, I don't think most of us are. And therefore, this particular legislation recognizes that while as a formality, the application goes to the minister will refer the application to the technical committee for further consideration of the application, and then that committee will obviously review the application and make certain determinations and recommendations to the actual minister. The committee, sir, is established at Section 5 of the bill, and the schedule to the bill actually contains the composition of that committee. You will note that the committee comprises the following technical persons or their nominee. So it is either the permanent secretary in the Ministry of Health and Wellness, the chief medical officer, director of EPD, Environmental Protection Department, the Solicitor General, the director of the Coastal Zone Management, the chief agricultural officer, the director of analytical services, the director of planning and development, or their nominees. So either of those, in a sense, figureheads of any of these respective agencies will serve on this committee, which is the Water Reuse Committee. The bill provides that the CMO will be the deputy chairman, And the chairman of the committee is the PS in the Ministry of Health and Wellness or his nominee. Now, bear in mind, sir, we had much discussion on this, and we recognize, obviously, that within ministries, you will have PSs, you will have DPSs, and obviously the work can be delegated to other persons. Similarly, with the chief medical officer, he may not be the person who always attends the meetings, but obviously he has the power to be able to delegate to persons to attend on his behalf and report to him as to the progress of the work of the committee. The functions of the committee are also very, very clear and very clearly laid out within the bill. At section 6, which sets out the functions are wide-ranging, and primarily this committee determines the suitability of an application, or in some cases where there is continuity of an existing wastewater treatment permit, that committee will make a determination as to whether that permit ought to be renewed or whether there are conditions that need to be further attached to that particular permit. The functions of the committee, therefore, include looking at consideration and recommendations to be made to the minister on the application of any wastewater treatment permit, determining the suitability of the premises and the structures on the premises. So basically, visiting the sites and being able to have an understanding of exactly what is being planned, if it is a proposed development, or if it is an existing development, being able to identify whether the structures that already exist are consistent with, no doubt, the regulations that will follow in relation to what is expected of these plants. The committee is also required to monitor each of the permit holders to determine whether they are operating in compliance with the Act, as well as the terms and the conditions associated to the permit. The committee is also required to inquire into any complaint which is made against a permit holder. And sir, I think, sir, I think this is quite key, sir, because, you know, sometimes we hear the complaints that sometimes legislation does not provide for complaints to be made. But because this is such a piece of legislation that is of a serious nature, that it has an impact on public health, there has to be a carve-out provision to allow persons who have concerns to be able to express those concerns by being able to take those concerns to a technical committee who can understand what their concerns may be, and to be able to make recommendations to the minister if he or she needs to take any specific type of action. And lastly, sir, the other primary function of the committee is to make recommendations on the suspension or revocation of a wastewater treatment permit. Put simply, it is not, while the power is for the minister to sign off on, the recommendation must come from the technical committee that has been set up under the Water Reuse Committee to give the advice and the guidance to that minister in order to make any decision. Generally, the bill provides for the powers of the committee and what they can do when they are considering an application. So once you apply in the form that has been prescribed, and it's been referred to the minister, and the minister refers it to the Wastewater Reuse Committee, immediately that starts a process where, depending on the nature of the application, the members of the committee can summon persons to appear before the committee in order to answer questions or to produce reports or any other documents with respect to the application. They can require a person to produce a report or any other document if they believe that it can contain information relevant to the application. And they can also take, and this is also very important, they can take and they can keep a copy of the report or the document in their possession. In other words, anything that they believe is going to help them to make a better decision in relation to the application. They can also either ask the applicant questions or they can put those questions in writing with respect to the premises that are the subject of the permit and any other matter that they may wish to clarify. The bill allows for them to be able to take the necessary steps to either invite the applicant in or in some cases to be able to write and set out very clearly in writing what is required by the committee. They can require a person to appear before the committee to answer questions or to produce documents with respect to any complaint which has been made against the permit holder. The committee also has some other powers, and at section 6.2, The bill envisages that before any recommendation is made to the minister regarding an application, that an inspection of the premises shall be made. And again, I want to repeat, before a decision can be made, there has to be an inspection that is made of the premises. So this is no fly-by-night piece of legislation. It is the minister has power, but in a sense, the minister is also powerless because he has to take direction at all stages from the technical committee. The bill defines an inspector as being either the CMO, the Director of EPD, Environmental Protection Department, or such other public officers as the CMO or the Director of EPD may authorize to inspect the premises. So while the term inspector in the bill refers to CMO and the Director of EPD or such other public officer, the reality is that the EPD may be authorized to conduct an inspection under the bill because of the specific powers that are also granted herein. And the reason for this, sir, is because obviously the Environmental Protection Department already carries out these inspections. And again, while the legislation seeks to place the regulatory framework and responsibility for the bill with the Ministry of Health, we wanted to recognize the fact that EPD is already carrying out this very important function and therefore needs not just a delegation of authority in order to continue to do what it already does. At Section 4.4 of the bill, the Environmental Protection Department, it says, will be responsible for the inspection of wastewater treatment plants or premises. They will be expected to visit the sites in order to determine the suitability, and as the case may be, if they're already in existence, they will look at their continued suitability for producing reclaimed water for sale or other supply. The Environmental Protection Department will also be responsible for monitoring the impact of the operation of the plant on the environment. So again, we have captured overarching responsibilities, but we've also captured within the bill very specific responsibilities as it relates to the Environmental Protection Department. The Act also sets out very clear timelines for the submission of the report from the person who is carrying out the inspection. So again, given that this is a very sensitive issue in terms of if there's a public health concern, Section 19 of the bill provides that within 21 days, the inspector shall submit to the minister a written report on the findings of that inspection. Section 19.1 sets out the items which must be contained in the report. It must therefore contain the date and the time of the inspection, and if it relates to an application for a permit, then he must provide the recommendation with respect to the issuance of the permit and state whether the premises meet the requirements for a permit to be issued. The report must also state if the findings are that the premises are deficient, and if so, then it must contain guidance as to the measures which the applicant must then take to rectify the deficiencies and the date of any proposed re-inspection. So, sir, you will find that throughout this bill, while there is power to revoke if there's a public health issue, the bill still allows for people to correct their wrongs as quickly as possible. And therefore, no decision can be taken unless that inspection is carried out, unless the applicants are actually notified of the concern and an opportunity given for them to also correct whatever has been highlighted. Where the inspection, though, relates to a permit that has already been issued, the inspector must state in his report whether the permit holder is acting in compliance with the Act, as well as the terms and conditions of his permit. If the permit holder is not in compliance, then the report has to state which provisions in the terms and conditions of the permit have been contravened. It has to state the nature of the contravention, the measures that must be taken to rectify the contravention, and the date by which compliance is expected. It must also state the proposed date for reinspection to reassess compliance, and a recommendation can be made as to whether the permit should be suspended or revoked. And the bill also makes provision for the inspector to provide in the report evidence of the findings from its inspection. So again, what is anticipated is if they have carried out tests, if they've done any other investigation samples taken, then that also will be attached to any recommendation coming out of their particular inspection. Once an inspection has been carried out in respect of an application or an existing permit holder, Section 19.3 provides that the inspector has to provide a written summary of the report. Again, a very important point, because a lot of times we verbalize what may be wrong, but the legislation provides that you have to put in writing what your findings are in relation to any inspection. And that report has to contain the date of the inspection, the assessments of whether the premises meet the issuance of a permit, any deficiencies highlighted, the date the action was taken to correct them, and if the permission has already been issued, particulars of any contravention should be in the report, along with the measures to rectify and the date for reinspection, etc. This gives persons, again, an opportunity to know the case that is being made against them, but more importantly, to give them sufficient time to correct that deficiency. The inspectors, sir, have wide powers as they help the committee to really determine the applications, as well as to determine if persons have rectified the concerns which were highlighted. And essentially, I would have to say that they are really at the forefront of allowing the technical committee to make decisions as to compliance with the bill. The bill gives them powers to enter premises. And let me just say, it gives them powers to do a number of things, first of all. They can enter the premises, they can go on any private road that is connected with the premises, they can carry out a search, they can stop and search a vehicle that is used to transport wastewater or reclaimed water. They can conduct surveys, examinations, investigations, or other studies, as well as to take samples and make copies of any documents, take photos. Basically, the powers are wide-ranging. And again, I want to reiterate that this is a very serious piece of legislation, because of if anything goes wrong in terms of the public health concerns, we are trying to make sure that all steps are taken to guard the public against anything that can take place. An inspector must, prior to the inspection of premises or vehicles, he has to identify himself, and this is a common provision across most other pieces of legislation. Just as a police officer has to identify himself, the inspector has to identify himself by showing his identification. If the situation so merits, the inspector can be accompanied and assisted by a member of the Royal Barbados Police Service, or by an expert who is appointed to assist the committee, or both. And just to speak a little bit to this expert, sir, you will notice that the bill, in addition to giving the support with the law enforcement, also allows the committee to be able to appoint an expert. That expert doesn't have to be a public officer. It is indeed not a public officer, but it can be, again, an independent consultant, somebody who is an expert in their particular field, who can provide assistance to the committee. And again, that person has to be appointed in writing, so the committee has to indicate in writing, and obviously I think that is also intended that if that individual goes along with the police to a plant and they have to produce identification, they can show certification by way of a written document that allows the person to know that they have been given the authority to be in their presence and to ask the necessary questions. The expert can be used to assist the inspector to assess an application for a wastewater treatment permit and to monitor a permit holder to determine if he's in compliance with the Act. Again, I suspect, sir, that given, and I'm sure the Minister will speak to this, but EPD is already stretched in terms of human resources and human resource capacity, as are most other government departments. And therefore, I think this allows for the outsourcing of persons to be able to help to perform functions which would help to, in a sense, deal with any backlogs, but also deal with any applications that are obviously needing to be dealt with as quickly as possible. So provision is made in the legislation for the outsourcing of services to support the work of the inspectors and in turn the work of the committee. What happens though after an investigation takes place? Well, basically, Section 10.2 provides that once the committee has received the report or any other information, it requires to make a decision. It can do one of three things. It can either recommend to the minister either that the wastewater treatment permit be issued, so the person gets the permit, they will pay the prescribed fee, and they're good to go. It can also recommend that consideration of the application be suspended until any matter which is identified by the committee as requiring rectification is addressed to the satisfaction of the committee. Or thirdly, it can refuse the application outright. If the committee recommends suspension until any matter is rectified, the minister has to notify the applicant in writing as to what must be done for him to meet the conditions of the permit. If it is refused, the minister sends notification of the refusal, and more importantly, has to send the reasons for the decision as well for the refusal. Section 21 sets out the circumstances under which a recommendation can be made for suspension or revocation by the committee. So for example, where the permit holder fails or he refuses to comply with the act, the terms and conditions of his permit, or any request which has been made, or any direction given in writing, or where he has been convicted of an offense under the act, or if he has altered the operation of the wastewater treatment permit in such a manner that he no longer qualifies for the wastewater treatment permit in respect of the plan. And finally, it can be revoked or suspended if there is a direct or an indirect danger to the health or the safety of persons from the use of reclaimed water from the wastewater treatment plant. And the relevant notifications would obviously have to be issued by the Ministry of Health in relation to relevant provisions under the Health and Safety Act and the Health at Work Act as well, or any other enactment for that matter. Again, the bill does not allow for suspension or revocation without written notice of the reason for the intended suspension being given to the permit holder. So it permits, where appropriate, for a further period of time to be given to the permit holder to, in many cases, rectify any of the breaches, and it also gives about 10 days from the date of the notice for any for him to make representations as to why the permit should not be suspended or revoked, as the case may be. If, however, the permit holder does not rectify the specific concerns which have been raised and provide a suitable explanation, the minister, on the recommendation of the committee, can suspend or revoke the permit. Where the minister acts in that way, and justifiably so, he has to give notice of the suspension or revocation and cause notice of the suspension and the period of the suspension to be published in the official gazette. So again, this bill is not intended to hide anything, and I will come to that later, because all of the wastewater treatment plants also have to be published in the official gazette as well. But in particular, any notice of revocation or suspension will also be published within the official gazette. One very important power that the bill contains relating to the minister is the section which allows for the power to revoke or suspend a permit with immediate effect. So basically, no notice, no giving them time to correct anything. But where they believe that there is a direct or indirect risk to health and the safety of persons from the reclaimed water or from the treatment plant, immediately the minister, acting on the advice of the committee, can basically do the full revocation or suspension. The bill also addresses situations where persons have been warned to rectify a particular breach and fails to do so. Section 20 provides that if an inspection reveals an area of concern which was the subject of a prior request for rectification, the minister may, on the recommendation of the committee, first of all, issue a written warning to the permit holder requiring that the area of concern be rectified within a specific period. The warning, again, will contain the area of concern, give details of any prior written request for rectification. So again, it is telling the person, we have been trying to tell you to correct this deficiency for the last 6 months, last 6 weeks, and therefore you need to act now, otherwise there are going to be consequences. It also requires the date on which they need to comply by to also be included as well within the within the legislation. Sir, you know, it's funny that we have to get to a point where we have to say, expressly set out these things, that there must not only be notice, but these particularize all of the details that must be embodied in a document which goes to somebody. And perhaps this would be good examples for perhaps other ministries as well to take heed of, because we have come to that point where we have to document every single thing. And it is important that there's certain standards across the board, that people understand that times matters, dates matter, giving people a time to respond by a specific date, and of course they follow through to figure out whether they have in fact complied with the request that has been made. The wastewater treatment permit, once it is granted, the permit is subject to the terms and conditions of the minister as recommended by the committee. It is not transferable, so you can't obtain the treatment permit and then decide that you're giving it to your neighbor. It is obviously relative to the individual or the entity who has applied. It is valid for a period of 2 years, and it can be renewed on a further application at least 1 month prior to the expiration of the permit. What is particularly important is that while you reapply prior to the expiration of the month, the inspector under the bill can carry out a further re-inspection of the plant. And that is particularly important because, in a sense, it gives a 2-year kind of a gratis period or grace period where persons will be able to operate once the permission has been granted. But it also appreciates that you cannot leave people open-ended to do as they like. And therefore, what we have to focus on, certainly as a government, is to make sure that we have the adequate resources to be able to operationalize this component, because it will mean if we were at 69 or so back in 2018, we may perhaps have a couple more by now, and therefore, if there are more entrants into the market, we're going to have a system for being able to review the applications over a period of time. Permit holders are required to display, they may display, the legislation doesn't say shall. So unlike in a transport vehicle, a public transport vehicle where you have to display the permit, the requirement here is that the person may display a copy of the wastewater treatment permit, and they can put it in a conspicuous place on the premises. If, however, you don't display it, and then the inspector comes to the premises and asks to see it, you better have it available to show proof that you have it. So it places the onus on the individual to ensure that they have access to this document if at any point the inspectors visit the premises or the expert visits the premises and requests this information, or the police visits the premises and requests the information. And just to say, sir, it doesn't take away, and I'll come to it later, but it doesn't take away, this may, in the wording of the legislation, does not take away from the fact that all of the wastewater treatment plants in Barbados will be registered and published by way of the official gazette. So everybody can see it, and there's therefore nothing to hide. And therefore, I want that this be understood in the context in which it is written. But you do have a responsibility to produce in the event that you are stopped and asked for it. In the event that, having been issued the permit, there are amendments to be made, Section 12 provides that the minister can amend the permit to reflect a change in name, address, other particulars of the permit holder, or he can alter the terms and conditions of the permit. It provides as well that where the terms and conditions of the permit are to be altered, he cannot do so, though, unless he has given the permit holder notice in writing of the intended changes and the reasons for it. And this, therefore, is an opportunity that has to be given to the individual to make representations in relation thereto. I think this has been the general theme of this bill, where you are being heavy-handed in terms of setting certain conditions, but you are still giving people an opportunity to be heard, to know what the case is against them, which are obviously basic principles of natural justice, Mr. Speaker, as you're well aware. But again, it has been incorporated into the legislation, I think, for clarity, so that there is no accusation that somebody had their plant shut down without knowing the case against them or the reasons for the decision being made. There is a requirement in the bill as well for the wastewater register. So separate and apart from the publication in the official gazette of the entities that on an annual basis have been granted the permit, one of the key provisions relates to this register, which, as I said, is the wastewater register. It must contain the following particulars in relation to the wastewater treatment permit, including the name and address and the contact information of each permit holder. If the permit holder is a company, then it has to include the registration number, the registered business address, and the names of the directors of the company. It must include the number that has been assigned to the permit and the date and issue and expiration of the permit. It must also include any amendments that have been made as well to the permit and any revocation of the permit that may have taken place, as well as the date of revocation. As it relates to, again, further operationalizing the Act, no, there's not everything, as you can appreciate, that can be placed in legislation. Even with all best efforts, the fact that we have regulations which then, and I know that the various technical members of the committee have had the opportunity to work together to start the drafting, and I believe there are draft regulations in place that will come in due course now that we've made the changes to who is responsible for the operationalization of the bill. But the fundamental thing, Mr. Speaker, is that the regulations are intended to help us to understand better how the process is going to work. And so the bill at Section 28 provides that the minister will be able to issue regulations that address the standards of treatment which are to be applied in relation to reclaimed water, whether it is for sale or it's for supply to other persons. This is very important, sir, because, as we said, different types of water and wastewater requires different levels of treatment depending on what the intended purpose is going to be for. And so there must be standards, there must be a way for the Environmental Protection Department and the Ministry of Health to be able to test, but there also must be a standard by which persons who are applying know that they must obviously meet and also maintain. The regulations will also address standards for the treatment of wastewater to be used in the operation of a wastewater treatment plant, otherwise than directly to obtain reclaimed water for sale or other supply. It will also speak to the mechanisms and the standards to be applied in relation to the management of reclaimed water. It will also address the tests which are to be conducted by the permit holder, as well as the form and the procedure for the submission of test results and related information. And of course, the regulations must address safety operating procedures because that is going to be critical in respect of any plant that is established on the island. The regulations will also speak to the forms and the types of training and certification which a permit holder must ensure exists amongst its employees. It will also address the fees to be paid, sir. And just to say a little bit on that, I know when we had our very last meeting, the Ministry of Health and the others were tasked with looking at comparative fees, not just here, but in other jurisdictions, because obviously this is a very intensive set of work that will have to be carried out by inspectors and certainly by the committee. And therefore, I think the fees have to address the amount of work and the serious nature of the work that has to go into dealing with this. And so they will be looking at the fees in due course to be able to determine the scale of fees, whether it will be the same fee for residential as it will be for commercial, whether it will be the same for small properties as for larger properties, et cetera, et cetera. And also, of course, the renewal fees, looking at whether that particular fee will obviously be higher or lower as the case may be, since you are simply reapplying. And of course, the catch-all provision for the making of regulations, that the minister can make any regulations that will give effect to the legislation. Another key element, Mr. Speaker, in this particular legislation is the issue of offenses. There are a number of offenses that are created by virtue of non-compliance by the permit holders. First of all, where a person without a wastewater treatment permit sells or otherwise supplies reclaimed water to another person. that is an offense that is created because you must have a wastewater treatment permit with the terms and conditions clearly set out. So an offense has been created as a result of that. Where the person makes available or misrepresents that reclaimed water that they have produced is non-portable and is fit for human consumption. So it is not fit for human consumption, but they are misrepresenting to the public that it is. And for that, an offense is created by making that misleading or misrepresenting that statement and leading persons to believe that it is something which it is not. An offense is also created where a person uses non-portable water as portable water in a manner that could endanger public health or safety, or where they use black water to water, to irrigate, or to treat edible crops which are to be sold or otherwise supplied for human consumption. So again, black water is actually wastewater that includes urine or human excrement with paper or both, okay? So again, today is another learning exercise for my colleagues and I think for all Barbados. You've heard about the gray water, you heard about black water, there's something called yellow water, so gray water, yes. But the penalty on summary conviction for any of those offenses is a fine of $500,000 or imprisonment for 10 years or both. There are offenses also created under the bill which indicate the seriousness with which we must treat to our inspectors, just as we would to somebody obstructing a police officer in the execution of his duty. The bill also creates offenses where either the inspector or the expert is obstructed in the performance of their duties. For instance, where the person knowingly provides false or misleading information in connection with the application for the wastewater treatment permit or an inspection, or if they contravene Section 15.2 of the bill, which is a section which permits or permits or otherwise supply reclaimed water. They must maintain a register of the name, the address, and the contact information of each person to whom the reclaimed water is supplied. So again, these are more administrative matters, but the bill addresses this in a way which treats to the level of seriousness and the onus that is placed on the owners of the wastewater treatment plants to basically provide information to the general public. They must also look at the volume of the reclaimed water that is supplied to the persons, the purpose for which the person intends to use the reclaimed water, the date of the supply, and such other information that may be required for the purposes of the Act. Failure to provide or to obstruct the officer in the execution of his duties under this section renders a person liable on summary conviction to a fine of $50,000 or to imprisonment of 5 years or both. There are also penalties for breaches of the regulations. These will carry a penalty of a fine of $50,000 or imprisonment for 5 years or both on summary conviction in respect of the offenses. And then we also have introduced into this legislation, which has been creeping into quite a bit of late, administrative penalties, things which are intended to not necessarily drag you before the court, but to fine you and to really hit where I guess it hurts the most in terms of the financial penalty that is associated with the administrative penalty. So at Section 26, again, if you contravene the legislation or term or condition of the wastewater treatment permit, fail to maintain adequate and accurate records on the operations of the wastewater treatment plant, or if you fail to provide reports or other documents when requested to provide them by the inspectors, this constitutes an offense, and the minister can impose on the permit holder an administrative penalty of $5,000. If the permit holder has to take measures by a specified date to rectify an area of concern which has been identified pursuant to an inspection, or if he contravenes Section 26(1), the minister is satisfied On the advice of the committee that the permit holder has failed to take the measures, the minister may then impose on the permit holder, in addition to the penalty specified in that subsection, an administrative penalty of $500 for every day or part of a day that the permit holder fails to take the measure, the appropriate measure. The administrative penalty can be imposed from the day following the date by which the permit holder was required to have taken the measures, and it shall not be imposed in respect of a period of more than 30 days. So there is actually a period of time, a maximum period of time by which it is imposed. But it certainly will send the message to those who are operators, once properly enforced, that this is obviously to be treated very seriously in terms of information that ought to be provided, and that is provided within the time frame that it has been requested. Similar provisions exist in relation to the issue of penalties because, again, notice must be given to the person. They must be given an opportunity to pay the penalty. They must be given notice of what the precise nature of the act is that they are accused of breaching. So at every juncture of the bill, the focus has been, again, on making sure that people have an opportunity to be told what the offenses are and have an opportunity to correct them before the heavy weight of the law comes down on them. The Act not only addresses those persons who operate without a permit, but it also expressly states within it that no person shall purchase or otherwise obtain reclaimed water from a wastewater treatment plant unless a permit has been issued in respect of the plant. So essentially, while we have seen the creation of offenses in relation to persons not or acting without a permit, persons who actually purchase it without asking the question whether you have a permit themselves have a responsibility under this legislation as well. So in summary, Mr. Speaker, this legislation introduces a number of things. It introduces a wastewater permit scheme. It establishes a technical wastewater committee. It introduces a formal application for applying for a wastewater treatment permit. It establishes the appropriate penalties to protect public and environmental health. It clearly sets out the rights and the responsibilities of the applicants, the committee, the minister, the inspectors, the appointed experts, and the users of reclaimed water. It enables a mechanism for complaints to be investigated, and it also establishes a wastewater register. The bill, therefore, sir, is a recognition that to reclaim and to reuse such sources of water on a wide scale, that you must have various control methods put in place in order to ensure that the activities are properly managed and controlled in order to protect public health, and that the public is adequately educated and aware of all of the issues that surround the need for the safe use of this area. The intention, sir, is to, over the course of the next few weeks and months, to have an intensive public education program. I think it has been a combined effort with EPD and the Barbados Water Authority. I know that the draft is certainly in its final stages, and this will complement the passage of the bill. Because these are, as you can appreciate, conversations, as I started in the outset by saying, that are not sexy subjects to talk about. They're not things that anybody wants to have conversations about. But they are our reality given the time that we are living in. And certainly we have a responsibility to educate from the youngest child to the oldest person what it is that we are speaking about when we speak about water reuse. Again, there's nothing for people to become alarmed by. I think this today is actually quite groundbreaking in the sense that we are actually creating this framework and actually putting it in legislation where we can go after persons in the event that there are breaches. And again, I'm not going to reduce the debate to which administration is responsible and which isn't. The timelines will show you that perhaps we've all presided over a period of time where the discussions have been taking place, because it started all the way back in 2005. And I'm sure if we check, the discussions may have been taking place even before then. I know that between 2008 and 2018, there would have been perhaps a lull in the sense that by 2019, we then had the first draft of the water reuse policy. But we have had to then accelerate the process to be able to get us to this point today. So, sir, I am hopeful that this piece of legislation will give certainly a different perspective to Barbadians as it relates to water reuse. Certainly from Barbados Water Authority's perspective, we have responsibility for 2 of Barbados's sewage treatment plants. They push out about 5 million gallons a day through 2 of our marine outfalls. And I think as the public is aware, they have been on the radar for tertiary treatment upgrade, and that is with a view to reclaiming the water and reusing it for groundwater recharge and irrigation. I can say to this chamber, sir, that with respect to the Bridgetown sewage treatment plant, we've sent out the request for the expression of interest for the design and the supervision consulting services for the upgrade of that plant. The deadline for submission of the tender is, I believe, the 2nd of June. And therefore, things are in motion as it relates to that aspect. As it relates to the South Coast upgrade, we had started some discussions early on. Of course, COVID took precedence over some of those discussions, but we have started to pick back up those discussions now, and we're trying to finalize negotiations to be able to upgrade that particular plant. So this legislation will obviously impact on the future plans of the Barbados Water Authority as it relates to its 2 plants, but it will more importantly, I believe, allow us a regulatory framework which will see a reduction on the reliance of portable water from the Barbados Water Authority's supply. And perhaps that is the part that excites me most, Mr. Speaker, because I know if my colleague from St. Peter was here, and I see the Honourable Member for St. Lucie as well, I know that the discussion, if this was a discussion strictly on water, that it would lead us to a conversation about brown water and the mains replacement program of the Barbados Water Authority, which they are rightfully within their power to ask about. And so I just want to say, for the purpose as I bring this particular introduction of this bill to a close, that while we are looking at water reuse, we are also dealing with the issues of mains replacement still. I think the record of the government has shown that we have started the process of mains replacement across the country. We've been successful to a large extent in being able to get adequate water supply in certainly the parishes of St. Joseph, St. John. We still have some teething issues, but I think in fairness to the Barbados Water Authority and to the government, we're a lot better off than we were 2 years ago, certainly in relation to issues related to water. And therefore, we continue to work on improving that. I am told, sir, that there's some work ongoing, I believe, in Crab Hill. So they've done about 27% of the 5 kilometers of mains replacement in that area. And that is expected to provide a significant improvement in that area. Again, we can't get to every single area to be able to improve the water supply all at once. One of the things that I think has to always be reinforced is that as we repair and replace the mains, we continue to get breakages. So I know the public sometimes get a little alarmed when they realize that we've done some work in a particular area, and then all of a sudden you see Barbados Water Authority, as the meme showed, peeping around the corner, trying to figure out how to dig back up a road. But sir, that is the nature, unfortunately, of having 100-year-old pipes across a system that was certainly not built for our generation, sir. It was built for a time when we had colonial masters. And therefore, the people who represented this country and ran this country did not look like us. So we don't have empires. We have a government that we have been given a wonderful opportunity to lead, sir, and one where we have to make the most of opportunities to get international financing to be able to help to repair our mains replacements program and to conduct our mains replacement program. But that is not an easy task in itself, because the rest of the world is also grappling with trying to get access to resources. Myself, the PS, and the technical team went to UN Water recently And again, you know, I must admit that when we spoke about Barbados and Barbados' situation, and we listened to other persons speaking about the conditions of water in their territories, Barbados was actually doing a lot better. We could speak of desalination. We could speak of our attempts to be able to do the mains replacement. We could speak of all of the reservoirs and the pumping stations, the standby generators, all of the things that we've invested in just the last 5 years, sir. And when I listen to people from the rest of the Caribbean, people across Europe, I felt good to some extent to know that even though there is disgruntlement at times, that we were still doing and performing way better than others. It does not mean that we sit on our laurels, sir, not by any stretch of the imagination, because that is not the nature of our people. We will always want more, and we will want to always punch above our weight. But I say that, sir, in all sincerity, that we have made significant strides in the last few years to bring relief to people across parishes of Barbados, in particular the northern parishes, and we will continue to do so, sir. And we will continue to do it because we don't like the fact that people are having to not be able to wash their clothes because the water is brown, or they cannot drink from the tap, sir. But we also are mindful that there are places in the world, and I remember having a conversation with, I think it was the minister from Israel, who alluded to the fact that he had struck a deal with Jordan in order to give them water. And while this seemed as such an achievement that they'd struck a negotiation, I certainly, sir, could not comprehend a situation where we were dependent on another country for water supply. And these are people who are practically on borders. So I say that, sir, to place in context where we are. We are still a small island developing state. We've been dealt a bad deal in the Barbados Water Authority's management by the previous administration. We've had to restructure debt, sir. We've had to renegotiate contracts, large, substantial contracts, jucking out the eyes and the ears and the noses of the taxpayers, sir. Resources that had been spent unnecessarily, which could have been put into making and expediting the process of people getting water a lot faster. We have had to do a lot in a short space of time, sir. As my colleague here reminds me, the issues of conservation. Nobody was talking about conservation. We're trying our best to educate from the youngest child to the oldest person in relation to conservation. There was an administration, sir, not so long ago that gave up contracts on the eve of an election, that didn't care about people in this country getting access to water. It didn't matter because it was about living off of the fatted calf, sir. We have had to come and try to renegotiate contract after contract, signed in the March of an election and 2 days before an election. Millions of dollars, sir. We should not have been in that position. So I get it when people talk about water and access to water. But the truth of the matter is that what we inherited, we've had to work with what we have inherited. And we're trying to get back on track. I think the trajectory is a good one. We have good people within the Water Authority, good technical people who understand what is needed. We're in the process of doing more restructuring to make the institution a lot more nimble, sir, that it is not as dependent on the state's resources as it currently is. But it is not going to come without a recognition that a lot of foolishness went on before we got here in 2018. And therefore, I am not one who going back in the past, but I like people to understand that we are not miracle workers. We have to work with what we have been given, and we are going to do the best job that we can in order to turn this country around. But let the record never show that this administration did not inherit a right mess as it related to the water supply and the water infrastructure in this country. We're going to be paying for generations for a building there in the Pines, sir. And I don't think y'all want me to start on that. But these are the realities, sir. Things that generations to come will be paying for. Contracts entered into in the dead of the night, sir. That is what we have had to deal with. Unfortunately, each of the ministers have had the opportunity to try to rework contracts and try to get ourselves out of these things. But it is costing the government. Because I think you can appreciate that a lot of these things were legally entered into, even if illegally done, they were legal in many cases because the contracts were signed. But they were, I can't say worthless. So that's not, that's unparliamentary. But sir, they were done, sir, and it is unfortunate. And therefore, when we speak of where we are now, we have a lot of work to do in Barbados Water Authority. I can say to you and to the country that we have found ourselves in a situation where we have, people have been responding in terms of paying off the arrears, but there's still more collections to be done. The reality is that Barbadians, we've said, you need to come forward and you need to enter into arrangements with the Barbados Water Authority. I am as patient as you can get, sir. But I do believe that that initial step to come and engage with the Water Authority is a necessary one. It is one that I encourage all my colleagues to encourage their constituents to do so that people understand where individuals are, what are the circumstances that they are encountering that may make it difficult for them to pay. What we will not encourage, sir, is a blatant disregard for the rules of the Barbados Water Authority, the payment system that has been set up, the concessions that have been granted by the Prime Minister in the budget, sir, to be able to give some kind of breathing space for people to come in and pay. We can't ignore that. So there will be a time coming, sir, and persons are put on notice that the Water Authority will have to do what it has to do to be able to collect money. But it will not be without the effort to get the public to come in and to engage with them to be able to enter into payment plans. We are not unreasonable, sir, but we simply ask that you come and address these issues frontally. Because you know when you don't tend to the foot and it start to get the gangrene, you know it's gonna get cut off. So similarly, if you don't come and you don't pay the bill, well, you know what's gonna happen. You're gonna get cut off. But we will not do so unless you come and you engage with us. Similar to the bill, sir. The bill gives you all of these opportunities to be able to explain yourself, to take corrective measures. But it's no different at the Barbados Water Authority. We're giving people the opportunity to correct the non-payments for all of this time. But the institution cannot run unless it is fed. And therefore, we need to have the money in order to be able to pay for what the expectations are of the general public as it relates to water and the expectations for water, sir. So as I close, sir, I think that we've had an overview in a sense of the legislation. As I said, this particular piece of legislation will certainly begin a transformation process that perhaps in some ways has already started, but now has a framework, and I look forward to being able to work with the respective ministries, EPD, Ministry of Health, along with the Barbados Water Authority, BNSA, to be able to complete what we have started. Along the way, we may have to tweak, and we will come back to this place if we have to. But I think that we have gotten to a point where we have a good starting point to be able to start to engage the general public on water reuse, certainly. Over the next few months, you will hear a lot about water conservation generally, because as I said, there are multiple approaches that we are taking. There's water reuse, there's desalination, we're looking at the mains replacements. We are doing everything to be able to try to conserve water and to get Barbadians to understand that the water got to come from somewhere, okay? And therefore that across the world, there are issues in relation to climate change that Barbados is not going to be left out of the equation for. And therefore we need to prepare ourselves and future generations to be able to deal with it. So with those few words, Mr. Speaker, I therefore move that this bill be read a second time.
Honourable Member for Christchurch, West Central.
Mr. Speaker, I want to first of all thank the honourable member who sat a couple seconds ago for being able to explain in a very limpid way the intricacies of the Water Reuse Act 2023. And I want to say, Mr. Speaker, that I would start by saying that I will try to be as translucent as the water that we are now getting in St. Lucie, in St. Thomas, in St. John, in St. Peter's, certain areas, in St. Andrew, of course, for the first time since 2018. And to say, first of all, Mr. Speaker, that this is revolutionary. But I need to ask certain questions so we can look at this water reuse in its true perspective. Why is it important? And why are we here discussing it? Those two questions must be answered, Mr. Speaker, if we are to do justice to this act. And I want to say, Mr. Speaker, we are here because of the vagaries of climate change. We are here, Mr. Speaker, because over the years, some may call it the lost years, where persons in St. Lucie were looking and still have not found the water that was lost somewhere. This, Mr. Speaker, is due to the fact that nothing was done over a period, a decade, where water conservation and water reuse should have been the focus of the day. That is why we are here. Why is it important, Mr. Speaker? It's important because we are experiencing, as I said, the ravages of climate change, which would see over a period of time of increased heat and temperatures, sometimes ranging between 0.16 degrees Celsius one day, and the next day you get flash flooding. Those are the types of idiosyncrasies that we are faced with in this new era. And Mr. Speaker, I want to say that Barbados is categorized amongst, it's supposed to be the 15th most water scarce country in the world. What does that mean? It means, Mr. Speaker, that it's estimated that less than 305 cubic meters of renewable fresh water is available per person per year. Yes, less than 305 cubic meters of renewable water, fresh water, is available to meet the population as it relates to one person per year. That is damning. It speaks, Mr. Speaker, to the quality of life that a person may be able to be exposed to and the constraints thereof without adequate water. That's what it speaks to. We are at the end of La Nina, where you will have that cooling of the Pacific. And we, unfortunately, over the next couple of months will begin El Nino, which would cause the increase in temperatures, drought conditions across the Caribbean and other areas. We will experience, Mr. Speaker, on average over the next 5 to 10 years, an increase of temperatures that would cause those who align themselves with the UNFCCC and the Paris Agreement to hold down their heads because it will go over the 1.5 degrees Celsius perennially that we have aligned ourselves with, and that we have said to the rest of the world that we will do everything in our power as it relates to our greenhouse gases to ensure that it doesn't happen. Now, all of these things affect the ability to have water for Barbadians. It affects the ability. The drought, the climate change, the fact that we are seeing some weather patterns that are normal. These things affect the ability of Barbadians to access water. But what is the discussion in this act about? I wanted to make it absolutely clear, unequivocally, that this discussion today is about non-potable water. Non-potable water. What does that mean? The discussion is about water that does not collide itself with the lips of people. It does not have a relationship with the palate. It does not enter the digestive system. It is water that is not for drinking purposes. I use the word potable. I am not being that so full today. I am saying to you, Mr. Speaker, that this simple conversation today about water use has nothing to do with water that you put to your lips. It has nothing to do with water that animals put to their lips. Because trust me, Mr. Speaker, if you're speaking about human beings, I would take the opportunity to speak about animals. Because sometimes they put them in the same category, or most of the times. And how we treat our brothers and sisters, I treat my brothers and sisters in the animal kingdom too, the fauna. So I am saying that this bill dissociates itself, divorces itself from water at this time that we will consume. And what does it speak about? Mr. Speaker, what is the water that this bill is speaking about? And we have to be absolutely clear. And that is why I start by saying, let us understand that there is a situation where the water we are speaking about is proposed to be used for irrigation of crops, agriculture, horticulture, the irrigation of crops. So the water, as elucidated in the bill by my colleague from St. Michael's Southeast, it once treated to a certain level would appreciate that it could be used for the irrigation of crops in both agriculture and horticulture. 1B, or the second use, washing and cleaning of outdoor surfaces, including roads and highways. Washing and cleaning of outdoor surfaces, including roads and highways. You never know, Mr. Speaker. Last time I had ashfall on the roads, on the roofs of our house, on the trees themselves. A lot of our insects and insect species died. I lost a lot of my leaf-toed gecko, over 1,000. Some people may call it the Philodactylus pulcher. I see my apartment, St. Andrew. He's looking around. He knows a little bit about these things. He's not a herpetologist, but I think that he knows a little bit about these things. But I'm saying that, Mr. Speaker, sir, we could appreciate, when we had the ashfall, the use of reclaimed water. We could appreciate it for washing and cleaning of outdoor surfaces, roads and highways. That's what we could appreciate. Toilet flushing. Now that is a given. Toilet flushing. Surface ponds and lakes. Aquaculture. If you want to use, because a lot of people like to use these big words. Aquaculture. Surface ponds and lakes, and for aquaculture purposes. We are signatory to the Ramsar Convention, which looks at special protective areas, wildlife, and those water source areas, ponds, and how we treat to those things will impact our international obligation. Now, with reclaimed water, we can recharge those ponds to ensure not only our biodiversity is conserved, but that our fish life and the aquaponics as we know it, because that is the way how we are going to ensure that we have an added avenue for our food security. Industrial and equipment cooling. What does that mean? Water is used in the industry and in the industrial process when we are producing paints. Millions of gallons of water, Mr. Speaker, sir, in the production of cement. I see my good people from the Water Authority shaking their head in approval. In the industry as it relates to fabrication, Mr. Speaker, for the production of chemicals to be used as a cooling agent in the steel industry. All of these different areas, water is used. And right now, the water is used as potable water. This bill allows the opportunity for us to be able to use reclaimed water or treated water for industrial purposes, Mr. Speaker. It obviously requires a change. As I said, it would not be long today because the Deputy Prime Minister was absolute in her presentation. She was as diluted as the water itself. There was no muddiness associated with her presentation. I want to say that it requires a paradigm as it relates to how we appreciate the full use of water. And every single drop. Because when you are having these conversations, you have to think about circular Barbados. You have to think about circular economy. You have to think about the way how you can utilize every single, not only drop of water, but other items as well that could be repurposed for viable purposes. And what I'm basically saying, Mr. Speaker, that every single drop of H2O, or the molecule itself, water, should be able to be conserved and used in a circular way in Barbados. Every single drop. That is how important it is to us now. It is the most used natural resource in the world. And sand is running a close second. Silica. It is the most natural resource in the world. You can live thousands of years without love, but it may only survive one day without water, Mr. Speaker. And I know you're a man that understands love better than most people. But Mr. Speaker, I'm basically saying that the importance of us conserving that which is the basis of life must never be underestimated. The importance of this art must never be underestimated. The importance of having water. Because when you're able to separate its usage in this way, then we will be able to access more potable water or water for the use for drinking purposes, because less of that water will be used in all the areas that I just outlined, from industry and aquaculture and what's not. Because right now, all these things are being funneled by potable water from the Barbados Water Authority. And they're having a headache out there as it relates to having this water for potable purposes. So, Mr. Speaker, what are we saying? And that is why it's important for us to reflect on some of the initiatives that we have started. We have started, and I want to encourage the people from the town planning department, because they have insisted basically as part of the planning arrangement to have the tanks as part of the planning application and approval. To say that tanks must be attached to homes before approval is revolutionary. The ability for us to harvest rainwater. I must say that I can speak as an advocate and an active participant because I have a tank on my house, Mr. Speaker. And this is a long time I have been able to harvest water, run from the piping system on my roof, connected to a pump on a tank, and the water has been able to supply my lawn and my fruit trees for years. 4 years, saving me a lot of extra financial burden, and of course, saving the usage of potable water. Because there's a double catch here. You are saving the use of potable water, which means that persons in the country who are suffering from water shortages could get more access to more water. And you are saving yourself where your pocket is concerned. So there's a win-win situation with having water harvesting devices on your home. So water conservation must become part of the conversation if we are serious about preserving the integrity of our water supply. If you're serious about it. And I want to say to Barbadians, I congratulate you today because as I drive around the country, I have being able to see persons with these black tanks all over their house hooking up and things. So Barbadians are now being sensitized to the importance of water conservation and water harvesting. I have seen it almost everywhere you go. And this is the type of direction we need to go on, and this is the type of conversation we need to have as a country, where water saving and conservation mechanisms and methods are being utilized. Because as I say, the importance of saving every single drop of water must now be the focus of the day. If we are serious about combating the vagaries of climate change. If we are serious about it. So we must have mature, serious conversations about water conservation and water use. And I'm saying to Barbadians, I applaud you for taking the first step in putting those devices on your house to harvest your water so that it can be used for agriculture purposes. And I see some persons using them to wash cars, and et cetera, et cetera. It is a step in the right direction. But government has started because we understand and appreciate the fact that there must be adaptation projects. There must be a consciousness as it relates to how we adapt to the vagaries of the climate change and the fact that it is a phenomenon that has seeked to wreck life as we know it in its normal way. And so we have started to do things as well. Because our Roof to Reef project, where we look at water from the time it hits the roof. So you're looking at the way how roofs are constructed, how they have the piping system, and then to the way how water flows to its ability to replenish the reefs. This is a very, very important project, and it speaks to the adaptation and the importance of us adapting to, as I said, the climate change phenomenon. The ability for us to build our house, to be able to resist the surges of the wind, etc. And along with that, being able, because you have the right systems and the right structural approaches, to be able to conserve, not only conserve water, but allow it to run its natural course so that it can replenish our reefs. I must tell you, Mr. Speaker, sir, our reefs are suffering now. Ocean acidification, sea level rise, the destruction of the phytoplankton, and the flora at the bottom of the ocean. The reefs are under severe pressure. Nitrate levels are higher than we can appreciate in some areas under our ocean, and is affecting a lot of our reefs. And I am saying the importance of replenishing our reefs with good, clean water is again something that we must consider if we are serious about having that blue carbon sink that is needed to be able to sequester the carbon dioxide, which is the leading greenhouse gas. The importance of the reefs. So when you have a project like Roof to Reefs, which I will say will be able to augment at least 15 of the 17 sustainable development goals, including the goal that speaks to gender equality, because as part of the Roof to Reefs, it has a domesticated aspect to it, where women are being empowered as part of the program. So I'm saying the replenishment of the reef with clean water is very, very important for us to be able to say to the world that we have an active, vibrant blue carbon sink for the carbon dioxide to be sequestered from the environment. Barbados produces about 2 million tons or so of carbon dioxide yearly, and about 25% is sequestered by our blue carbon sink, and the other 25% by the green carbon sink. So the importance of improving planting trees on the land and improving our resupply on the ocean should never ever be underestimated. So the ability for us to have fresh, clean water, even to be able to buttress our reef is a very important dimension. And how we are able to recharge our aquifers, all of these discussions must be part of a good policy that speaks to essentially the conservation and use of our water. I want to say, Mr. Speaker, sir, that the EPD, the department in my ministry, Environmental Protection Department, plays a regulatory role as the Member of Parliament for St. Michael South East Port 2, along with the Ministry of Health, to ensure that the water that is reclaimed, that it meets certain specific standards. And to ensure that, of course, that those established standards are carried out by the entities given the various permits. So what does the Act allow the EPD to do? It allows, for instance, the EPD to monitor, inspect, sample of the effluent to determine the compliance with the water permits, the water treatment permits. So the EPD, who will be charged with, of course, monitoring these various plants, they will be responsible for ensuring that sampling is the various sampling of the water is taken to the government analytical lab where necessary. We are also using best scientist lab in other cases, along with the university, to ensure that the quality that is required, that quality is maintained. So it's a regulatory function of the EPD. The inspection of facilities, again, a function of the EPD, to ensure that the water, again, the treated or wastewater or reclaimed water is again up to those standards. The preparation of guidelines and the process of application for the permits, all these things are the responsibility of the EPD. So they will review the wastewater treatment plant, the designs, to determine the appropriateness of the proposed application. So along with the Marine Control and Pollution Act, the EPD is charged with reviewing the proposed designs for the treatment plant to determine the appropriateness. So before they get the license are given, EPD does the review of the proposed constructs of the plant. They're also responsible to inspect the treatment plants to ensure that they are compliant with the applicable standard, and this standard has to be maintained throughout the whole process, from the inception right through to the production of the water. They're responsible for sampling the influent and effluent to determine the quality and the plant performance. Identify areas of improvement in the operation and maintenance of the wastewater treatment plant, and communicate to the respective operator if there are any anomalies. So basically, EPD, as I said, along with the officers of EPD, they are responsible for, on a regular basis, to ensure that these various plants fall within the scope of standards on operation. The preparation of guidelines on discharges to the environment for wastewater treatment plant operators, including provisions for plant assessment by the operator and sampling points in the treatment plant. Again, another function of EPD. Based on the volume of the discharge and the quality, the characteristics of the treated wastewater identified, we also look at the environmental impacts of the discharge. So by soil sampling, air sampling, and sampling of the immediate surroundings, the EPD responsibility is to ensure that the plant is operating minus any contamination. As a member of the Water Reuse Committee, they are supposed to provide technical advice on wastewater treatment treatment technology, and water quality standards. So the EPD serves as an educational hub. We have been doing it for a number of years now. I want to thank the officers, led by, of course, the director of EPD. I want to call his name, Anthony Headley, who has been working extremely hard over the last 4 years or so to ensure that this act becomes a reality, and all the officers within the EPD, because it is no more than ever that their role and their function and their ability to carry out their expectations, that is now put under the microscope. So I want to thank them, and I want to implore them to continue to have that bird eye examination and microscopic examination of the plants, the operators, to ensure that there is compliance at every single stage. But because with the improvement in technology, there may be situations where you can have computer monitoring, because we live in a real world now and a very technological world. So gone may be the days in the next couple of years where an officer will have to go into a plant and do monitoring and for different physiochemical sampling and etc. You may have these things hooked up for computers and stuff, so that they can monitor based on levels of chemicals and be able to alert. These types of things happen in other countries in the world, and I suspect that Barbados in the not too distant future can get there. We cannot have the success of this act and invariably the success of having water and water conservation and water reuse in the way we expect it to, unless there is unequivocal consultation and communication with the people of the country, Barbadians. And so the EPD, using a Jeff-funded project, is called the Crew Plus 9601, started a communications construct where the discussion will be had with persons in the communities, the ordinary person. The discussions will be had with the persons the operators of the various plants. It will be had with the technical people, the active participants, the plumbers, those persons who are involved at all levels, to ensure that you have the buy-in. Because unless you have the buy-in of the stakeholders and of the people whose life will be affected in a positive way, then we will be spinning top in mud. So there is a project already, as I said, started with the Jeff Crew Plus project, and it is being obviously the consultants were hired through the IDB and the Organization of American States, and to be able to have that ground assessment, the SWOT analysis, and the SWOT analysis speaks to the strength, weakness, and the opportunities and threats. That has already been done, and it's at the level where now, as the Member Parliament for St. Michael Southeast spoke to earlier, where we will start that communication strategy so that Barbadians and persons alike would understand implicitly what is being done in order to have this whole act and the whole conservation and the idea behind water reuse in a special way. These are the things that we are doing because we understand full well the importance of communicating to Barbadians. We have said before as a government that we will not do things, as the member who spoke before me alluded to, in the dead of night. We will not hide behind the darkness and expect that when it comes to light that it would salivate Barbadians in a special way. That is not the way how we intend to do business. So we are saying that there is a communication strategy and a communication plan. We will have those discussions. The Member Parliament for St. Michael Southeast spoke pellucidly about the bill in terms of all the different aspects, the charges that one could expect if they run afoul of the bill. And I'm saying, Mr. Speaker, I support the Water Reuse Act 2023, and I implore the persons involved in the dispensation of the reclaimed water to make sure that acquiesce to the tenets of this particular bill, and I am sure that it will redound to the benefits of every single Barbadian. Mr. Speaker, I'm obliged.
Honourable Member St. Michael South Central.
Thank you, Mr. Speaker. I think that with respect to this bill, and certainly with respect to this sector, there is scope and there's perhaps the necessity to put all of these efforts in perspective. This bill that is before the House really addresses a small part of the needs of the sector, of the gaps that currently exist in the sector. And in fact, I would like to encourage the government, the cabinet, the ministry to begin the process of putting everything in perspective for the people in Barbados. Because the water sector, as the member who spoke before me spent some time clarifying, it is the most important resource that we have. And I make this appeal because, for that very reason, I make this appeal because we want the partnership of Barbadians in making sure that this sector begins to take on some sustainability. We want the collaboration and the solidarity of Barbadians in matters of conservation, some having already been announced. But in order for that solidarity to take place, people need to understand the landscape. They need to understand what is coming. They need to understand what will affect them. They need to understand what they will be allowed or disallowed from doing. And they need to understand what are the financial implications that may affect them. They also need to understand some of the bread and butter issues that affect the sector. So let me start by saying that I think it's important to clarify, to make clear that this bill and its purpose relate to essentially commercial production of treated wastewater. I say that because I feel that people may wake up tomorrow and hear the honourable member who led the bill and hear perhaps 30 seconds or 45 seconds of her very expansive presentation and not have the full benefit of it, and may be led to the conclusion that this will affect how they use water in their homes. And what I am seeing before the House is something that does not address that, but addresses the companies, the entities that are in the business of treating wastewater for on-selling or for onward provision to other users. And I think to support that, what perhaps I would like to understand, or would have liked to understand, is really what is the size of the sector. How much water are they currently producing? What is the percentage that they are currently contributing? Whether there is scope to contribute more as a result of this legislation being passed. That's something that I would certainly like to understand. What is the size of the sector? Who are the clients? Who stands to benefit? And so on. I think I would also, sir, like to understand and like to know, and I suspect this will be the subject of the regulations that will attach to this legislation, whether there are certain categories of use that will mean that these categories or these intended purposes would need to be treated to different standards. So that, for example, if there is water that is going to come into contact with human beings, whether that is washing your car or something else, whether that's a different standard or a different use or a different category from water that will just flush toilets, and therefore it will not come into contact with my skin or with my hands. Or so to understand, and perhaps this is contemplated in the regulations, but to understand whether there are categories of that water, so that these companies that are treating that water are treating it to various standards. And if not, then to also understand that if we're talking about one treatment standard for these different uses of water. But beyond that, sir, I do think that we need to understand, we would wish to understand the overall lay of the land with respect to the sector. I do recall that some time ago there was an effort or an intention to create a water sector master plan or something of that nature, so that all of these different bits of, not just legislation, because legislation is not there for the purpose of legislation in itself, but all of these different parts of these different considerations for the provision of water to Barbadians, that we could all understand how they fit, and we can all see what needs to be done. And so I do not know if there's still that intention to create that. My nomenclature may not be accurate, but something that amounts to a water sector master plan, if that is in the works, so that it will show us what are the different parts that relate to the sustainable provision of water to the country. I think that would be useful if it is still in the works. But there are all kinds of other parts that relate to this. And I do want to say that these efforts in part relate to not just making sure that we have greater access to water. And so being able to treat wastewater and have it used for things other than drinking is important. But there are all kinds of other things that contribute to this goal. And I know, for example, that the Barbados Water Authority and the ministry have water loss reduction as one of its targets. In other words, how do we go about making sure that we don't continue to lose water through leakage in pipes and mains? But we also have to be concerned with losing water at the level of the household. And sir, I must always, in these conversations, represent the concerns and the difficulties of the people of St. Michael South Central who have sent me here. And with respect to the issue of water loss reduction, I have constituents who are from time to time confronted with astronomically high water bills. They manage to show the pattern of those expenditures or the pattern of those charges, and to say, well, in March, it was $80, and then in April, it was $2,080. And I look at that pattern and I think, well, something has gone terribly wrong here. And I seem to recall, and I put these things on the table not to suggest that I am right, but as an appeal for some information and clarification. I seem to recall some time ago that the Water Authority used to give some assistance to householders in helping to figure out the source of the leak if they thought there was one. I do not think that that practice continues. I think that there was some time ago a policy that suggested, well, if the leak happens on our side, as in off the premises of the householder, then that's something that we can check. If the water loss is with our infrastructure, if the water loss may perhaps be at the level of the household, then we're not able to give that assistance. Again, I put that on the table to be subject to correction if correction is needed. But it seems to me that householders are experiencing challenges when it comes to not understanding the source of their leaks. There are cases where people say to me, and in many cases I'm talking about pensioners, people 85, 90 years old, who are saying, well, they said I need to call a plumber myself. I called a plumber, he can't find anything. The bill come in the next month for $4,000. They insist that their usage does not warrant such a charge, and they are at a loss as to what they can do. I seem to recall the minister, the honourable member for St. Michael Southeast, did acknowledge that this was a challenge that was presenting. And I make the point again to keep it front of mind for the Water Authority and the ministry, because if water loss reduction is one of the targets, then it has to be done in such a way that it also directly benefits the people of Barbados. And so that it is not an academic exercise, but it is something that they can see the benefit of, not just in terms of the sustainability of water in general, but in their own bottom line and what they are paying or able to pay. But sir, I call for this sector to be mapped out for Barbadians so that we can understand the intent and the direction, because I am aware that there are other issues. I am aware that the Water Authority and the ministry are exploring, finalizing at different stages of settling these issues. But I do think that each time we bring legislation on a different piece, it starts to raise a lot of questions about the other pieces. So for example, having formerly had responsibility in part for planning and development, physical planning, the issue of water zones has been vexing. The issue of how are we zoning the country, what are the implications for the erection of sewage facilities at the level of the household or independent sewage facilities to which households can be connected. It is something that from time to time pops up, starts to occupy the public discourse, and we determine that we will wait to discuss the legislation, or we will wait for further clarity. But I do believe that the time has come for us to understand the direction in the sector. And so these bits all fit together. So the issue of the water sector master plan would start to help us map that out. It would show how does the water reuse bill that we are discussing today contribute to the objectives that we have in the sector. It would discuss how does the water zoning bill or the Barbados Water Authority Amendment Bill also contribute to those objectives that we have. But I say all these things, sir, because I think that while this legislation is desirable, from where I might sit as a Barbadian, as somebody who is looking on, wondering, how does this affect me? I see the creation of committees. I see the establishment of guidelines. I see an official process being created. And that's fine. Official processes are necessary. What I don't hear is, when will I be able to have some agency as a citizen? When will I be able to do something about my own access to water in my house at the household level? And I think that's really what we want to understand. Issues that relate to rainwater harvesting and potable water storage are, I would say, top of mind for many Barbadians. We want to know under what arrangements can we catch water at the level of the household, catch water on the roof, catch water in a tank, and have it be useful to us in our homes. What would that require? We know, and the Minister, the Honourable Member for St. Michael Southeast made reference to it earlier, we know that it will require us being able to install and implement dual reticulation plumbing systems, which means that there's separate plumbing for non-drinking water that there is for water that we're going to drink. We know that the plumbing code that was mentioned earlier is meant to advance this process. However, there is a bit of a breach between where we are now and where we are going, and perhaps some steps that we can take until we get where we are going. I am not sure that Barbadians understand the current guidelines or requirements with respect to having a water tank at your house. I know that under the old planning legislation, there was just the requirement to have a tank of a certain capacity. Not much else was required at the time, not much else was associated with that, whether it needed to be hooked up, how would this water be tested, what were some of the other requirements to make sure that the water stayed clean, and so on. And it led to some confusion with respect to what householders needed to do. But I think that even now, even as we settle some of the requirements, there is space for a conversation on what is it that we want every Barbadian to be able to do at the level of the household. How much water do we want people to be able to store? By what means? How much water do we want people to be able to harvest, as in to catch, to be able to treat in a way that they can at the level of just a householder? What can it be used for? And where are we going? Where are we going with respect to the regulations around this? What will the Planning and Development Department require of householders in the future with respect to the sustainability of water and making sure that in the event of outages, in the event of ruptured mains, in the event of natural disasters, when the water supply may be knocked out, what are we asking householders to be able to do? But further to that, what might be the financial obligations on householders to do that? I know that part of that process is to be able to understand what is required for this dual plumbing system, what is it likely to cost. But I also seem to recall that as part of the $27.6 million grant from the Green Climate Fund that is meant to execute a project called the Water Sector Resilience Nexus for Sustainability in Barbados project, that they're involved in that project was an intent to be able to use some of these savings from having photovoltaic energy generation, use some of the savings from that renewable energy in the water sector to be able to contribute to a revolving fund so that potentially those Barbadians who will need to retrofit their homes with this dual reticulation plumbing would then have the opportunity to do so through some kind of financial arrangement. I raise these issues, sir, because I don't want them to slip from view. I think that the question of having each household having their own access to the water that is falling above their heads is the next level of progress and development in the sector. And so this issue of rainwater harvesting for reuse at the household level is perhaps where we need to be able to bring utility to people. I would say further, sir, that with respect to the issue of reduction of water loss, there are several other initiatives of the Water Authority and of the ministry that I also need to be put in very sharp relief for people to understand. So in other words, there's a lot that has to be done in the sector. There's a lot that is being undertaken by the Water Authority. But overall, it needs to be made clear what might be the financial implications for every Barbadian. But beyond that, what are the benefits to be had from the kinds of initiatives that the Water Authority and the ministry are involved in? I know, for example, that when it comes to the issue of the plumbing code, it will then start to raise other questions of a general building code and whether this remains contemplated. How will these two things relate? Really, sir, what is the landscape? What does it mean for the kinds of businesses I can have attached to my home if I'm in a particular zone of the country? What does it mean for sanitation opportunities? What does it mean for being able to develop housing projects in a certain area? So, sir, I think that we are going in the right direction. I believe that this water reuse bill starts to show the intent of the ministry and the Water Authority, but I must always come back to the issues that are affecting people every day. Not just the ones that are affecting them today, but the things that are going to give each Barbadian, not just a commercial sector, but each Barbadian the wherewithal to have some agency and to be able to control their own access to water. I know we have a ways to go, but sir, I am always cautious when I see legislation that creates official processes and does not let us see beneath them to understand how the government is putting people in the position to have greater access to water, to be able to meet their own commitments, because the Honourable Member for St. Michael South East made reference to the fact that the only way the Water Authority can deliver is if its financial commitments are met through the payment for the utility. This is true. So then, let us put people in the position to meet those commitments. Let us make sure that we don't have householders who do not understand the source of their leaks or why their commitment seems to be far above what their usage is. And I think it goes beyond the issue of public education. I think that sometimes Barbados is small enough, we have that benefit. Barbados is small enough that being able to engage with people directly, being able to explain to people, well, this is what you are doing that you should not be doing. We have had that model with our environmental health inspectors. We have that model here in this bill with people who will visit these entities and require certain information of them. Let's not only visit or have an interest in the commercial entities, but let us also understand that people, in order to be able to do the right thing, we also have the scope and capacity to put them in the position to do the right thing, to be able to meet their commitments, to be able to pay those financial commitments so that they do not then have the issue of being disconnected. And sir, you know, these issues do not stand on their own, and I sympathize often with the Water Authority, because issues of water and land in this country are inextricably linked. And we have, as a part of our development process, to perhaps once and for all be able to settle issues of land tenure, of land ownership, of how can people prove ownership, how do we support estate planning and making sure that when I pass on a property to my grandson that I have the paperwork in place so that he can prove that this property is his, and so he doesn't have the complication of not being able to show ownership and therefore not having water reconnected. These issues are all linked. And we are now, sir, several decades post-independence in a position where we have another tier of basic development in which to engage. We went through a process of dealing with basic needs like food and water and workers' rights, and we, as a small country, led social development in a number of areas. We continue to do so, for example, with the child protection and child justice bills that are before committee now. We continue to lead on these things. Let us not lose momentum. Let us not fall behind, because basic issues that relate to water supply, basic issues that relate to land ownership start to get away from us, such that Barbadians start to feel dispossessed once again. These issues, sir, as I close, are not straightforward. Being faced with having to replace almost all of the mains and pipes and connections underground in a country as populated as it is cannot be easy. Being faced with persistent drought as a result of the climate crisis, and seeing the rainfall and having people think, oh, well, the rain falling, so the drought is over, when in fact that is not the case. Being faced with all these things, sir, I don't want to give the impression that it is easy. It is not. It is difficult. I believe that in order to ease the transition, in order to put people in a position of feeling like they understand and they're not afraid and they don't know when government is going to get up tomorrow and come with another committee, in order to ease that anxiety, let us all see and understand what is the intent of the sector. Where are we going? We have South Coast tertiary treatment plants. We have sewering of the Bell and other under-sewered, under-sanitized housing developments. We have water zoning. We have rainwater harvesting and potable water storage. We have a set of things that together will put us on very solid footing. I'm just asking that we be made to understand fully what that footing looks like, and furthermore, perhaps more importantly, what it requires of every Barbadian, and how will the government support those efforts at the level of each individual. Sir, I support this water reuse bill, and I look forward to having the fuller plan before us for consideration. I'm obliged to you.
Honourable Member for St. Andrew.
Thank you, Mr. Speaker, sir. I rise to add my voice in support to this bill that would provide for the capture, collection, and treatment and reuse of water, wastewater for various purposes. First, Mr. Speaker, I want to paint a picture of the global context in which Barbados now operates. Today we are seeing strange weather phenomena. We're seeing changes that go beyond the natural variation in the temperatures on land. You're seeing it on the sea. And you're seeing abnormal trends in the timing of seasons in terms of some seasons being longer and some being shorter than usual. You're seeing a variation in rainfall patterns and many aspects that tells us in no uncertain terms that we are going through a period of climate change. And I want to speak to, very briefly, to 3 areas that I think the experts have pulled out and we have been discussing for some time, which will be the impact, the ones that you can point your finger to, of climate change on weather patterns here in Barbados, especially the world over. But we can see them very clearly displayed here in Barbados. And one such is change in rainfall patterns. And this year presents a good example of a drought situation. We have seen a reduction in rainwater, because we are going through a drought right now. I mean, yes, we had some rain yesterday, but we are going through a drought. And based on the predictions of the experts, this drought may last right well into the month of June. And that has its effects in terms of our ability as a government to extract water from the aquifers. So we're having that problem where we are already seeing a reduction in the levels of water in our aquifer. And we have, fortunately for us, the facility at Bomiston that can give us a good sense of where we are in terms of our water levels. And from our reports, we are more on the low side, on the low end, than on the high. So that's a good indication of where we are. And also, if you look at our water runoff, as an MP for the constituency of St. Andrew, we are accustomed to seeing rivers and streams. If you were to go into St. Andrew now, you may hardly find a stream. You may find a dry riverbed. But you're not seeing any rivers, you're not seeing any streams. And sometimes those, even at this time of the year, even though the water will be much reduced, much lower, you would sometimes still see 1 or 2 streams running. And you're not seeing that. If you see them today, it may be as a result of the rain that fell just yesterday. But for the last couple of weeks or so, we have not been seeing any water in many of our streams. Also, another very obvious effect of climate change is the intensity of the rainfall. Now, it almost seems counterintuitive that having large rainfall or heavy rainfall is seen as a negative. But it is, When you think about it, you have these small, short bursts of rain. They fall on the landscape, and just as fast as they fall, they run off. And you're not in a position to capture them. They don't stay on the land long enough to percolate down through into the aquifers. They just run off back into the sea and become and actually are wasted. So they do not contribute in any way, shape, or form to groundwater recharge. So when we have these large rainfall, like last year, for example, if you recall, in the months of December the 17th, I remember it very well because I had just returned to this country the day after we had a terrible rain, some horrible weather that destroyed some of the infrastructure in St. Andrew. We were not accustomed. We were not expecting that near to the end of the hurricane season to be getting that kind of rain. But that's what we got. We're seeing these variations, these strange weather patterns, heavy rain, and that rain just ran off. It was of absolutely little use in terms of aquifer recharge. So yes, we're having the heavy rains, but they're not helping us in the way that we would expect. And in fact, they are hurting us because they are destroying infrastructure. And then we have what we expect, also reduced rainfall. Naturally, if you have reduced rainfall, We have reduced amounts of water reaching the aquifers. So reduced rainfall results in reduced aquifer recharge, and high intensity rainfall also results in reduced groundwater recharge. So we have a double whammy in that sense. Yes, there's rain, but it's not falling at a consistency that helps us in any significant way. And then I think the Honourable Member for Christchurch West Central would have alluded to the fact that we are seeing a rise in temperature. You know, we've experienced even just recently some very hot days. But I look into it further and I realize that in some countries there are departments where there's a portfolio that deals with heat and heat-related illnesses. Where climate change has impacted some countries a lot worse than it has impacted us thus far. And they are already seeing the effects of heat waves. I think there was a heat wave in Europe, in England, sometime last year. Unusual phenomenon. We associate England with, cold, miserable weather, even sometimes in the summer. But they were experiencing a heat wave for the first time in so many years. All over Europe, you saw heat waves where reservoirs were drying up. Some places, persons were forced to ration water. All over the world, you can see now that you have the wonder of the internet. You can see photos of displaying bodies of water that over the past 20 years, over the past 30 years, have been reduced to such a state that some have already totally dried up. And you're seeing these things in Europe. But also here in Barbados, we are having the challenge with rising temperature. And the member for St. Philip South can speak to it because it impacts the farmers. It impacts the farming community. When it's so hot that the little bit of water that you sprinkle your plants with, 2 tools, is dried up. Those are some of the impacts. And I'm sure it impacts us in other ways. I'm sure certainly in TW, we've been doing a lot of road construction, and oftentimes we have to wet the road just to reduce the dust and the misery that causes. And we sprinkle the road, and sometimes less than half an hour, the road is dry again. And we've seen the effects of temperature rise right across the board. Then you also have sea level rise. And most persons would not understand what is meant by rising the sea level. How does that bothers anyone? But it bothers us if you're into the extraction of water from the aquifers. It bothers you because that water, it comes in somewhere. And normally where it goes is into the aquifers, impacts the water lines. If anyone in water tell you, there are basically 3 lines. There are 3 types of water you find down there. There's the fresh water, which is at the top. There's brackish water. And then there's the salt water at the bottom, brackish water in the middle. I mean, we have done these experiments over the years, and we've seen how water separates. And that the more dense salt water goes to the bottom, the brackish water, which contains some salt, was not as dense as the salt water that stays somewhere in the middle. And then you have the fresh water lanes at the top, and that's where we extract our water from. But when you have that intrusion of salt water from seawater intrusion from rising the sea level, then you have a displacement of fresh water, and there's increased salinity or increased salt in the water, and that has impacted us in a significant way because it has resulted in us having to rest, as the term I think they use, to rest some of our water wells along the west coast. So we are already, in more than one way, feeling the effects of climate change. And I'm speaking of climate change this way because it's really because this bill is a bill occasioned by climate change. We are debating this bill today because of climate change in a very real way. All those things that I mentioned just now have already and will continue to impact negatively on our conventional source of fresh water, and in the case of our desalinated plant, our brackish water lens as well. So we're having challenges both in terms of our fresh water and desal water, because if it gets to a point where there's too much sea level rise, that could also impact desal, because most persons believe that we extract the water straight from the sea and we pull the salt from it, and then the fresh water comes. When in actual fact, we drill down into the aquifers, and that's where we extract brackish water from within the aquifers as well. Just like we drill wells and boreholes on land to pump water via wells, we also do a similar exercise when pumping water for our desalination plants. So I've heard heard on the radio, seen on social media, people complain as, how is it that we can be water scarce when we are surrounded with so much water? We have a desalinated plant and we are surrounded by water, because they believe that we extract water from the sea, and we do not. That water comes from under the ground, the same place where we extract the fresh water that we pump into our wells and we sanitize and pump into persons' homes. But as I said before, this is important because despite the fact that some of us may take it for granted, the water sector that's being impacted by this climate change is, in fact, they said it's the most used natural resource, but it is in fact the most important sector of all sectors. It is the one sector that without it, no other sector can survive. We cannot have a vibrant tourism industry without a reliable water service. We cannot have a health sector without a water sector. We cannot have agriculture, food security industry without water. It is central to almost every other sector. It is central too. So when I look at our place in terms of and the member for St. Michael South East alluded to it, the member for Christchurch West Central spoke to it, and I will also touch on it because I think it warrants repeating the situation that we are in today as it relates to how we are categorized as a water scarce country. They say we are at number 15. If you use the Falcon Mark water stress indicator, we are at number 15. And now, being at number 15 may not sound all that scary because, you know, there are persons who probably at number 14, 13, 12, 11. Maybe there are people at 3, 2, and 1, and we're not there. But remember, there are like 195 countries in the world. So to be at number 15 is not an envious position. To be at number 15 is cause for concern. We should be worried. Every time we hear that, we should be somewhat concerned. There are 195 countries in the world. I suspect some of those countries that are at 15, 12 are countries located in the desert. That's where you'll find those countries. Many of them, maybe 1 or 2 in the region, but the vast majority of them will be in the desert. But, you know, historically, I said it before, we have seen a positive of, and I'm sorry that the member for Christchurch West Central left because he is the one who's been championing the cause for biodiversity in this country, certainly in this honorable chamber. And I've always said that there are 2 areas where we have always fallen behind our neighbors, and those, our neighboring islands, those are in biodiversity and also in water. And one is linked to the other because there was a lack of water, bodies of water. That's perhaps why we have a paucity in our biodiversity. Those countries that have rivers and and big lakes, and all through the region they have thousands of species of birds and snakes and different insects, and we have a limited amount because we never really had a lot of water sources here, at least certainly on the surface. And then there's also, if you really were to check the history of Barbados, many people, when they came here, there were evidence that people live here, but there were no large groups of persons living here. People would visit here. And they will continue to go and live in Guyana and live in St. Lucia and Dominica because obviously those countries had large bodies of water, surface water that persons could benefit from. And I said that because I want to speak specifically at some point later on to use of water, reclaimed water, surface water, pond water, and so on in Barbados. So part of the reason why this country was not inhabited when we were discovered, I use that term very, very loosely, back in 1627 or so, was because of water. That's what the historians say, because of water. So water has always been central to Barbados' development. So the fact that we were able to manipulate what little sources of water we have in this country and to build the type of society that we have built over the past 400 years, that's a credit to us as a nation, and long may that continue to be so. But just going back quickly to the fact that we are number 15 in terms of the countries in the world that are considered to be water stressed, I want to just give a sense, because it sounds academic. We often say we have like 305 cubic meters of renewable fresh water available per person. And so what does that mean? 305, that still sounds like a lot. I mean, this is per annum, but it still sounds like a lot. But if you bear in mind that on average what is expected for a country is like 1,700, that's what one person should have access to. They're not going to be able to use it, I know, but they have access to that amount of renewable fresh water. That's good. That's the threshold. When you start dropping below that, like 1,000, you're looking at scarcity and limitations. And then you start looking to see how that can impact the economic development of your country, because if you don't have water, you can't grow your economy. You can't develop your country if there's no water. And that's why great cities all sprung up next to waterways. Water is crucial. It's a crucial element to development, to human development, human health, human socialization. So if you are 1,000 cubic meters, you're already under some pressure. And if you are 500, that is considered to be a constraint to your well-being, to your life. Constraint. You're struggling. And that's 500. And we are at 305. Sometimes I hear 320. We are at 300. It's almost a miracle that we can do what we have done with the little that we have. And the unfortunate thing that if you were to look at all the climate modeling scenarios that the experts have come up with, it will suggest that there's not going to be any major change in climate patterns in the foreseeable future. So we have now to deal with the situation that we find ourselves in for at least a few more years, I would say decades, but a few more years for sure. But it all highlights the vulnerability and the negative impact of climate change to Barbados. It's actually set the context of why we find ourselves here debating a bill, as a wise man said to me, would perhaps make a great difference, a significant difference, maybe not in 5 years, maybe not in 10 years, but 15 years from now, might become seen as one perhaps the most revolutionary piece of legislation passed in this honorable chamber during this period. And just to think, because it's hard sometimes it's better to remind persons, because sometimes we forget what we go through. And I guess it's something about the mind. You forget the pains of what you go through. I remember the years of, probably can't remember 91 as well, but certainly 2014, 2016, the drought of that period, the water outages from that time. But the reality is that in the last 20 years or so, 30 years, a large percentage of those years were considered to be drought years. Large percentage of those years were years where the rainfall situation in Barbados could be classified as being a drought. So we've been struggling all those years. And I know that those experiences are what would have triggered a number of solutions or approaches that the government has taken to combat, to deal with climate change and to deal with water scarcity in this country. Because, mind you, despite the fact that we were not getting the rain that we were accustomed to, people still expected a certain level of service, a certain level of quality of water. They still expected the pipes to be on every single day. People still expected that when they go to take a shower, whether it be a half-an-hour shower, they can take that half-an-hour shower without having to worry about running out of water, which is a reality that I've come to discover is the lived reality of many of our neighbors. I live in this country, and I have never heard the term 24/7 water, because I took for granted that we get water 24/7 every day, at least most of us. It's a concept that people are working towards in other jurisdictions. They're working towards it. And some of them will not realize it within the next 2 or 3 decades. They would not realize 24/7 water, where they can provide the people with water every day. And that's something that we take for granted here in Barbados, many of us. So within those years, even though we would have struggled, we still expected that level of service from the Barbados Water Authority, which would have forced them to look at solutions. And there are 2 types of solutions that, well, groupings, I should say. There are a number of solutions, but they could be grouped under two main categories. And that would be demand management and supply management. And I think I mispronounced the word, demand management and supply management. Now, demand management entails management and control of water demands for various use. So you ensure that there's efficient water resources through the adoption of various water conservation measures. And I want to just touch briefly on water conservation. A good example of the approach by this government would be the National Water Reuse Policy, and my government is the Water Reuse Policy, and the harvesting and storage of rainwater for non-potable use, that policy. Mr. Speaker, today we are seeing the proliferation of water tanks all over Barbados. I know at the initial introduction, there were many people who would tell you that they didn't want no water tank around their place. They didn't want them. They were a requirement. And I think it was said in here that people would rent a tank and borrow a tank. And as soon as they made the requirements for the, I guess, for the house or the property that they were building, then they would get rid of that tank because they looked unsightly to the Barbadian eye. Those black tanks were unsightly. And that's the reality. They didn't like them. They didn't fit into the aesthetics of the of the brand new house. It's almost like we refer to it, that weight bar on your brand new SUV. It looks unsightly. Those black tanks, the persons may probably think that they were imposed upon us. Now I don't think they can produce enough of them in a time to suit the demand for those water tanks. And certainly in the north of the country, where works are ongoing to change out the mains so we can treat to some of the problems that experienced down there in the northern part of Barbados. I would have had a touch of it in St. Andrew, a touch of it in St. Joseph. We see it in St. Thomas from time to time. We would have experienced it in St. James at some point. But throughout the north of the country, where we have an aged infrastructure, where we're still having severe challenges with discolored water, and working hard every day to address, we are seeing the proliferation of those water tanks. And under the Water Resilience Nexus for Sustainability project, we have seen that vulnerable persons who could ill afford to purchase those water tanks, those persons were supplied with not only a water tank, but also a jet pump in some cases, so that these persons can have water pressure that is similar to that you would experience when you turn on your tap. Now, in many cases, persons were given 2 tanks. They were given 2 tanks. They were given a tank for potable water usage, and they were given a tank for rainwater harvesting. And you would hear the complaints, especially when the numbers start to get low. But obviously, we don't have enough for every single person who has a challenge with the water service. So some persons got and some persons did not get. And people would say, but why give a person 2 tanks when, in actual fact, they could give them 1 and maybe give 1 to somebody else. But the reality is that we have to get Barbadians back into the habit, back into the mindset of harvesting water, of conserving water. Every drop of water that you pull from your roof, that offsets the water the potable water that you would have ordinarily had to use. And this is something that is not new to Bajans. Bajans were harvesting water from time immemorial. When we came here, we had no choice but to catch water from the roof, catch water from the rivers, catch water from the streams and the gullies. That's how we got water. It's only with the introduction of centralized water system, I believe it was in 1857, with the formation of the Bridgetown Water Works Company, that we saw the centralization of water, and that was mainly in the city. That was in Bridgetown. It did not get into the rural spaces until sometime around 1886. It took a long time. It took a long time to get from Bridgetown to the environs of Bridgetown. It took some years. But it took an even longer time to get into the rural spaces. So persons in those places would have had to continue to use water that they got from the roof or they got from runoff from the land. When the gully out, we country people know gully being out. Water is pouring. Sometimes you go in there, it's pure water. It looks like water you get from the pipe. And those of us who grew up around in the country, around gullies, would look for the day when you go down to the gully, you go down in the gully, you hear the water running down there, like purest water you've ever seen. And people would capture that water, they would use that water. People would wash with that water. I'm sure that some people who like to live close to nature, aeration, would cook with that water. I'm not encouraging persons to do that, but I know that these are things that happen over the years. And only with the advent of a centralized water distribution system that we saw the decline in persons capturing water, persons taking water off the roof and things. But now we have come full circle. We have come full circle. Exactly. The Honourable Member for St. Philip, South just remind me that people are now utilizing the spring again. There's some people who never stop, but there are people now who are discovering the spring. All right, there are people who are discovering. Yes, of course. I remember for St. Thomas just reminded me that people never start using Porridge Spring. In fact, I recall when we had some really horrible water outages, persons from in Hillaby, persons from in White Hill had to go down to Porridge Spring and make a line. I had to go there and make a line to get that water from down there. So, and I'm going to push on. But as I said, it was only with the advent of that centralized system that we saw persons moving away from water, some of these water conservation measures that we are now seeing creep back into our society, and we're now actively encouraging to augment the water that is, or offset the potable water that we get from our taps. However, the experts will tell you that even with the best will of the world, efficient use of water will not on its own, enable us to generate enough water to meet our needs. Even if we do that, we catch the water from the roof, we catch the water from the springs, we still will not have enough water to quench the thirst of a growing, developing Barbados. It's not going to happen just like that. That's why we have now to turn to alternate means of water, which brings me, Mr. Speaker, to this bill in hand. We are putting the regulatory framework in place to monitor, to regulate those persons who intend to get into the business of treatment and reuse of water. And I'm just going to, because I think the member for St. Microsoft East did a very comprehensive presentation of the bill. As the member for St. Joseph said, she got into the minutiae of this bill, spoke to every aspect of it. But there are some aspects of it that I think I would want to touch on because it speaks to the seriousness of this bill, monitoring of reclaimed water, the use of reclaimed water. It can do a lot to help us in terms of augmenting our water supply, if managed properly. If not, it has the potential to be a health concern. So that's why we have to take this thing very seriously, and I think one way of looking at how serious we have taken it is the offenses. The offenses and the fines that persons will be charged if those persons were to, for example, try to engage in the commercial sale of reclaimed water without the requisite permits that we would obviously be using to help regulate the water, this particular area. If they may or misrepresent as fit for human consumption any of this reclaimed water, if you by chance try to misrepresent this water as drinking water, you are looking at a fine of $500,000. And I think the member for Church West Central alluded to the fact that we don't even expect that this water will be given to animals, to pigs, those in the poultry industry. We don't expect. It's not listed amongst the areas that we expect for this water to be used. Now, I, for one, was one of those persons who became a COVID gardener during that period of the pandemic. I stayed at home. I got into gardening with my wife. I had a few pineapples I grew there, some ornamentals. I was like many people. My member for St. Michael's Southeast became a full farmer, a full gardener. But I got into one or two little plants. I saw the importance of rainwater harvesting. But even in this particular legislation, it's not intended for the water that, one, whether it's from a pond, whether it's from industrial use, domestic use, that water, no matter how you treat it, is not intended for sale, for the use for
Your Honourable Member
animals to
has
drink.
2 more minutes.
I'm winding down. So I just want to make the point that these offenses are, these fees are high because we are taking this extremely, extremely serious. Persons who even obstruct inspectors from coming onto their property to see what they're offering to the public, those persons will also be faced with a fine of $50,000 or up to 5 years in prison. We're not taking this thing for a joke. This is not fly-by-night legislation. This is legislation that we have to police very seriously. I'm telling you. So as I conclude, I want to end where I began by saying that as a water-stressed country, we are now in a position to explore and to properly regulate and manage all aspects of water available to us, all aspects of water. This bill, the Water Reuse Act, this bill is designed to promote the safe reuse of reclaimed water and ultimately to improve the safety and efficiency of that non-potable water through a regulatory framework that takes into consideration the sensitive nature of such water. So I don't want to detain the House any longer. I'm just going to say that I support this bill. It is a step in the right direction. I think I have laid out exactly how we got here and why we are here. And perhaps, maybe, even if we don't see the benefit of it right away, I'm sure that sometime in the near future, the benefit of this piece of legislation will become very clear. And with those words, Mr. Speaker, I'm obliged.
Honourable Mr. Michael Sophie.
Thank you, Mr. Speaker. First of all, let me thank all honourable members who would have lent their voice to this debate. I know that the water reuse bill is a bill that may not evoke the participation of all honourable members. As I said before, it is not a sexy bill, but it is one that certainly will impact on the lives of all Barbadians, and one which I think all members of Parliament need to familiarize themselves with, as well as the general public. Just to respond to a few of the concerns that have been raised, I really enjoyed the Honourable Member for St. Andrews' presentation. He always brings a level of local knowledge, not only to this chamber, but certainly in many of our meetings as we're doing work in relation to the Scotland district. And it gives a perspective that is really different. Because again, the references to the gullies and the sound of the water, again, for a town girl like me, is a little different in terms of listening to him sometimes. So I do enjoy when he does speak and he's able to relate it to the people in not only St. Andrew, but in all of the other parishes in the countryside. I wanted to again thank the Honourable Member for Christchurch West Central as well, who would have indicated the progress that is being made in terms of the regulations. As I said before, the regulations that will accompany this particular piece of legislation have already been drafted. They've been drafted for a long time. I'm sure that the tweaking and the fine-tuning will take place. Given that we made some changes in the last 2 weeks, I'm sure that those amendments will be made, and we did speak to the CPC about ensuring that the regulations that need to come are followed as quickly after the passage of this bill. So I anticipate that the work will be put in and has already been put in to be able to bring these regulations to have the teeth to operationalize this particular piece of legislation. Mr. Speaker, sir, I also want to thank the Honourable Member for St. Michael's South Central. I know that the comments and the observations are merited in some ways in terms of being able to reflect. Certainly when you're not in cabinet, it is obviously a place where you have a different perspective oftentimes. I certainly had a different perspective when I was in opposition. I thought I could change everything by the time I got to government, sir. And then you come to realize that it's not as straightforward as you thought it was, because there are so many moving parts, there are so many dynamics to be able to get things done. And so I think with the Barbados Water Authority, it is true that there are a few more things that we have to do. The public education definitely has to happen. We have to make sure that people understand all of the moving parts, but there is a reality. We are doing a number of things across Barbados Water Authority, across many ministries, and BWA is no different from any other ministry. We're relying on the same human resources to be able to do the water harvesting policy, to work on the water reuse policy, to help us with the public education and all of these various things, to be able to work with all the international agencies to execute all of the projects, sir. And we do so with a reduced capacity sometimes internally, not necessarily that the technical competence is not there, but we do so oftentimes with that reduced capacity, trying to almost play, catch up constantly in meeting targets and trying to be able to bring legislation to the fore and various policies. Sir, that is not to say that the efforts are not being made, but it is, I think, simply to bring balance and to the reality of what it is that all of us as ministers, I think, are facing. I need not be lectured on what has to be done. Sir, I feel very passionate myself about the burst pipes and certainly the digging back up of roads across the country and the loss of water. I'm the general manager, and everybody in the BWA knows how I feel about these things, very passionate about it, equally as are my colleagues. But there are still certain deficiencies that we are in the process of addressing. And I will constantly go back to the fact that resources were spent badly within the Barbados Water Authority. We are trying to put things back on track in order to be able to capitalize on what we know we have to do. It is not going to be an overnight process, but it is one that the process certainly has started, and I know that the team at the BWA is certainly committed. The PS in the ministry and the rest of the team is committed to being able to make that turn. We are seeing whether it is within BWA or we're seeing within MTW, certain transitions, sir. It does not happen overnight, and so as we try to piece all of the moving parts together, we will engage with the public, but as the Honourable Member for St. Andrew indicated, we've had the water harvesting policy. We've also, and they're working on the communications plan for that. There's also this water reuse policy where the communications plan is taking place on that as well. You still have to deal with all the bursts that are taking place on the premises of homeowners because the BWA has been tasked with, again, developing a policy which would allow us to be able to find a mechanism to assist those bursts that people cannot afford to repair, because that is a wastage of water. And it is no longer sufficient for us to simply say it is on your property and we turn a blind eye and we go the other direction. We actually have a deeper responsibility to be able to help people to identify what the problem is, and if we have to tack it on the bill, sir, we have to figure out a way. If we can go in and do the repairs, we have to figure out a way to be able to do it. Those are some of the things that the Barbados Water Authority is looking at, but again, it has legal implications because you can't just go and turn up on people's properties and start repairing bursts either and digging through pipes, sir. Mr. Speaker, you'll be well aware of what I speak. So it is not an impossible hurdle that we have to conquer, but it is one that obviously we have to make sure that we get all of the rights and the responsibilities correct, and that we have the right people trained to be able to go in. But that is something certainly that does concern us. As it relates to, again, a master plan in relation to water, as I said before, there is a plan. We're working towards a number of things. We are trying to increase the capacity in terms of not just from procurement, but just general human resources, make sure that our industrial relations, our relationship with the unions is such that we're able to engage in conversations that will make life easier, not just for the workers, but all of Barbados. These are difficult conversations, sir, that nobody likes to have. But we are at a place now with the scarcity of water where if we are going to try to play catch up on the last decade, we are going to have to accelerate our capital works program. And it is going to involve making sure that we open up a little bit more to others to be able to help the Barbados Water Authority to be able to carry some of the weight to execute some of the policies. So, sir, I just wanted to touch on those few things. I think from some of the comments, those would be the key ones that I would just want the record to reflect, but I thank the honourable members. I know the support is there from pretty much all of the members here in relation to the parliamentary group as it relates to this particular bill. As it relates to the water zones, again, in the Barbados Water Authority Amendment Bill, you know, legislation sometimes comes on the order paper, sir, but for one reason or the other, as happened with this, even though we think something is ready, sometimes it isn't. Sometimes bills leave here, they go to the Senate, and changes have to be made, sir. Equally, different eyes will reflect different things that need to be amended. And so, you know, government is and legislation is a fluid process. Different members from CPC who look at the legislation found different ways to redraft. That is the nature of legislation. It doesn't mean that we are not prepared to debate something or that we are delaying legislation coming, but there are often reasons behind the scenes why things have not been brought at a particular time. So with that, sir, I want to again thank my honourable members. Looking forward to the engagement with the public in the coming weeks and months as it relates to the discussions on water reuse generally. And certainly, again, just want to thank the technical team and the legal team for being able to assist us in getting us to this point as well. So with those few words, Mr. Speaker, I beg to move that this bill be read a second time.
Question is that the aforementioned bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Okay. Hey, Mr. Speaker, I beg to move that you do now leave the chair and that the House resolve itself into committee for further consideration of the bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
This house is now in committee.
Part 1.
Mr. Chairman, I beg to move that Part 1 be deleted and be substituted with the new Part 1 as circulated.
And stamp part.
And stamp part.
Part 1, we repeat it. Yeah, and substitute. And part 1 be amended.
The question is that Part 1, as amended, stand part. All honourable members in favour, say aye. Honourable members against, you say no. You think the ayes have it.
Part 2.
By way of amendment, Mr. Chairman, I beg to move that Part 2 be deleted and that the new Part 2 be substituted and stand part.
The question is that Part 2, as amended, stand part. All honourable members in favour, say aye. Honourable members against, we say no. Methinks the ayes have it.
Part 3.
Beg to move, Mr. Chairman, that Part 3 be deleted and that the new Part 3 stand part.
The question is that Part 3, as amended, stand part. All honourable members in favour, say aye. Honourable members against, we say no. Methinks the ayes have it.
Part 4.
Mr. Chairman, I beg to move that part 4 be deleted and replaced with parts 4, 5, and 6 of the substituted bill as circulated and stand part.
The question is that part 4, 5, and 6, as amended, stand part. All honorable members in favor, say aye. Honorable members against, say no. Methinks the ayes have it.
First to the third schedule.
Beg to move that schedules 1, 2, and 3 be deleted and schedules 1 be the new schedule as amended.
Be the schedule.
And be the schedule to the bill.
The question is that the new schedule will be the schedule to the bill. All honorable members in favor, please say aye. Honorable members against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do not report progress to His Honor the Speaker. Passing of one bill in committee as amended.
The question is that I do not report His Honor the Speaker the passing of one bill in committee as amended. All honorable members in favor, say aye. Honorable members against, please say no. Methinks the ayes have it.
chairman of committees is reporting the passing of one bill with amendments in committee.
Mr. Speaker, I beg to move that the bill be read a third time.
The question is that the aforementioned bill be read a third time. All those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, I beg to move that the bill be now passed and cited as the Water Reuse Bill 2020, Water Reuse Act 2023.
The question is that the bill be passed and so cited. All those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it. This bill is passed and so cited.
Order number 3, sir. In the name of the Honourable Minister of Finance, to move the second reading of the Duties, Taxes, and Other Payments Exemption Bill 2023.
Honourable Member for Christchurch, East Central.
Thank you very much, Mr. Speaker. I know it's late in the afternoon, and after having such spirited debate already for the day, my intention is to be as brief as possible, which is going to be very brief, sir. But it is important that we get these policy arrangements in place, given one, the announcement by the Honourable Prime Minister in the budget in relation to how the government will contain the tax expenditures moving forward. And I just want to take the opportunity, sir, just to give just a very short background, because it's important to set the context within which this specific bill here is before the chamber. Now, Cap 67B, sir, if you look at the piece of legislation, sir, is really just a short piece of legislation, 4 clauses currently, that gives the Minister of Finance the power to waive any tax, any fee, any payment that arises for government, and the extent to which the regime within which we have been operating over a number of years has meant that because we've not had a significant change in or review of policies historically, we've had a situation where, sir, between that which is legislated as well as that which were granted as part of the discretionary powers under Cap 67B, we've reached a situation, sir, as you will recall, the Honourable Prime Minister in the budget in March clearly stating to the country that we had reached a point where in 2022, the total amount of tax expenditures foregone had reached approximately 750 million Barbados dollars in 2022. For the public, what that means is that the government of Barbados in 2022, and we had seen a gradual increase over the years, has been foregoing revenue, sir, foregoing revenue in order to facilitate, if you like, sir, various pieces of policy and legislation over the years. And we've determined through the upgrade of Asecuda World that we are going to provide an environment where we would facilitate the processing of concessions and the like, sir, coming through the Bridgetown port. Yes, to enable investment in the country, but we needed to bring a measure of order to it such that we are in a position, sir, to ensure that the intent with respect to the policy or even from the legislative framework in the past, that the granting of the concessions by the Ministry of Finance in collaboration with the other stakeholders, that we will do so in a way that is consistent with and definitely, sir, in the public interest. Let me state, sir, that as it relates to what we are seeking to do here, sir, and we have started to do it already internally and this legislation really is just to give the necessary framework for it, because we've resolved that we have to work collaboratively with other ministries who have, through legislation, for example, sir, as you know, the tourism sector is captured for the most part by the Tourism Development Act, for which concessions are granted for the tourism sector. There are other various pieces of legislation that governs how agriculture governs the processing of rebates and concessions for agriculture purposes. Within the manufacturing sector, sir, policy is in place to be able to help manage concessions within that context. The Ministry of Health, through the drug service, as well as under the Office of the Chief Medical Officer in the Ministry of Health, provides concessions, obviously, for the processing of drugs, as you would appreciate, sir. Pharmaceuticals, drugs which are all, for the most part, imported, are also covered by the waiving of duties and VAT and those types of things, for obvious reasons, sir, because it is in the public interest to be able to access affordable medications in that context, and we shall continue with respect to that. But I'm just making the very point, sir, that the cumulative impact of all of that has meant that we've reached a point where, sir, we have to review whether or not the systems that we have put in place, whether they're working and whether they're still effective. And I must tell you, sir, that in having conversations with various stakeholders, people will often tell you about a memo that they received from the Ministry of Finance in 1991, and a memo that was received in 1997 and 2003, and that type of thing, which was true. The reality is, sir, is that we started to look at the process, obviously, early on as part of the BERT program, and as COVID intervened, we had to pause the implementation of it. But the reality is, sir, is that policy set in 1991 and in 1993, sir, is not necessarily policy that is relevant for 2023 and to move forward. And therefore, the review of all of this, sir, within the context of being able to ensure that that which persons seem to have enjoyed before, we now have to literally quantify, sir, and determine whether or not it is still relevant for the granting of concessions, for the specific things that were relevant in those time periods. And the truth is, sir, that some persons have gotten so accustomed to things done a certain way that it really has not created an environment where innovation we feel could be advanced, because people have grown comfortable in the context of what they've grown accustomed to, and then they ask for more. And the reality is, sir, that having set up a series of legislative structures, and we say this is what certain sectors will do, ultimately, sir, people will then write to the Ministry of Finance to get the extras, so to speak. And it's the cumulative impact of those extras, sir, that really has meant that, and I think for the reality is, sir, that before we came to office, there was a sense in the country that we were being taxed and taxed and taxed and taxed. And that was, in fact, true. And that was the case simply because not just, well, truth is, sir, as you know, the last government were not very good at managing the public finances. But this was an area that had they taken an approach with respect to addressing how they were going to manage the concession process, then Barbadians perhaps would not have had to feel as if they were being taxed every year. The Minister of Finance stood up in a budget to increase taxes, because as you would appreciate, sir, $750 million approximately in foregone revenue is quite significant, and therefore we are seeking to ensure that we set a clear framework in place to move forward to arrest this challenge. And we accept, sir, that it is not going to happen overnight to bring it from 750 million down to acceptable range, sir, which will take some time, and that's why we've sought to through the Customs Department, to start to look at the sectors and the entities operating within the sectors through an audit process to ensure that we can manage the processing of these concessions, and where persons have not been compliant, sir, because one of the things, sir, over the years is that we haven't checked. The government simply has not checked up with respect to making sure that there is compliance with the concessions that have been granted. What do I mean, sir? You would tell me, sir, that you are going to make an investment of $100 million and you're going to have 200 jobs and you're going to bring in a ton of foreign exchange. And our systems have been so analog, sir, and that's why the digitization is so critically important, which we have worked with the Revenue Authority, with the NAS, with Customs, and to some degree with CAIPO, sir, to ensure that we are able to capture the information in real time in order to deploy persons effectively across the system to ensure that there is, in fact, compliance. And we have had anecdotal stories, heard anecdotal stories, sir, of people importing things and having issues in relation to whether their licenses are undercutting and these types of things, sir, which, whilst on the face of it might appear to cause some within the business community some concern, we've had to take a very deliberate approach, sir, to ensure that that which we know may have come into the country has been done within the context within which the framework that has been provided. And therefore, it is important, sir, that in this vein, we set out very clearly for the country that what we have done, not just with respect to tax convergence, and we've reduced taxes, certainly, sir, consistently as a government. We've tried to make sure we create an environment, sir, where we allow business and enterprise to grow and to incentivize as far as possible, sir, persons to do the right thing. The reality is, sir, that compliance within the framework of being able to earn foreign exchange, to create jobs, we now have to quantify and make sure that each person who has been granted concessions in the past, that they now come into the new regime. Now, one of the areas, sir, that as part we've already started to implement is the requirement, and you would have heard the Prime Minister announce in the budget in relation to the compliance issues in relation to the supply of information, because the formulation of policy, sir, has to be driven by data. And oftentimes, people have refused deliberately to supply information to the Barbadian Statistical Service or to the Central Bank in the conduct of the balance of payments survey, sir. And as you know, we've passed in this chamber, when we did the Central Bank Act, the provision for persons to be able to do that. But within the context of this framework, we have already started to demand that those persons who are benefiting from concessions, sir, that they have to supply information to the government, because if we do not have the appropriate information to measure, sir, and to account for what is actually happening in the economy, then we could continue to have gaps within which not just to measure how much output is in place, but to really ensure that the policy that is being formulated is rooted, sir, in activity. So I reiterate to persons, sir, that this is really not the time in the 21st century with things happening as quickly as they are and escalating as quickly as they are. This is not time to run from government. This is not time to be hiding, because we have to have available to us, almost in real time, sir, enough information to be able to pivot, as we have done certainly in the last 3 years, particularly with COVID, but in this post-COVID environment, sir, as we had to do with respect to managing the fallout from the war in Ukraine, as well as the escalating cost of living issues therein. And therefore, it is important that we get this right as a country. This is not about the Ministry of Finance wanting to stop people from getting concessions, sir, because we have seen, and there are instances where the Customs Department, under the existing legislation, have had to impose penalties on persons for false declarations, sir. And as you would appreciate, sir, if you say that you're bringing in something for your enterprise, but it ends up, sir, by me because you've been given a benefit for a specific purpose, but it ends up by me, sir, then obviously you have supplied not just a false declaration, but that is what we call diversion, sir, into the real economy, because the purpose for which we may have granted you the specific concession was for you to do the specific activity that you said that you were going to undertake. And therefore, when you do that, it means you're cutting out, sir, potentially other parts of the economy, and therefore people are not operating on a level playing field. And therefore, the regularization of all of this, sir, is important, because it is critical that business is conducted in a competitive way, but equally, sir, that we can't have a situation where persons are potentially being undercut and faced with a playing field that is not level. And therefore, the context within which this bill is before the chamber is to refine, if you like, sir, and to put some limitation with respect to the Minister of Finance to be able to grant concessions in the way that it was done before. But let me be clear, sir. We have been, since we've come to office, with every major investment in the country, sir, the Ministry of Finance, in collaboration, whether it's tourism, whether it's education, whether it's health, agriculture, or any of the other major investment areas, we have been working together to ensure that the granting of those concessions have been done in a way that's consistent and indeed in the public interest. We have had instances where, for example, sir, persons have come for concessions to build out medical facilities. And yes, we have granted the concessions for the construction of those medical facilities. But that process was also negotiated with the Ministry of Health in relation to what will be the level of access by the public or public patients to said services as part of the I don't want to say negotiation, but as part of the process, because we want Barbadians to be able to have access to the best possible health care. But realizing that the government and its current offering can't necessarily offer to the fullest extent all of the possible services that may be available from a medical perspective. And therefore, engaging the private sector in that way, sir, is definitely in the public interest, because if we're able to build on a strong legacy of and strength within the public health space, then it makes sense for us to be able to have an ecosystem, if you like, sir, of medical providers for which public patients can have access to these services. And therefore, that is the type of arrangement, if you like, sir, that is definitely in the public interest, which allows us to be able to have a better provision of of medical care for the public that makes sense for all of us. And therefore, it is important to understand that whilst we will work with the Ministry of Health, because as I've said, and to the officers when these applications arise, is that we can look at the numbers and look at the revenue and the forecast and all of that, but at the end of the day, sir, it is about the quality of healthcare being received by the public that is important. And therefore, in that context, we work with the Ministry of Health to be able to devise what for them would be reasonable access on an annual basis for a number of patients, depending on obviously the specific specialty that the facility may be offering. But equally, sir, as you would be aware, some of these medical facilities will be doing so to be able to attract people to come to Barbados as part of the medical tourism ecosystem. And therefore, there's an advantage, if you like, sir, to having this type of approach with respect to being able to provide clarity in relation to the concessions granted, the attraction of people to the shores with respect to accessing medical services, but equally being a part of how we solve some of the issues with respect to the public provision of healthcare, which is important. Similarly, sir, we've worked with the Ministry of Agriculture effectively to do the same thing with respect to addressing food security and other areas, because as you would appreciate, sir, the cost of living certainly has gone up significantly in the last few years, and therefore we've been engaging with the Ministry of Agriculture in terms of how we can build up a more robust landscape with respect to investment in some of the areas that will help deal with either feed or fertilizers or those types of things, sir, which we believe will help boost our food security efforts as we are working with Guyana and Suriname in relation to resolving that. And therefore, working with the ministry, and again, sir, we're not agriculturalists. We're just looking at the numbers and the structure, but the Ministry of Agriculture will bring the expertise, as you would appreciate, sir, with respect to what the targets will be in relation to production, in terms of what we can see moving forward with respect to the economies of scale, if you like, sir, with respect to what we are doing with the food terminal and other areas to be able to facilitate investment, but equally, sir, with respect to ensuring that Barbados will be in a position over the short to medium term to achieve some level of food security that would help to shield us, if you like, sir, from some of the vagaries of the international environment. And therefore, it is in this way that we work to determine what is definitely in the public interest in order to ensure that these things are being granted consistent with what policy needs to be in the 21st century. And therefore, those are just some examples, sir, of how we've been working collaboratively already to be able to ensure then that the granting of concessions, which is over and above anything that the Ministry of Agriculture will currently be granting, or in the context of the Ministry of Health or any of the other ministries that are already there, what we will do over and above what is already legislated in order to make sure that it meets that public interest test in relation to not just driving investment, but really trying to make sure that Barbadians will ultimately be the beneficiary of this process. Let me also indicate, sir, that Clause 6, which speaks to alleviating hardship and avoiding injustice as part of the process. Since we've come to office, sir, and I take this opportunity to very quickly remind the public through you, sir, that when it comes to persons with disabilities, I know the member for St. James North, in this capacity as the chair of the advisory committee, we met with them. But since this government came to office, sir, we had a very clear policy as to how we will deal with, especially, sir, with persons with disabilities who have mobility challenges. And we have been granting concessions on scooters, wheelchairs, cars, wheelchair-adapted vehicles, and the like, sir, to ensure that persons can have some level of independence in terms of their transportation. And we have been doing that consistently, sir, since June of 2018, to ensure that persons with disabilities will not have to suffer, in a sense, in terms of the cost of being able to access a wheelchair-adapted vehicle, because it's quite costly, sir, for the adaptations to the vehicles. And therefore, with those costs imposed on them for the adaptation, we have waived all of the customs duties, all of the excise, sir, all of the VAT in relation to those items, which we believe, sir, is clearly in the public interest, and therefore would allow those families the opportunity to be able to provide independent transportation for those persons, which again is consistent with the government's policy in relation to giving access to persons with disabilities relief in relation to that. I know that the recommendation was made that with respect to the new draft bill, that would be something that would be incorporated as a matter of right, as opposed to something that's discretionary before that. Let me just say, sir, that in coming to office, I personally found instances where applications to the Ministry of Finance from persons with disabilities, sir, were denied. And I asked the officers to reach out to the families of those persons, and we were able, sir, to refund those persons what they had paid because they were denied. And that is the kind of thing, sir, that is important for this government to highlight. Because if we are saying that things have to be in the public interest, sir, then we have to make sure that as a matter of policy, and I hope that we can, with my honourable friend here from St. Michael South working with the member for St. James North, that piece of legislation can get to Parliament soon, such that we can imbue persons with disabilities with the rights to be able to have it legislated, so that it is not up to anybody, sir, with some misguided notion that you don't deserve these types of this type of relief, because it does play an important role in the lives of those persons. And the truth is, sir, whilst I'm speaking in this way, there are other areas that we have also similarly granted relief for persons with disability, especially children, as we've seen, sir, with a varying number of conditions and having to access specific, not just medications, but specific implements to aid in their upbringing, which we have granted relief for in a way until I think once we can get this legislation in place, will make it much easier for them to be able to facilitate it, so that this type of thing makes a difference, sir, to the lives of ordinary Barbadians. Now, I promise not to speak too long, sir, and I will still keep the promise, sir, but it is important to say to the country that this is a process, sir, and to the business community, that this is a process for which we will need the cooperation of everybody. Because if we do not bring this thing under control, sir, under control, then it will mean that there's potential for some kind of adjustment on the other side. And we are going through a very deliberate process to ensure compliance with respect to what is supposed to be granted, the metrics for which persons say that they were doing concessions, and it will mean, sir, over the course of the next year or so, that some of those memos, sir, that I spoke to you about, that people bring out, and you see you recall, sir, you will know when something, I mean, literally typeset on typewriters, you will see people sending, accompanying their applications for it, saying that the Minister of Finance in 1993 ordered this thing. And that is fine. But we now have to literally assess sector by sector, industry by industry, sir, whether or not all of those policies make sense. And we've done that. And therefore, the conversation now is the implementation of it, sir. And we are going through a very deliberate audit process to be able to communicate with those persons, because as you know, sir, when people get accustomed to something for so long, they start to feel as if it can't change. And the reality is, we want business to grow. And therefore, in allowing business to grow, we have to focus, whether it's concessions or incentives or whatever you name it, sir, on the things that will actually generate areas of foreign exchange, generate activities where we're going to get more jobs in the economy, rather than just sustaining the status quo as it is. Because I suspect, sir, people have grown a little comfortable, based on some of the business models, relying on government through the concession process to make their projects more viable than the ordinary would be. And the extent to which we are working, certainly we will be working with the Ministry of Commerce, especially, sir. The Ministry of Commerce, on the pricing side, is to make sure that from the consumer perspective, sir, especially where taxes have been waived, that the benefits and the pass on with respect to the relief to consumers is going to be equally important. And therefore, if we say that we are granting relief for a specific purpose, all of us have to be in it together, sir, because the taxpayers cannot be the ones on the receiving end with respect to giving the relief, but then being charged the price as if the duties and the taxes had been paid up front. And therefore, we will be working with the Ministry of Commerce to ensure that there's compliance all the way through on that side, because it is important that Barbadians feel a sense of confidence that the government, through policy, is consistent from A to Z, sir, and that we have the capacity to enforce. And that is why we are going to shift, as the Prime Minister said, the burden of proof, if you like. We're going to focus more on post-clearance and auditing, and that's why we're engaging members of the audit community to be able to strategically go and look at what it is that we want to look at in terms of what the data is telling us. And therefore, we will be going through not an audit to embarrass anybody, sir, but when we find something, sir, we'll give you an opportunity to set it right. And in giving you that opportunity to set it right, sir, then I'm confident that we'll be able to rein in the quantum of concessions that are being granted, and to then allow the government to be able to collect a little more revenue, sir, a little more revenue. That then affords the opportunity then for the improvement, certainly, of some of the other public services. And as you know, sir, we have a very clear target within the next year to reduce it by $150 million. And this year, our target is $30 million as we are starting the process in relation to getting this in place. And so the bill before the chamber, sir, is to repeal the existing CAP 67B, replace it with this. So we will continue to do that which we have ordinarily done, working with the stakeholders and the processing with respect to these concessions as the legislation speaks, formalizing the subcommittee in relation to the granting of the concessions, and doing so in a way that allows us to focus very clearly on what is in the public interest. And the public interest clearly, sir, will depend on the specific application, if you like, in relation to that, and therefore allowing us then to focus on what it is that would allow the entity or the industry or the sector, sir, to grow and to export. And if we're able to do that, then it means then that not just the whole management of the concession exemptions will be reduced, but it means that the competitiveness, I believe, sir, of the country will be enhanced as a result. And therefore, sir, this bill before the chamber is just one piece. It is really the ongoing surveillance and the capacity to monitor compliance, which the Customs Department, the Revenue Authority, the NIS, as I said, the Commerce Department, CAIPO, and others will be working collaboratively to ensure that on the compliance side, that businesses are doing what they're doing, and then as we work with the other agencies in relation to agriculture, health, industry, sir, sports, with respect to sporting goods and equipment and the like, and certainly with the Ministry of People Empowerment, to ensure that once we get the necessary piece of legislation updated and refined and have a process set in place for consistent review that is based on data, then we are confident that we'll be able to relieve ourselves of some of those age-old customs, for lack of a better term, sir, to ensure that the policy is fit for the 21st century. And so, sir, with those very few words, I beg to move that this bill be read a second time.
Honourable Member for St. Michael, South Central.
Thank you, sir. I know the Honourable Member for Christchurch East Central suggested that he would be brief. We all knew better than that. Wish that we would be brief, but, sir, we weren't elected to be brief. We were elected to be rigorous and effective. So I think that the House will willingly indulge this intervention on this matter. Sir, I support the repeal of CAP 67B, as the member who led knows well. But I think that the bill that is before us bears some discussion and some consideration in light of some wider issues. Now, the original CAP 67B was very, very short, a piece of legislation of 4 clauses, 4 sections, and intentionally so, because really it sought to give full discretion to the Minister of Finance. And the truth is that it perhaps allowed for a multitude of sins among those who, in a previous government or administration, may have been so minded. And we always say that we have to legislate, not necessarily for ourselves, who are minded to act in good faith, but we have to legislate for those who may come after us, who may not be so minded. And so I believe that this new piece of legislation starts slowly down the road to where we want to be. And it does so in part by capping the decisions that can be made by the Minister of Finance. I believe it is at $100,000, so that, subject to the provisions of the Public Finance Management Act 2019, the Minister of Finance may by order grant an exemption to or remit or refund any payment made by any person in respect of the amount of any duty or tax where the sum does not exceed $100,000. So that starts to help with issues of transparency and discretion. For those requests that are in excess of $100,000, the exemption must be approved by the Cabinet. Again, that starts to go down the road towards the right place. But, sir, I believe that as currently presented, the bill does not cure the wide discretion of the Minister of Finance on the matter of granting duties and exemption. And let me be clear. There will always be an occasion, there will always be purposes under which the Minister of Finance must be given some discretion and some flexibility to make certain decisions. And we're fooling ourselves if we think that that's not the case. Certainly we saw with COVID where if we did not have in our legislative framework, or we did not make space in our legislative framework for the government to be able to act quickly, for the government to be able to procure overnight, the whole world was scrambling to be able to get certain supplies and to be able to do certain things. And if we did not have that provision, goodness knows where we would be today. So I am not so naive as to think that that power is not required. However, sir, I, again, hope that we're not missing a very important opportunity to go further. The honourable member who led the bill suggested that part of the reason for it is that we want business to grow. And I think that if we want business to grow, we need to have an approach to fiscal incentives that makes everything clear. We need to have an approach to fiscal incentives which sets out in one place, perhaps that a company, an entity like Invest Barbados can disseminate to the world, sets out in one place what are the requirements, what are the conditions under which incentives and concessions will be granted in each sector: manufacturing, agriculture, technology, health, sports, tourism, charitable organizations, importantly. What are the conditions under which exemptions will be granted under each of these sectors? And then, if they do not apply, or if the request does not apply under those pieces of legislation, then why would, or under what circumstances, would I need to invoke or apply under Cap 67B, or this new piece of legislation that will replace that? Because as we all know, what was happening was that people would simply bypass a piece of legislation that they didn't like. They would know that something applied to them under manufacturing or under agriculture, but they would say, no, I'm gonna make this application under Cap 67B so that I could then trigger a negotiation process with the government so that I have more scope to be able to access the kinds of duties, the kinds of exemptions from duty that I may wish to have. And so I feel government must make it very clear the exceptional circumstances under which an application for an exemption will bypass these other various pieces of legislation and then can then be directed towards this bill that is before the House. And I think, sir, that a new all-encompassing fiscal incentives bill is necessary so that this can all be seen and considered in one place. Sir, the resources of government are thin on the ground. The question of examining an application for exemption of duties is an administrative exercise. And if you look at all the different pieces of legislation that govern it, it gives authority to different ministers. It invokes action by different public officers in different ministries. There is not, for that reason, an equality of the length of the process across various sectors. And so something in agriculture may take as long as the Ministry of Agriculture is able to respond. Something in manufacturing may take as long as the department responsible for that is able to respond. And anything that we can do to remove, one, the administrative burden of having to make a decision on concessions, and two, the discretion is something that is not just good for transparency and accountability, but is good for business. The value that an investor or a small business owner or a householder gets, or a returning national gets, the value that that individual gets from the predictability of knowing what they're entitled to, the kind of exemption that they're likely to be granted, that has tremendous value. I can know that when I come to Barbados and I'm making a tourism investment, that I can predict reasonably what I will be granted, and I can do all of my business planning and my modeling on that basis. And so I believe that we should not maintain a situation where we still have these pieces of legislation that govern different sectors with respect to the granting of exemptions from duty, and that are not unified in one place so that we can say to the international community and that we can say to Barbadians, this is what you can expect. We have, quite frankly, a complicated process with respect to the tourism sector. That's something, first of all, that I have to satisfy myself as an officer that the thing that you're applying for a concession for is a part of the schedule, the list of things that I have in my hand. And so I might say that I need, for my tourism investment project, I might need a lawnmower. And I am entitled to having a duty-free lawnmower. And then something comes in that the officer cannot tell whether it's a lawnmower or not. I swear to you that it is. But the administrative burden and the level of discretion and the level of understanding that is needed to be able to say, that don't look like a lawnmower, and that is not on my list, you cannot get that. That is an investment and an administrative waste that we can't afford. And so if we can have a system where there's a greater degree of predictability, perhaps you get 3% of the value of your project, and you can use that 3% to say, I want vehicles, or I want to be exempt from vehicles, I want to have that 3% go to this particular input or that particular input. It removes the burden from government of having to make a decision and having officers try and check something and try and develop expertise in all kinds of areas that they don't have expertise. Furthermore, sir, the conditions that are referenced in the legislation also leave a wide area for discretion. And so at 5, an order made under this act is subject to any conditions specified in the order. And so we don't know what those conditions might be under any future order. The Honourable Member for Christchurch East Central made reference to some worthwhile options. One is that if you say that your investment will generate a certain level of foreign exchange, it must do that. If you say that your operations annually will generate a certain level of foreign exchange, it must do that. Otherwise, you may no longer be eligible for those concessions. That's worthwhile. If you say that your investment project must generate a certain number of jobs, it must do that or is no longer eligible for concessions. Worthwhile. If you get these concessions, you must report, you must fill out, complete the balance of payment survey as circulated by the central bank. Worthwhile. However, I would like to see that stated in the legislation. I would like to know that the conditions have a certain baseline, and then more may be added as necessary. But right now, as it is outlined here, any condition may satisfy. And so it does still leave some room, perhaps more than we would like, for discretion. Sir, I will be brief, unlike the honourable member who came before me. But I feel that it is important to understand that there are, not that this bill in itself is not desirable, but there's further that we can go and perhaps should go, and that we should not perhaps be tinkering with the big issue that we have to solve. The final thing I will say, sir, is that I would love to see incentives where they matter in this country. Obviously, we want to create a growth environment, a job-led growth environment. We do want business to grow. But there are also other things that are desirable and that we can use incentives for. Sir, I saw recently that there was some discussion of moving towards a salt tax alongside the sugar tax that has already been introduced on sugar-sweetened beverages and so on. I think that we need to exercise some caution. We need to exercise some caution. The health industry has had a history of demonizing certain food groups, demonizing certain nutrients, demonizing certain minerals, because we have this all-or-nothing approach to health. I understand with sugar because there's not much desirable in sugar, but salt is something that can be consumed in a balanced way and that is needed in the body. And so to say, well, we're going to tax the consumption of salt when you have people who are athletes, for example, who if they don't take sodium and potassium and magnesium will get cramps. What would be the threshold of sodium content that would apply? I don't know that we need a tax for everything. I think that perhaps we need incentives for certain things and certain behaviors that we want to encourage. That's one of the reasons we had talked about having this Wealth for Health grant, so that people who have been diagnosed as pre-diabetic or borderline hypertensive can, rather than us spending the money on the Queen Elizabeth Hospital to treat NCDs, we can give the resources as an incentive for people to be compliant with their treatment protocol, for people to exercise, for people to eat well. I think that we have to look at applying incentives, not just in the formal market industries, but where they really matter to the quality of people's lives. I support the target that has been identified by the Honourable Member, the tax expenditures in Barbados, the amount of revenue that we do not get, that government does not get because it is granting concessions to businesses, is unsustainable. On that, we agree. As we look at that balance, let us also look at how we can have a composition of those tax expenditures that does not just focus on incentivizing business, but also focuses on incentivizing the healthy behaviors and the kinds of lifestyles and the well-being of people that will bring about the Barbados that we want to see. So, sir, I do not raise any specific objection to the bill as set out, but it does not go far enough. And I believe that we have a responsibility to make more transparent and lay out more clearly what is the framework of fiscal incentives that people can reasonably expect when they invest in Barbados, and likewise, what are the incentives that are going to encourage us to engage in the behaviors that are going to redound to the benefit of all. With that, sir, I'm obliged.
Honourable Member Christchurch, East Central.
Thank you so very much, Mr. Speaker. The honourable the member for St. Michael South Central, as always, is lucidly clear. We have had to be very careful, sir, with respect to how we implement this particular policy. And part of the reason for that, sir, is because, on the one hand, much of the benefit has been legislated, and because in the past we have not given specific timelines with respect to whether those, and don't get me wrong, there are specific pieces of legislation, for example, like the Special Development Areas Act that gives a very defined period. And we have adopted this approach with respect to focusing on the compliance part and to refine, if you like, sir, the terms upon which persons will be able to access this, which, as you would appreciate, sir, based on what was given in the past, we do have to make sure then that from the compliance perspective that we're able to bring greater discipline to the space whilst we reformulate, as the honourable member indicated, the concession framework to be as all-encompassing as she referred. The reality is that even as we speak, there is, and you know you're not supposed to talk about legislation that's prospective, but we have reviewed the incentives, if you like, sir, with respect to industrial development, given what we are focusing on doing. In a sense, sir, to focus on driving innovation and for driving growth rather than what we have grown accustomed to. And that speaks to how we will use technology and innovation and certainly the ingenuity, I believe, of Barbadians and whoever may want to come to Barbados to build out a different type of industrial process which I think is capable of leveraging the global supply chain and get Barbadian products to market such that we can get engineered growth. And we simply have to be more pragmatic in relation to some of these spaces. But I agree with the honourable member. I would dearly love to reduce these exemptions significantly in a very short space of time. But it really does take a little bit of engineering. That's why we've taken the time from the data perspective, because whilst we've been able to do that with the implementation of Assecuda World in 2019, and we have a decent set of data now upon which we can go and do the right audits and make sure that we can trace and track and then determine whether or not your ability to continue accessing at the level that you're accessing it at until you right-size yourself, so to speak, is important, because we simply have the government from whenever, not just, and I'm not speaking only to Cap 67B, but all of the pieces of legislation. We simply have not audited effectively and consistently, I don't think ever really, to determine whether or not entities have actually done what they said that they would do. And so that's where we start. and therefore, as we reformulate not just a piece of legislation, we've issued the policy directions already, and therefore, in the administrative part that we're referring to, and as we've done with the New Customs Act, as well as the regulations which will be laid very shortly, that they already have within that specific space the authority to do that which they can do, whilst we are working on the legislative part. So there's a very intense data crunch that's already taken place, and we continue to do that. The publication of the level of concessions within the context of next year's budget cycle, you'll see some of that information come as part of the estimates process and all of that with respect to the granting of concessions and that type of thing historically. And the reality is that whilst that is retroactive, it will give us an opportunity not just to see which sectors have benefited from the larger set of concessions and entities therein. As you know, sir, statutory instruments are laid in Parliament, but of course it's individual. So it wouldn't tell you the whole story over time, and therefore that particular publication of the data will give you by entity and under which specific piece of legislation the concessions were granted, the cumulative impact in relation to that. So I do agree that there is work to be done in relation to it, but accept that there's an element of capacity as well to be built in the system to reorient the minds, and that's why even with respect to, and I use this with the BRA, it's taken a while to get all of the systems to look at a single taxpayer. So we've actually kind of reached the point now where we can genuinely look at a taxpayer from all directions in order to ensure then that we know whether or not you're compliant or not. And that's taken some time to build out, and we're going to leverage that capacity now in order to make sure we can accelerate, not just in this particular process, but just generally speaking as it relates to broader compliance issues. And then and as we have had conversations in relation to the sectors, the truth is that, as you know, there's been a culture in the country, sir, where persons simply don't want to provide information. And therefore, as we reformulate, not just in this specific piece of legislation, we're looking at it more from the overall statistics provision thing. So the reason it's not here in this act, it will be in the regulations, but when we look at the overarching statistics framework, all of these things will be front and center there, but we've issued policy guidelines already. You're receiving a concession, you have to provide information for these things as part of the compliance measure, and I am absolutely sure that nobody wants to have a concession removed because they didn't answer the survey. So I'm pretty positive, as the business community is listening to me now, sir, that when they receive the request either from the statistics, the Ministry of Labour, Central Bank, or any other sanctioned survey by government, that they will respond, because, as I said, we have to make the best possible decisions, and the only way we can do that is if we have information that makes it possible to be able to formulate policy. And therefore, our thrust is to help business grow, genuinely help business to grow, and therefore you really can't be hiding from government or the regulators, if you like, sir, because at the end of the day, if you're going to do business in another country, you have to provide the information anyhow. And therefore, it is important that we know, such that we get the policy right and that we can move forward, sir, with certainty. And so I don't discount the fact that this is taken long. COVID intervened, and therefore we are very minded to make sure that we follow the data as presented and give us the best opportunity to be able to encourage compliance, but equally encourage and build confidence across the business community in order to ensure that the ability to attract new investment domestically, foreign investment, as well as the export of capital as part of the thrust to grow the economy. And as I said, sir, it's going to be critical as we are able to respond on multiple levels in order to ensure that we indeed can meet the public interest with respect to the provision of these provisions at various levels, and therefore manage the public finances in a way that really and truly, sir, has not been done before. And so with those very, very few words, sir, I beg to move that this bill be read a second time.
The question is that the bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do not leave the chair. The House resolve itself in the committee for further consideration of this bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
Chair, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Chair, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Chair, I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 4.
Chair, I beg to move that Clause 4 stand part.
The question is that Clause 4 stand part. All honourable members in favor, say aye. Aye. Honourable members against, say no. Methinks the ayes have it.
Clause 5.
Chair, I beg to move that Clause 5 stand part.
The question is that Clause 5 stand part. All honourable members in favor, say aye. Honourable members against, please say no. Methinks the ayes have it.
Clause 6.
Chair, I beg to move that Clause 6 stand part.
The question is that Clause 6 stand part. All honourable members in favor, please say aye. Honourable members against, please say no. Methinks the ayes have it.
Clause 7.
Chair, I beg to move that Clause 7 stand part.
The question is that Clause 7 stand part. All honourable members in favor, say aye. Honourable members against, please say no. Methinks the ayes have it.
Clause 8.
Chair, I beg to move that Clause 8 stand part.
The question is that Clause 8 stand part. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 9.
Chair, I beg to move that Clause 9 stand part.
The question is that Clause 9 stand part. All honourable members in favor, say aye. Honourable members against, say no. Methinks the ayes have it.
Report.
Chair, I beg to move that you do not report to His Honour the Speaker the passing of one bill in committee.
The question is that I do not report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, please say aye. Honourable members against, please say no. Methinks the ayes have it.
The chairman has reported the passing of one bill in committee. Honourable Member Christchurch, East Central.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that the bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill be now passed and cited as the duties, Taxes and Other Payments Exemption Act 2023.
The question is that the bill be passed and so cited. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited. Honourable Leader, Government Business.
Thank you, Mr. Speaker. With that, we've come to the end of today's sitting. I therefore beg to move the adjournment of the House until Tuesday, the 30th of May at 10 a.m.
Until the 30th. The question is that this honourable chamber be adjourned until Tuesday, the 30th day of May at 10 a.m. in the forenoon. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honourable chamber stands adjourned until Tuesday, the 30th day of May 2023 at 10 a.m. in the forenoon.